Call the meeting to order at 4:02. Sunshine Ordinance Task Force. Please call the roll.
Member LaHood?
Present.
Member LaHood present. Member Wolf, Josh Wolf, not present. Member Tesfaye?
Present.
Member Tesfaye present. Member Martin?
Present.
Member Martin present. Member Highland, not present. Member Yankee?
Present.
Member Yankee present. Member Hinsey?
Present.
Member Hinsey present. Chair Wolf?
Present.
Chair Wolf present. We have a quorum.
Thank you. Just note for the record that Vice Chair Josh Wolf has car trouble and he's trying to get here. Okay, it's called. Any changes or adjustments to the agenda? I'm sorry. Yeah, call the. Sorry?
Meeting decorum.
Oh, the quorum message, right. Thank you. Are we, at the beginning of our meetings, we're now reading a short statement about meeting decorum. Any member of the Sunshine Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Okay, now.
Item number 1.
Yeah.
Call to order, roll call, and agenda changes. We have called the roll. In my knowledge, there are no agenda changes.
Okay. Very good. Let's call the next item.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force November 6, 2019 meeting.
Note that Member Highland arrived at 4:05.
Any changes to, I have a copy of the minutes
Changes,
here.
adjustments to the agenda, the minutes? Member Yankee?
Oh, looks great.
Oh, wow.
Okay.
Present.
Wait, am I in the right meeting?
Right. Okay, is there a motion to approve the minutes? I'm sorry, yes, a motion to approve the minutes?
Make a motion.
I'll second.
Moved by Member Martin, second by Member LaHood. Any public comment on the minutes? Seeing no public comment?
Roll.
Yeah, please call roll.
Member Martin?
Aye.
Member Martin, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf, not present. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the minutes passes.
Thank you. Please call next item.
Item number 3, file number 18012, complaint filed by Denta Tedeschi against Lori Mazzola, City Hall Building Management for violating Administrative Code, Section 67.5, by restricting access to all meeting of any policy body in City Hall.
Are both parties here? Mr. Tedeschi is here. Is somebody from City Hall here?
I heard from a member of City Hall Building Management. They said they would not be present. However, they have submitted a written response that I received yesterday at 10:15 in the morning. I have copies of it if you wish to accept it.
So, members, this is a case that has been re-referred back to the task force after being reviewed by Compliance and Amendments Committee. The respondent did not appear at that meeting, didn't offer any response at all, and so it's now back with us, and a response is before us. It's not necessarily submission of the documents are not necessarily, part and parcel to our complaint procedure at the beginning of the complaint procedure. So it's really up to us if we want to accept the documents into the record. It's new. But it's responsive to the case that was not provided before.
Make a motion to accept.
I'll second.
It's been moved by Member Highland, second by Member Martin. Discussion.
I just want to express my concern that, I'm usually not in favor of this action because, for example, here, the complainant has not had the opportunity to review the documents in advance. He would have to be responding to them on the spot. And if there is substantive information there that, we would be expecting him to refute with record information, he hasn't had a chance to, prepare any of that. I just want to, that's my usual sentiment about this kind of thing.
I would agree with that. One of the things that we were waiting for, though, was some sort of document from either building management or the sheriff's department, and I'm hoping that might be in this, and that's the only reason that I made the motion, but typically I
Yes.
would agree with member.
I think this.
Okay, it looks like that might be.
So let's just ask the petitioner, Mr. Tedessa, have you had a chance to see this document?
I actually just got it today from Cheryl, and I just read the first couple sentences. I got really upset. I almost didn't even show up for this hearing
Okay.
because this
So
is one of those things that are not not allowed in your bylaws. You say five days in advance. I just ask that you treat me the same that you treat everybody else, and discard this late submission and not have it submitted. into the
I hear you.
record.
Thank you,
Please.
Mr. Tedessa. I'm just trying to get through the procedural part before we take testimony. I just wanted to ask if you had received it or not.
I
this
saw
time.
I saw just a couple first sentences, and then I just
Okay.
I had to come here, so I had to get ready.
Very good.
So I haven't seen.
Member testify.
And I also want to briefly say that, if this is the information that we've been requesting, I don't think that we should be not considering it. I just think that we should move this item to a later date so that Mr. Tedessa has an opportunity to review it. We also have some time to review it, and, really be able to use the information because it was what we requested, so it's relevant to the case. So.
Could I ask Mr. Tedeschi a question?
Sure.
So,
Yeah.
just, we're trying to help you here.
Sure, sure.
And if this document, and we haven't seen it, but you have, if this document goes at all towards getting what we want, that was the basis of my motion. However, I will restate what Member Tesfaye said, and this case has a history of not sending the qualified people, not producing the document in time. So typically my inclination would be not to include it, and we move forward with what we got. But if you feel that this document might help you get where you want to get to in any way, shape, or form, I'm all for it.
I haven't gotten a chance to read the whole document.
Okay.
Truthfully,
In which
and
case, I'm going to withdraw my motion.
yeah.
Okay.
And also, respectfully, they actually have said to your face that this body does not control them. They don't see whatever you say here as legitimate. Basically, they've said that to your face. Maybe not to the full task force's face, but to the Compliance and Amendments Committee. They've said that they don't take what your determinations say as pertaining to them. So basically,
Right. Thank you.
yeah.
Okay, so Member Rodman, Martin,
Yeah.
we're
I mean,
going to rescind the.
Okay, then I think what Member Tesfaye said was, and it's a continuance. If there's material stuff in the packet that is important to what we're trying to decide, I don't know how we can have anything without it. Substantive.
Okay, so two things. One is we can continue with this item to the full task force, or we can send it back to compliance and amendments.
I would suggest that we continue it to the full task force. Otherwise, it's just going to be ping-ponging back and
Okay.
forth. It's going to come back here.
That's fine, just
Could
an
I-
option.
Could I speak to that? I just wanted to also make a point that for the petitioner, it's been very difficult for him to get here to attend these meetings. And I think by continuing this, we're almost doing him a disservice, and we're allowing the respondent to kind of yet again get away with it one more meeting session. I mean, my inclination is to dive into it without accepting their submission, and if we feel as a body that this then moves on to, we want to dispense with this and perhaps send it to ethics or elsewhere, I'm all for that, because this has been going on too long. Them not being here, them not submitting something on time has got us to this point. and why punish the petitioner for that?
I want to address that just a little bit to let you know that about a week ago,
Can you speak in the microphone?
I did receive a phone call from Jennifer Johnston, and she said that they weren't going to make an appearance and they had nothing to submit at that time. And then I got this on Tuesday morning, yesterday.
Okay.
So I think that states their position pretty clearly.
Well, okay. I'm more inclined to give the benefit to what the petitioner wants. The petitioner wants time to read this through, consider it, and then have more ample time in the future to.
No, I was just
That
answering
hurt.
the fact that I did not read it. I definitely want this to go ahead. I don't want this to be delayed yet again.
Okay.
The delays are costing me in many, many ways. I just want this. It's pretty obvious to me that they're not going to comply. They're not going to comply. So what are the next steps? The next steps are either you send it to the ethics, or also you send it to the Attorney General, and I ask you to please consider that.
Well, if we're going to move ahead, then the question is whether to accept this document into evidence and then consider it as part of your case.
I say you shouldn't, because the 5-day rule has not.
The 5-day rule applies.
and nor are they here to even for you to even ask them,
That's-
is this substantive? Yes or no?
Okay,
They're
so
not here to even.
I understand two issues, okay? One is, and I explained it at the beginning when I opened the case, is that the 5-day rule applies to the beginning of the complaint process, so at the very initial. This is now a referral back, so we're in the middle of it, and as new documents or new information, especially information that's responsive to the crux of the case.
But
if
they're
it-
not even here to answer that
That's-
question.
I
And
understand.
it's a document that is submitted. I thought that the rule was
Mr. Tedeschi,
any
you're going to have
su-
to let me finish speaking, okay? We can only have one person speaking at a time. The second issue, that they're not here, that's another issue, and the task force will deliberate on that part. And yes, we're very aware of that and of the past, of the history of this case with regarding the attendance of the respondents. So, so to the first question though, is the bringing this this document in now. The issue that I have with it is that it didn't exist at the time of the complaint. It exists now. So the question becomes, whether there was a policy in place at the time of the or prior to the complaint that was submitted, and we actually took action. We have an order of determination based upon the lack of that evidence. The fact that it shows up now, to me, it just seems like it's like, okay, good, they created a policy, but it's not applicable to this violation because of when it happened.
Chair Wolf, just based on memory and reading through the notes here, I think the timeline is as such. I think when we had the Sheriff's Department in front of us, they said they were going to have.
Yeah, but that's a different case number. This is just City Hall. That's the next item.
Okay, then
Okay,
I'm conflating the two. But I think what the petitioner was saying on the 5-day rule was just getting things into the clerk in time for 5 days so we can publish it. That's the point he's making. And having heard from the clerk that a week ago they'd already said that they had nothing to add and not sending anybody kind of states their position, I think.
It's all part of your making your decision on how to dispense with this case.
Right. I would be inclined to move ahead and not accept that document.
I'm curious if Mr. Tedeschi, would it make a difference, and could the chair push this to later in our meeting if Mr. Tedeschi wanted to review what was in there to incorporate it in his what he presents here, or is it either yes or no and we move on now?
Well, I'd maybe
actually
like
fair.
kind of an answer to my concern as to whether this document existed today or 10 days ago or a month ago, it didn't exist a year ago when the violation happened, and we had already made an order of determination without the existence of this. So the question is whether it exists today or not, it's only for us to review to say whether it's more of a procedural issue that is not really part of the case. It would be something to send to CAC to determine whether it actually is in compliance in general for all members of the public.
I see what you're saying. That makes sense.
Yeah, that's my sense of it is that the fact that they've produced it today, it was not in effect at the time of the violation. And
Sure.
so trying to make it retroactively, I don't think we can do that.
Not trying to conflate two different items, but I think given the history of this case and other items, I think we've determined that, there's silo A, silo B, and all that kind of stuff. I think going forward, I could be wrong, but I think the petitioner has named one or both parties in several of his cases. So, if this particular item is against City Hall, right, building management, I think the previous case might have been against the Sheriff's Department where they were going to produce that training document to us.
But please, let's not conflate the two cases. We can't do that.
But what I'm trying to say is they are already conflated in our past.
If you want to combine the two cases, then let's do that. Otherwise, you must keep them independent of each other.
Okay, I just have one point I want to make.
Because it's on the same agenda. We can't do that.
I just have one point I want to make, that this response was submitted by City Hall.
Can you speak closer into the microphone? Or just pull the microphone closer to you. That way. Great. Thank you.
I just want to make the note to the file that this response is from Vicki Hennessy and City Hall, and it responds to 18012 and 18028. It's a combined response, so we might want to consider that when we're thinking about the next matter.
Okay. Thank you. I understand, Member Highland, that these two cases are similar, but they were heard independently for a reason. Okay. That the task force did not want to combine them. The committee did not want them combined. So, let's hear them independently for the issues that may be independent of each other.
All right, and again, not to get into the merits of this case or the next one, I think there's a second piece of the documentation that we were waiting from our DCA. I'm wondering if back in the notes, I'm not sure if that ever made it in. I would hate to first go all the way down the road and then continue it because that's not in as well. Am I misremembering that, looking at the notes? So there's two critical documents, one from City Hall and our Sheriff's Department, and then a analysis by our DCA on ADA and versus our charter. Ring a bell?
I didn't.
I'll find it in the notes.
Because I didn't see that in the minutes.
It's something we've asked for in the past. I'm just not sure if we ever got it.
Okay.
Is the point I'm trying to make.
Okay.
And I think we need those two things to be able to move forward with either case.
Well, there was a response from former DCA Nicola on it, who did an analysis.
And that analysis did not take into account 28 CFR 36.302, which is very, very important. Again, 28 CFR, Code of Federal Regulations 36.302, in which it states that if the handler or the service animal, for the handler's safety or for the service animal safety, cannot use a leash, at that point, the only requirement under the law is that the animal be under voice control, tether, or any other effective means. Meaning, I can even use a tennis ball in order to control her. again, this is only for service animals. And again, like I told the task force that she is a registered service animal under San Francisco. She's a California assistance tag. You have that information. She's legal. She's up on her vaccines. The only thing here is that she's a pit bull. And unfortunately, or fortunately for me, federal law says that breed restrictions and local laws against those particular breeds is no reason to disallow the designation of a service animal upon any upon my dog, who happens to be a pit bull. But I've done everything that the law requires me to do to have her as a service animal. She's never acted out of control. They have never presented proof or evidence that she's out of control. I just please ask that you respect that.
Yeah, Chair. I mean, our job here is to determine whether there was a barrier to access.
Yeah, and it says
Not whether there's a problem with the animal or not. It's just did somebody prevent access to a meeting?
And then under your own laws, under your I think it's the last paragraph of the packets that you send to everybody else. It says that if there's a greater if there's a conflict between local laws, the Brown Act, or any other laws, ADA surpasses that, and the one that gives you greater access prevails. And this is what I asked. I believe that's 67.5 under that statute.
I think with
Member Martin.
file 18012, if you follow the timeline, August 21 EOT, November 7, 2018 task force, December 5, 2018 task force, January 2, 2019 task force, April 16 compliance and amendments, May 21, I think the EOT.
What page are you looking at?
Page 3.
Now we're at staff
Staff
compliance
notes.
and amendments, August 27. At that point, it was Lori Mazzola, not present, did not communicate with the administrator. They wouldn't appear. Referred the matter to SOTF with recommendation of willful misconduct violations, and that the building management provide a person most knowledgeable at the hearing. Well, the person most knowledgeable is not here. It's the recommendation that there'd be a finding of willful misconduct. I think the next one may be the case that additional material might be relevant to. It looks like this was referred to the task force just to say no one showed up, willful misconduct.
Right.
That's what it looks like to me if you want to narrow it. But if anyone's reading it differently, please let me know. If that's the case, then I think we just proceed and dispense with it. It's fairly clear.
Yeah, and the next item is also referred, but less clear cut. We've got to kind of unpack that a little bit more. I agree with that. That's how I read it too.
And also, if I may, I have video from the last time.
Hold on.
Sorry.
I think
We're not-
that packet, you'll have 5 minutes, I think, to talk
Okay.
about all this stuff.
We're
That
not-
packet may be more relevant to the second matter, is I think that committee had asked for those materials at that. And we can address it then. If it's tied to both, you said they referenced both, even
The
though.
response
Okay.
was by the Sheriff's Office and City Hall Building Management.
Yeah, so I think
For both
that,
matters.
I think in the next matter, that may be more relevant to what was discussed.
Yeah, in the next matter, I specifically asked for that update
Okay.
regarding service animals, et cetera, et cetera.
Can we not refer to other
Yes.
cases that are currently on our agenda?
So I would move to go forward with this and not utilize the material for this matter.
Okay,
I'd agree with that one.
okay.
On
great.
that note, do we want to maybe push the second matter back a few items to let Mr. Tedeschi review it, and then
I'm, well, that's, again, the question, the first question
Well, we can come up with that question again at the next item. I mean,
Yeah, it will definitely have to ask the same questions for the second one. But let's just, silo this one and determine the merits of this particular case, which is specific to City Hall and the City Hall administration.
all right. And then do we want to push this the item 4 to
No.
later to allow him to review? or
No.
Okay.
No, I don't. We'll deal with that when we get to item 4. Okay. How do you want to proceed?
I'll second Member Martin's.
Which
Member
was
Martin's
was that a motion, Member
Yeah.
Martin? And
Yeah.
repeat it, please.
So it's a motion to hear
Item 3.
item 180.12. and to
Well, it's
proceed.
already on the agenda.
Sorry, to not have the materials attached to that item,
Okay, so not to accept the materials.
related to file number 18012.
Okay.
Because they were submitted late.
There's, I
Yes.
don't know that is applicable, okay, because this is already an open case, and the deadlines for submitting for the record is applicable for the initiation at the beginning of the complaint process. If there is other evidence or information that comes in, then we need to consider whether we want to accept it into the file or not. I don't necessarily think that there's a time factor.
Is there not a time factor for getting anything into the package for the members of the public? I mean, that just
Well,
hurt.
it's just for publishing, okay? The fact that this arrived yesterday and neither of us or one of the parties was able to review it, you can say, okay, let's have a continuance so everybody can read it and we'll come back to it at some other time. Okay, but the question is the concern I have is that is to determine whether that item actually has any bearing, any relevance to what happened in 2018. This is now. This is 2019.
No.
I'm sorry,
2017.
2017.
Yeah.
Sorry. So does it have any relevance? Because now it's active, it's an official policy. Is it retroactive back to 2017? I can't imagine that it would be.
It doesn't matter. We've already ruled on what happened then, and this is
Exactly.
the remediation.
Exactly.
I think, again, to this, it was referred back here with the recommendation of willful misconduct violations on the part of building management, City Hall building management, and that a person most knowledgeable appear at this hearing. Well, they're not here,
Okay.
okay? And there
So
was a
that's-
recommendation for a willful misconduct violation. As far as I'm concerned, those are the two.
Right. That's what I'm
issues.
saying. The submission of thank you very much for
Irrelevant.
creating a
Yeah.
policy. We glad that there is a policy. I think the task force independently should look at it and see if it's in compliance with state and local law, and then that's a completely different memo, and position that we take. For right now, Member Martin, you're correct. I think the issue here is, why did this come back to the task force? Why did the committee send it back to us? And that's what we're here at hand. So if we can put the submission of this document to rest and move ahead with the rest of the case, I think that will serve everybody's interest at this point. Okay? All right, so let's do that. So we're considering we're considering a recommendation of willful misconduct violations on the part of City Hall building management, and the second part is that they send somebody to this meeting, which they haven't, which seems to further bolster the willful part. So,
Sorry, I'm making a motion to proceed without including the materials that were provided.
we are already in procedure.
Oh, okay,
We don't have to make a motion. The item is on our agenda before us.
Okay, good.
Question is what do we want to do moving forward? What action? Action, no action?
Well, in the light of any other information, I think we take the recommendations of the CAC.
Okay. So is there a motion?
So moved.
What motion?
What's the motion? Yeah.
Well, let's talk about that a little bit more then,
So
especially as to where we want to send it.
Let's deliberate what the motion should be. So you have two recommendations. One is based upon the current history of the case to make a recommendation of willful misconduct violations. That would be a report to the Ethics Commission as to the facts that leads up to that kind of conclusion. It'll be up to the Ethics Commission to make a determination of willful misconduct. We do not do that here. All we can do is provide the facts and evidence that may exhibit that. Member Yankee.
So I'm looking at the last order of determination, which was February 6th of 2019. It's, we made, found that they violated Administrative Code 6713A by failing to allow access to a meeting of a policy body. So I guess my question to the petitioner would be, since that date, February 6, 2019, have you had issues with access to a meeting of a policy body?
Yes, I have, and I have a video that I'd like to submit. For some of you who haven't seen this video, the last compliance and amendments, they have seen the video, but this is what happened after that determination. And I'd like to show it to
Member
you.
Yankee, what file number was that on February 6th?
This is the packet that's
It's the same, should be the same.
yeah, it should be the
file
same
number.
one.
It's
Yeah.
18.12 and then
If you open
18.
up the agenda item for that, for
28.
item number 3, yeah, it's the first few pages there is the,
Problem is that's appearing on item 4, that date you referenced. That's falling under 18028.
28, yeah.
So is there a order determination on 18012?
Yes, there
It's on
is.
page 10.
yeah.
I'm looking at the staff notes. I don't see it in there. Hold on.
Page 12?
Oh, excuse me.
12, page 12.
Wording is on page
Yeah.
12. It starts on page 10.
That'll form the basis of our motion, right?
Right, so my question would be is, since we made that, order of determination, has the problem continued?
Right.
Yes, it has, is my answer. And I also have the video to show you. And I wanted to show you this video for the full task force to see it, to see what I'm talking about. And so this would add to the willfulness of this whole action. And I respectfully ask that you not go to the Ethics Commission, but go to the Attorney General. I think I'll have a fair review there.
We do have limitations for that. It's not
just a letter,
carte
yeah.
blanche
Yeah.
for us to do that, because certain parts of the ordinance allow that and other parts for other bodies.
But I believe it's
But
in your
we'll-
power to write a letter saying, look, we have this situation. This gentleman's still not able to come into the city hall, and can you please advise or?
All right, well, let's proceed.
What date was that video, Mr. Tessie? Or is it on the...
Yeah, it should be actually on the. Let me see. Sorry.
Okay, I see the OD, February 6, 2019. All right. And that's
This is on,
violation of 6713A.
This is
Thank-
May 4th. Is the video that I have right here
Of 2019.
of 2019, May 4th, 2019. And this is the test. That here it is. I think the
You should
volume
be able to
is.
see it on your.
Everybody look at your monitor.
Cheryl, the volume is on. I believe the volume is on your end.
You want to stop it for a moment?
Sure. Sorry.
Nice if this can go in the record, but...
I'm trying now.
Okay. Okay.
There's no sound.
No, so I'm trying to figure.
There you go.
So this is Rosie. Again, May 4th, 2019, entering City Hall. And good girl. As you can see, she's right on my right the whole time. And I'll try to go faster. Up. Hello.
How are you?
Good.
Me?
I do not. She's under voice control. She's a service animal. Non-violent protection in the city.
Okay, give me just a second, okay?
Okay.
So I explained nonviolent protection is a task.
Yep. Sit.
She lays down. And so a call is being made right now, as opposed to what they said before is he'll be able to just come in. No, I'm not. A special call has to be made, and then the sergeant comes down. So I'm going to just go forward a little bit, so don't waste anybody's time. And this, while we're waiting, there's an unsolicited remark by a gentleman who I assume works here, who states that he sees service animals all the time in City Hall, and this one is actually a real service animal. He can tell. He actually says this. I don't know this person. This is completely...
I'm just wondering if you know a great place to be.
This is the gentleman. Listen to what he says.
A few choices down if you go to the Twitter building on Market Street. So just take a right and then walk into the same market and it'll be like a big tourist.
Fantastic.
Yeah.
So you're on the phone with.
Yeah, with my supervisor because I haven't been here for a while, so we're
Okay.
just checking the status.
So she's under control. She's a service animal, and non-violent protection is a task that she provides me. And her certifying determination, I want a determination against the sheriff's department to let me through, and you're not letting me through.
Sorry, sir, give me just a second. Just following protocol.
Okay.
I might have skipped the comment that he made. But. Three more minutes, sorry. It's just gentleman right here, I think.
Yeah, so one of my supervisors are going to come up here and then he'll have a word with you.
It should be very easy, yes or no. I mean, why am I having to
He's going to give the final say.
Okay. He can't tell me, he can't tell you, or he can't?
I'm just following message.
Okay, all right.
I think that's the first time I've seen a real service dog. I see a lot of dogs in the past. You can sure tell when they've been trained.
You can sure tell when they've been trained. That's what he just said.
Thank you.
Totally unsolicited. So I'm going to go forward a little bit.
160.
Oh, so then the sergeant does come down. He waves me in, and I'm very happy. Wow. And so we're walking toward the elevators. He's going to mention something about her vest.
I like his new, what do you call it, a little
Tactical vest, he calls it.
vest there.
I say nothing. Now this is the same guy who has threatened to shoot her with a gun, with his hand on his gun.
You can take the car out. Wait. I feel comfortable with you guys in the.
We're going to escort you up to wherever you're going. I'm letting you know that now, so there's no things after that.
No,
We'll leave you alone.
I don't feel like.
That is our instruction as of right now.
So they're going to escort
I'm not
me.
going to stay with you.
So you're gonna follow me everywhere
No,
I
we're
go.
just going to follow you to wherever your destination.
No, I'm sorry. That's unacceptable.
Okay, that's fine.
That's a denial of.
Have a good.
And that's that.
What was that sergeant's name? It's okay. Yeah. And did you then go up to the meeting with Rosie? So he offered to.
No, I
offered
did
to-
not. I did not. And then this is what. So I went to get some papers, and this is what I got. So what I did was I
It's okay. Take your time.
I tied her up outside, made sure she wasn't on City Hall property, went to a sidewalk, and this is what happens when I come out. I see them surrounding her. Again, I'm assuming to call ACC and to get her out of here, out of there.
Hey, baby. Sure, that's fine.
That's what happened.
Okay.
She's not barking at them, although she has every reason to, because of all the past incidents with these sheriff's officers, and she's just patiently waiting for me. That's it.
So just to go back to the end of your video, when you're inside, the sheriff says, "I'm going to escort you to where you're going."
Yeah.
And you said, "I prefer you don't do that." And then
Yeah.
you then left City Hall.
Yeah,
Okay.
yeah. So then I left and I tied her outside, and then so when I videotaped this last clip that you just saw was when I went to the supervisor's office to get the packet, and I left. And I walked out to get her. So it was within just maybe 3 minutes.
Okay.
So that's why she wasn't taken. But basically they were on the radio call again, calling ACC to pick her up.
Could I just ask if you had just said, "No, thank you, I don't want your escort," and then got in the elevator, was that sergeant going to follow you up anyway?
I did not want to take the elevator with him hovering behind me.
Right.
It's not acceptable, and he's going to follow me into the bathroom. He's going to follow me into wherever. That's not, if Rosie was out of control, then I could see potentially that type of action. But without that action, she was under control, as you can see. These are the same people who have chained her up, who've put her on a choke collar, and would not let her go for 30 minutes on November 7th, 2017, when I was actually attending another task force meeting here, and she doesn't even bark at them.
Okay.
Okay. She's not.
That's great. Thank you.
So I just want to remind everybody that if you look on page 12 from our order of determination of February 6th of this year, 2019, that we found as Member Yankee had put it, to find a violation of 6713A by failing to allow access to a meeting of a body. And then I took the prerogative to refer the matter to the Compliance and Amendments Committee to monitor the petitioner's ability to enter City Hall with a service animal off leash. So it was appropriate to have the video shown at this point. It's just continually monitoring, whether it's at the subcommittee or whether it's here. We have, far more jurisdiction over the committee. So that's kind of where we're at this point. We have a recommendation from the Compliance and Amendments Committee. What should we do?
Well, I think we sent it back to the board for consideration of sending it. Obviously, they have continued to prevent Mr. Tedessa from free movement around City Hall, according to our order of determination, and we wanted to bring it back to the full task force, I guess, for consideration of sending it to ethics or taking some other action.
And what choices what places can we send it? Ethics, Attorney General, or DA?
Well, in this one, let's see.
be the most.
This is not a 6721 issue. So there's section in there around the Attorney General part. The section for here,
This one was 6713A.
right, so there's no application as far as where enforcement goes. So you have to go to the bottom of the ordinance, and it would be
I think 6734 talks about willful
Right.
failure, and it looks like it says shall be handled by the Ethics
Yeah,
Commission.
but that's for willful misconduct, willful failure. But there's also another section here that talks about, let's see, if there's any violation. Where was that? Well, 6735 is for the individual. The 60, I think it was in 6730. Here, 6730C, in the middle, the task force shall make referrals to a municipal office with enforcement power under this ordinance or under California Public Records Act and the Brown Act whenever it concludes that any person has violated any provisions of this ordinance or acts. So municipal office, that would be most likely the DA. Because the municipal, I would gather to mean local. The AG's office is a state body. The DA essentially is a district office of the AG anyway. They're going to be, they would be applying the same set of laws in the same rubric. I'm getting a nod from our legal counsel that that's the case. Okay. So you have 6730C. You have, we can't find a violation of 6734. We've have an agreement with the Ethics Commission that they would be the ones to find a violation of 6734, but we can provide them with recommendations of facts and evidence that could help that would provide them advice or information that that they may take an action on that. Those are the two options. Not independent or combined or together.
I mean, based on compliance, and I think that's what it, is that the prior committee it was at? Compliance amendments?
Compliance amendments, yeah.
I would make a motion to find a violation under the first.
6730C.
Correct, I think that's what you were referencing.
Yeah, that's if it, but the petitioner has petitioned to us to send it to the AG's office. 6730C doesn't allow that. It allows only to a municipal office. So
That'd be
it has to
district
be local
attorney.
district attorney.
Yeah, I'd make a motion for that.
Okay, so we have a motion to find a violation of 6730C.
30 or 6737?
6730C. And is there a second?
I think we want to say we want to find continued violations of 6713A and refer it under 6730C.
However you want to.
Yeah, I would.
Because there's not
Yeah.
a violation.
Right, it's not,
C.
yeah, we're just referring under 6730.
Member Yankee, please make the motion.
So I would move to a friendly amendment to that motion.
Well, just make a clean one. Go ahead.
Just
I'll
make a
make that
clean
motion cleanly.
Make a clean
So, okay, so I
motion.
would move to find continued violations under 6713A and refer to the district attorney under 6730C.
Okay. Is there a second?
I'll second.
Okay. Is there anything specific, language or message that you want to include that to the district attorney? I mean, any kind of direction? If not, that's fine. We just send it off and...
I mean, I think the video is fairly self-evident of the issues that the petitioner's having, so.
Okay, so we're including the video into the record also?
Yes, yeah.
Okay.
Yeah, including.
Is it possible to actually add the SFMTA website issue to this? No.
No.
Okay.
Sorry.
Okay.
No,
Okay.
that's a different case.
Okay.
So we need to get the video from the petitioner and have that included.
Yeah, is that something that you can send to Cheryl?
Sure.
Okay,
Sure.
great.
But
Okay.
I've tried to do that before, and it wasn't able to be submitted.
We can't
because of
submit the
Drupal.
video that he had in the state that it is into the agenda packet that was going to be published. That was our issue the last time.
Can it be uploaded to somewhere so a link can
Well,
be
one
provided?
thing a friend of mine had suggested was to have him put the video on YouTube
Okay,
and send it that way.
you could do it
Yeah,
that way
yeah, I
too.
could do that. Sure.
And send it to me.
Or
And
something
if you
like
have difficulties,
that.
please get in touch with me.
Okay.
We'll figure out something.
Okay.
Okay, so we have a motion. Is there any more discussion on the motion? Let's get public comment. Thank you, Mr. Tedessa. Any public comment on this motion? Seeing none.
May I comment from the phone? Hello?
Yes, go ahead. Unmute the mic.
It is unmuted.
Okay, go for it. Person on the phone.
Sure. So I strongly urge you to vote for this motion. I know that because there are only, I think, 7 or maybe 8 of you there, I believe they need a full 6 of you to vote in favor of them in the public. I'm not sure about the rules. So I please urge every one of you to vote for this. As you know, justice delayed is justice denied. This complainant has been waiting for years for this, and I want to thank you also for not continuing the matter to later or accepting late evidence. And I would suggest not only do you make this motion, but you would suggest send it also to the Ethics Commission for a public hearing, so there can be both a law enforcement investigation and a public hearing at the ethics level. Thank you very much.
Any other public comment? Seeing none, ready for a vote? Please call roll.
Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf, not present. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Hensy?
Aye.
Member Hensy, aye. Member Highland?
Aye.
Member Highland, aye. Member Wolf? Chair Wolf?
Aye.
Chair Wolf, aye. Motion passes.
Great. Okay, please call next item.
Second. Item number 4, file number 18028, complaint filed by Denta Tedeschi against the Sheriff's Department for violating Administrative Code Section 67.5 by restricting access to all meetings of any policy body in City Hall.
Okay. So this item also, so this item was heard on February 6, 2019. Task Force found a violation of Section 6730A by failing to allow access to a meeting of a body. On August 27th, 2019, the Compliance and Amendments Committee referred the matter back to the task force. And so here we are. Okay, so we have a order of determination that was made on March 6th. That's on page, starts on page 146. And it was to find a violation of, find a violation of 6730, find the Sheriff's Department violated Administrative Code Section 6713A by failing to make public meetings accessible to persons with disabilities caused by the mandatory service of animal leash requirements. And again, this was referred to compliance amendments for monitoring. Is somebody from the Sheriff's Department here? Respondent is not present. Again, we've been notified that there has been a new policy that has been submitted to the task force that was recently approved. That policy was not in effect at the time of the violation or at the time of the order of determination. And so, again, how should we dispense with this? Is it the same set of issues or a different set of issues?
Well, I think that the materials provided late may be more relevant to this matter than the preceding one. I also think that there was the hearing in February. I think that's when it was, right? The task force meeting, when the order was handed down. Subsequently, there was a pilot policy following that.
But that was rescinded.
Well, right, but all this happened in the span. I think they had compliance and amendments in April, and it had been rescinded at that point.
Right, because they actually came to that meeting and they said, yeah, we did this, but this is not a continued policy.
Right, and then I think, was your guys' conclusion why?
No, we never got to
It was not clear.
Right, so in our notes,
never got to the why.
it says Captain William Kelleher, Sheriff's Department respondent, provided a summary of the department's position, period. Captain Kelleher stated the sheriff's directive, which allowed for off-leash service animals to enter City Hall, was a pilot program that has been revoked upon review and consultation with the city attorney, sheriff's legal, city administrator, and building management, period. Captain Keller stated that they are in the process of developing new policies regarding the matter.
Okay, so I think that's where the material might be relevant, is if they have been developing policies.
Well, the question is are we here to review the policies and whether they're applicable or not, or are we here to hear about the recommendation from CAC as to compliance based upon the monitoring?
Is the mayor's office on disability here?
No.
Mayor's office on
Yeah, so
disability?
They're not here.
The action was, it was moved by former member Kanata, seconded by member Hinsey to refer the matter to the task force with the recommendation, this is from the Compliance and Amendments Committee, with the recommendation that the sheriff's office has not complied with the order of determination, that a member of the sheriff's department who has knowledge of the service animal program be in attendance, and that a member of the mayor's office of disability be present at the next hearing.
And there's not a member of the sheriff's department?
No.
Okay, then I think we follow the same outline as the previous hearing.
And
Previous matter. Sorry.
I would note that a quick glance at the current website, we can always go to that and look to see if there's anything that we think allows full access under 6713, and that should be their up-to-date policies if we want to do that.
I think we, once we determine what the outcome is of this, that we should take up that discussion as to what committee it should go to and with what charge.
Right, and one would hope that the respondents would appear at that committee hearing to tell us what the new policies are.
Okay, we can make that. What's the verb for compelling? Compelling. We can compel them to do so. Okay. Any questions for the petitioner, who's the only party here? Do you want to accept the video we saw in the last for the last case into the record for this one?
I think so. It's relevant.
Okay.
Yeah.
Can somebody make a motion for that, because it's somewhat...
I'd like to make a motion to accept the video that was presented in the last case to be appended to the evidence for this case going forward.
I'll second.
So moved by Member LaHood, second by Member Hinsey. Is there any public comment on that motion? Seeing none, can you please call the roll for that? Thank you.
Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Yankee?
Aye.
Member Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf, absent. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye.
Okay. Now, is there any other motions? Actions?
I would move the same motion I made for the prior one.
Just
Yeah,
state it,
violation
because
under.
it's a different respondent,
Yeah.
so state it.
Violation, find continued violation under section 6713A and refer to the district attorney under 6730C.
Is there a second?
I'll second.
It's moved by Member Yankee, second by Member Martin. Any further debate, discussion?
Based on previous public comment, do
Member
we
Highland?
also want to refer it to another body like ethics, or do we decide that we can't do that?
You can do that under,
Because it's not a 34?
hold on, it's under,
And if we can, do we want to? I'll just put that out there for...
well, it's up to you. I mean, it would be under our process for 6734. If you want 6734 considered, it has to be considered by the Ethics Commission. We would just send the whole case over to them with instruction about how we think that it's willful. But we can't make a recommendation for 6734. All we can state to them is that we find this to be willful.
So that would be 6713A.
No, 6734.
So the motion would be amended if we were to do that, to read under 6713A and forward it under 6730 and
But
6734.
the violation is 6713A.
Right.
We already found that. What Member Yankee is doing is saying that it continues.
Yeah,
Okay?
under 30 and 34,
No,
if,
no.
if we change it.
No,
Or-
6713A is the actual
got
violation.
that.
Okay,
Yep.
6730C is the process for reporting it to the municipal office.
Right.
6734 is to find I don't know what the right word for it.
Refer it to ethics.
It could be referred to ethics to be considered as willful failure.
Okay. Just to play devil's advocate, if we refer to both, they might just bounce it back and forth. So I think maybe just having the original motion stand is probably...
Yeah, I'd be more inclined to do that,
Okay.
especially since
All right,
we're
I
going
just
to
want
be
to-
having a new district attorney. We might want to see how that plays out before we.
Okay, agreed.
Spread it
I just
all
wanted to
over.
discuss it, so I'm happy with that then.
Okay.
Okay, so can we review what the motion really
Okay,
is?
the motion is to continue to find a violation of 6713A based upon the evidence has been presented that through our monitoring, this is just narrative, through the continual monitoring by the task force, we're finding that this violation continues. We are invoking the process of 6730C to refer it to a municipal office, which we're determining to be the district attorney. And again, it's 6730C, it's the second to last sentence. The task force shall make referrals to a municipal office with enforcement power under this ordinance or under the California Public Records Act and the Brown Act whenever it concludes that any person has violated any provisions of this ordinance or the acts. Okay? All right. Is there any public comment?
Yes.
One moment on the phone, please.
Sorry?
Go ahead, Mr. Picarello.
Good evening, task force members. Thomas Picarello. I'm troubled by you deferring 6734 to the Ethics Commission, and I was just wondering what legal authority you had to do that, since the ordinance was enacted by voters, giving you jurisdiction on 6734. You have the option of referring it to the Ethics Commission, District Attorney, or the Attorney General. By requiring a petitioner to separately go to the Ethics Commission on a 6734 violation, you're you're just delaying his or her ability to get public records or attend open meetings. So, but I'm more curious as to what legal authority that the task force has to delegate your authority to the Ethics Commission under 6734. Thank you.
I just want to respond to the public commenter on this. It has been the experience of the task force that when it invoked 6734, that there was some issues with it being adjudicated at the Ethics Commission. And subsequent to that, some years ago, it was found that there wasn't actually a set of rules that kind of outlined how the Ethics Commission should be handling sunshine cases. So there's actually two sets. One rule is if somebody brings a sunshine complaint to them directly, and one is if the task force provides a referral. Now, included into that referral for 6734, it was agreed by both entities that the task force would not find a violation of 6734, but would invoke a process for it so that it would be considered at the Ethics Commission, since they ultimately would be the ones to find the violation in the end anyway. It was the only way for the task force to make it work. And until the ordinance is amended to provide more authority to the task force itself for enforcement power, that's the best that could be done in support of the people in order for it to be considered at all. You can read in the minutes going back 10 years or more that every time a 6734 violation was sent to the Ethics Commission, it just went nowhere. So this was the best way to make sure that it at least had a day of hearing. It had its day in court to be heard in its entirety, and then the Ethics Commission would at least have the opportunity to hear the public and to make a determination based upon that. That's why if we do this, it's pretty serious. We want to make sure we have all our ducks in a row and we have all our facts and evidence really straight and provide them with good narrative and good direction so that there's no wiggle room. So that's why we're a little cautious about using 6734. But I think based upon Member Yankee's thought, because this is, I think with the sentiment of the topic of this particular case, bless you, with regards to that it's a potential ADA issue, that jumps a little higher because not only is there federal law on ADA, there's state law on ADA. And the Ethics Commission, they could take up issue on it, but it would be based more on a, kind of, did you follow the rules right or not? And was there are you actually doing something wrong? And so an order can come from a district attorney to make changes with regards to that. I think it just has a little more heft to it. So that's it. Okay, we have any other public comment? I think there's one on the phone.
Yes?
No, this is public comment on the motion. Go ahead.
Okay. So, sorry, there's a tremendous amount of static today. I don't know. It's not normally there, so I don't know if you can hear me. But sadly, I'm going to have to disagree with the previous public commenter. It does appear, and obviously this is directed solely at the task force and is not in any way legal advice to any complainant, but it does appear that for non-public records issues, the only options are the district attorney and the Ethics Commission. It doesn't appear the Attorney General can do anything for non-public records issues. But I would still ask that you reconsider. You can always make a second motion to also send this to the Ethics Commission. I do understand some of the members' apprehension in that they might just kind of both want the other person to deal with it. But I do think for this kind of issue, when someone is being denied access to a public hearing, that's something that should be discussed in a public hearing itself with the full transparency that a public hearing would accord. That's it. Thank you very much.
Is there any other public comment on the motion? Seeing none, are we ready for a vote? Okay, call roll.
Member Yankee?
Aye.
Member Yankee, who was the second? I didn't get that.
Martin, Member Martin.
Okay. Member Martin?
Aye.
Member Martin, aye. Member Wolf, not present. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye.
Motion passes.
Motion passes, sorry.
Okay, is there anything else for this? Did you want to consider the policy that has now been created to be reviewed by compliance and amendments?
Sure. I'll motion to. Do I need to make a motion? I will motion to have the new policy reviewed by the Compliance and Amendments Committee.
Second.
Okay, and is there anything you want them to do with it? I mean, is there any charge? You just want them to read it?
To review it and take into consideration whether it should be submitted regarding other issues, other cases that might still be open related to this issue.
If I can make a suggestion,
Yes.
I think we should determine whether it's in compliance with the Sunshine Ordinance.
I think that's a great idea.
Okay, and then whatever their recommendation is, if a communication needs to go out on behalf of the task force to make that recommendation.
Okay, so I motion that Compliance and Amendments review the new policy to see whether it's in compliance with the Sunshine Ordinance, and then make refer it back to the full task force for consideration.
With a recommendation.
With a recommendation.
Okay.
Would it be worth noting that that policy is under the Mayor's Office on Disability? Am I correct? And is that where it comes from?
I don't know. We haven't seen the document, so we don't know.
Yeah,
No, but I think both these other bodies that we've dealt with today are under the purview of that body, and that body has the policy, which is on their website, which is in violation of 6713.
But we're not. But the question.
I'm just saying, so it's all.
But we can't consider items that are not pertinent to the case. So if we're talking about this policy that was submitted that supposedly is joint between the building management of City Hall and the Sheriff's Department.
Got it.
The Department of Disability may apply everywhere else, but our focus here is on City Hall, which could extend to other city buildings.
Okay.
But the city does business in buildings that the city doesn't own either. So there's some
Just keep it within the case.
kind of thing,
Got it.
issues with that.
So nobody's going to review this, or?
CAC should review it.
Yeah, we're just sending it to CAC. We'll wait for their recommendation. That's it. Okay. Anything else? Is there a second? Wait, second member testify. Is there any other deliberation, debate on this? Any public comment on this motion for referral to compliance and amendments? Seeing no public comment, please call roll.
Member LaHood?
Aye.
Member LaHood, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf, absent. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
The motion to send to the Compliance and Amendments Committee passes.
Okay, let's call the next item. Oh, public comment. So we might be on 5 o'clock. Please call item number 5, which is the next item.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within this task force jurisdiction but not on today's agenda.
Hi, this is Denta Tedessa again. I'd like to just submit to the task force another video. This happened on a Muni bus, the same issue regarding this leashing. The driver was terrified Rosie, mentioned to me that I need to have a muzzle. I said no, she does not have to have a muzzle. She's a service animal. He then called the SFPD. Well, he actually asked everybody to exit. Everybody exited, and the this same actually incident. This is kind of a a good. This is a good. This is a point of view from the SFPD. This is the SFPD getting things right, because I still stood my ground. She was the same way. A couple months earlier when I was arrested. I was arrested, taken off the bus, arrested. Even if I demanded that I would sign the ticket, they refused me even that. They took me to jail. They took Rosie to ACC, and I had to pick her up after spending a night in jail, all because of the drivers being afraid. So this is actually this is the one time that actually worked. This is how it's supposed to work. And I will really try to be brief on this.
What date is this?
This happened. This was on July 5th, 2019. So it's still happening. So that's why I'm saying all my complaints from the SFMTA website to the city attorney's office, serving me with the revocation of my 5-year ban from the cable cars. All of this is connected. This is why the sheriff's officers are acting the way they are. And it all ends up to the city attorney's office, basically, because the city attorneys, they are the law of the land. And so this is basically after everybody's exited the bus, and
This is unacceptable.
And I'm really frustrated, as you can hear, because this has happened over and over and over and over again, And so empty bus. I'm just waiting for the cops to come, and here they come.
There has nothing. There is nothing that she's done, nor there's nothing that I have. I'm sorry.
Why? Just let me talk. They just told. I don't even know what's going on.
Because he's not driving the bus. I told him she's a service animal. This has happened repeatedly.
Service dogs are allowed here.
No. Yes. As long as they're under control.
Yeah.
Of their handler, they can be off leash.
Yeah. I'll see.
Okay. I just got on the bus. He wouldn't open.
What's her name?
Rosie. He wouldn't open the back door, so I went to the front door. He said, "You have to have a leash." I said, "How am I going to carry?
Turn it down.
How am I going to hold this with all these bags?"
Okay.
Number one. Number two, as long as the animal is under control, you can have that service animal off leash. If you use voice control, signal, tether, those are the 3 other means of control that service animals have.
Okay.
She has a California assistance tag. Right. This California assistance tag is only given to service animals. Okay? This is for.
I believe you're correct. I just got here.
Yeah. So what I'm.
And I'm trying to put this a little bit lower in volume because this is not reflective because this is on the high volume. So can you please
change it on your end? No.
Yeah, because I can't change it here.
Because okay, well that's part of my.
So it's kind of.
I'm sorry to say.
That's okay. No worries.
And
I don't want it to be taken out of context, but I am frustrated. I'm not cursing.
No, I'll keep my. I won't have your.
I'm normally not like this.
What I'm just saying is, I have a right to the bus. I have a right to ride the bus. I paid my fare. She. This is what I'm talking about.
So this is the thing. There's always different sides of the stories, but when we get called,
it's unacceptable how SFMTA has. It's a long history with you guys and then also SFMTA. That's why.
I'm just trying to explain that when we got the call. All this said is there was somebody on the bus refused to leave with an aggressive dog not on a leash. And now do you see I'm comfortable?
Okay.
I'm still not comfortable because you never know. But I have to assess the situation, and when they say it's an aggressive dog, I don't know you, I don't know the dog, right?
No.
So when I come on,
and that is to the credit of the SFPD.
No.
So that's why
I would have a muzzle for God's sake if that was the case.
Okay.
This is.
Hold on
it's
one
happened
sec.
to me. It's
Hold on one sec. I'm going to talk to my partner. Just talk to me, but
He just said that according to his boss, what his boss said is a dog on a bus. They gotta have either a leash.
And just look at her.
Okay. Have him call.
Looks like Yoda.
Huh?
Looks like Yoda.
Yeah. I mean, she's.
I know.
I know. I have the rule. I have the rule from.
I know. We're double checking.
I have it from the chairman of the SFMTA.
Yeah, I know.
himself.
I'm pretty sure you're right. That's why we're going to.
And they are well known to me, and it's because my dog is a pit bull, and it doesn't help my color. I say that as a secondary, but she is such a. She didn't bark. She didn't even.
New policy came out for the whole city and in general.
For service animals?
Service dogs.
And you know why? That was because of the Sunshine Task Force complaint because of me.
Oh, really?
Yes.
So
that's why I find this. That's why I'm a little bit amped up. If this was the first time it happened, I would be very calm.
So there's service dogs, and then there's
emotional support.
Emotional support.
Those are not service dogs.
Exactly. And so in San Francisco, only city buildings in Muni will accept the emotional support dogs.
No,
but nowhere else in the city has to accept emotional support.
No. Title.
But service dogs.
Title.
Everywhere.
Title 2 of the ADA has there is 509 rehabilitation code, and there's also there's another code which right now escapes me is the HUD, emotional support animal guide. So
Mr.
HUD,
Tedessa, can you stop it for a moment? So you're out of time here.
Sorry.
Is there anything more pertinent?
I just want to. I mean, since for the last for the 18028, I didn't even speak. So I respectfully would ask that my time there be allowed here, if you can. If you can't, I understand. But the thing that I want to impart to you is the fact that this is a good ending, because the driver actually had to drive me to my destination. But actually, incredibly, later on, when I'm trying to get his ID, he refuses to give me his ID. Then he turns around on Fillmore and drives the bus in a direction that I don't know where he's going. I demand that he stop and he let me off. I mean, it's incredible. I have this video. And this is what's happening to me to this day. And when I tell you, from my heart, again, that this situation has had me evicted, for God's sake, evicted when I asked for video to show why I have Rosie off leash at my building, and it's because of her safety. She's able to escape these other dogs, which are quite vicious. Yes. And so when that happens, and when that is compounded with the collusion between the building management and the city attorney's office and SFMTA to get me out, this is the result, and it's still happening to this day. And I will file more complaints regarding this issue and others, but I just want to. This is what's happening, and it's happening to this day.
Thank you, Mr. Tedessa.
Thanks.
Any other public comment? General public comment. Go ahead on the phone.
Good evening. Of course, I can only speak about cases not before you today. First, I wanted to thank the Department of Police Accountability for publishing last night over 9,000 pages of SB 1421 police records. However, as we speak, the Police Commission is having a hearing about creating additional non-statutory exemptions and delays in SB 1421. Thankfully, the public defender is fighting the good fight over there. Now, they invited numerous stakeholders regarding police transparency. Why not invite this task force? I have warned the various police agencies that if they refuse to follow the Sunshine Ordinance in these productions, including lack of justification of redactions, they're going to have to waste enormous time redoing all of their redactions. And I urge you to take a look at these issues of SB 1421 before the city wastes a lot of time and money. Second, I urge you to add an admonishment regarding California Rule of Professional Conduct 3.3 to your agendas. When a government lawyer cites a law or case to your task force, the rest of us non-attorneys have to trust that they are doing so correctly. I don't think that has always happened in the last many months. Third, a committee of your task force heard case 19108 last week, where the city attorney, because his spokesperson was on vacation, refused to attend or send anyone in his place. Now, your complaint procedure in that case, C8B, required that you give a majority vote because either the respondent had requested a continuance not within 5 days or the complainant didn't consent. Fortunately, your committee did not give that majority vote. Now, finally, in that same committee, Hank Heckel, on behalf of Mayor London Breed, before you and on tape, twice invoked the assassination of Supervisor Milk and Mayor Moscone by a former supervisor, not a random member of the public, as to why the mayor's entire future calendar is being hidden from the public. Now, the city of San Francisco proudly joins the federal government in using scaremongering tactics to suppress democracy when the words of the law are not on their side. Thank you very much.
Any other general public comment?
Thomas Piccarello. Thomas Piccarello again. Procedurally, have you exceeded the 2 minutes on public comment? I mean, last time I was here was 2 minutes. Now it's 3? Mm-hmm. 3, okay. I'm a big proponent of getting the city nonprofits subject to the Sunshine Ordinance. As some of you know, or should know, Administrative Code 12L this deprives anybody access to nonprofit records or public meetings. I think 12L allows us to go to 2 public meetings per year. So my suggestion to you is either agendize 12L or set up an ad hoc committee discussing nonprofits and Sunshine Ordinance and 12L. Initially, 12L, I believe, preceded the Sunshine Ordinance by a couple years. And at the time, nonprofits, most of them, were mom and pop, very small budgets. But today, many of them, if not most of them, have multi-million-dollar budgets, which exceed many of the city departments that you have jurisdiction on. So it seems to me that to have transparency and accountability, nonprofits should be subject to the Sunshine Ordinance and not 12L. Thank you.
Any other public comment? Please come forward.
I am Luke Moody.
Can you pull the microphone,
Hold the
please?
microphone to you.
Thank you.
Okay, I am Luke Moody.
Can you speak up? It has to be
I am
recorded.
Luke Moody, here from DSA, and this is my statement on police accountability. Being a police officer is an incredibly important job, a position located at the gates of life and death. The people who chose to be police must unequivocally hold themselves to a standard equal with their higher power. The thought of lying or hiding one's faults or failures shouldn't enter the mind of someone who purports to be the hand of justice. There is an infinite supply of honesty in this city. We need to hold those responsible, and let those who are honorable step in. Duty must be taken on with humility. You are not to be selfish in your service. Every interaction with citizens needs to be recorded, written, and with video. Imagine being held up by a man who can't handle too much paperwork. There are desk jobs and school for people who are at that stage in development. If you are jaded to police misconduct, get unjaded. Proper record keeping is essential. By the book and to the ID number, there's nothing wrong with being a cop. Make it that way.
Thank you. Any other general public comment? Seeing none, general public comment is closed. Please call next item.
Item number 6, file number 19017, complaint filed by Alika Vafi, Asian American Advancing Justice, Asian Law Caucus, Jeffrey Wang, Council on American Islamic Relations, San Francisco Bay Area, Alan Schlosser, Northern California American Civil Liberties Union, against Catherine Whalen and the Police Department for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. I do want to say that Javeria sent me on Friday 2 articles that she wanted included in the packet. It was too late to do that, so I brought copies of them. This was right after
Okay.
it was published. I did bring copies for everyone and for the public
Okay.
if you guys want it.
We'll take that up in a minute. Let's see, this was at CAC and referred back to us too. Member Highland, Member Hinsey, Member LaHood, is there anything you want to present?
What was this one?
This was on September 24th. This is multiple organizations against Lieutenant Catherine Walland in the police department.
I mean, the only thing I would add is it seems there have been some new progression with the case since we heard it. So,
Well, I think this has to do with a document between the SFPD and the FBI and counterterrorism stuff, a white paper. And there was a Superior Court judge who ruled on whether that document is public at this time or not. He said no. And it's whether the Superior Court trumps the Sunshine Ordinance task force.
Right. So the crux of the matter for this, first of all, both parties here? Can you come up to the front so it's easier to get to the microphone? And it helps our meeting go faster. Appreciate that. You just have a seat in the front row or just stand here wherever. Just I appreciate that. So basically, the crux of the matter is, and I'm reading from the case file, Lieutenant Andy Cox from the police department, respondent, provided a summary of the department's position, period. Lieutenant Cox stated that the police department has an order denying petitioner's motion for preemptory writ of mandamus from the Superior Court, and that the issue is currently in appeal, period. Lieutenant Cox stated that the order denies the complainant's motion to release the white paper, period. Lieutenant Cox stated that the police department will not release the white paper document, period. The action from the committee, it was moved by Member Highland, seconded by Member Hinsey to refer the matter to the task force, period. The committee requested that the task force legal counsel advise the task force regarding whether the ordinance overrides a Superior Court writ of mandate. Go ahead, Member.
And then I was going to say, and then according to the documents that were submitted for this hearing, it seems that it has been released, but not under the reasoning that was presented to us.
How were they presented?
Well, it says that, that they received an unredacted version later, and both versions are identical. But it was and I believe this was the second one that received, said that the FBI has loaned it.
So let's get some confirmation. Please state your name for the record.
This is Javeria. I'm Javeria Jamil with the Asian Law Caucus.
What's the petitioner?
The petitioner, yes. Did you want me to present or did you want me to answer the question?
Well, this is a referral back. There's no real presentation.
Okay.
If you want to just explain to us, what's happened since.
Sure.
And that would be helpful. Yeah.
Sure. So I think the last time that I was in front of the Compliance and Amendments Committee, the white paper had not been released, and we were still appealing the case up to the Court of Appeals. Since then, a lot of things have happened. The Court of Appeals dismissed our appeal, but they gave us the opportunity to go back to the Superior Court because facts had changed between the Superior Court ruling and the Court of Appeals ruling. And what had basically changed is that the FBI released a copy of the white paper to Supervisor Marr. And then a few minutes later, we also got a copy of the white paper from the city attorney's office, and I believe that was on October 3rd. We asked the SFPD for a copy of the white paper that they had in their possession because the way they had described the white paper did not fit the description, did not fit the substantive description of the white paper that we received from the FBI. SFPD continued to refuse to provide the white paper to us or their version of the white paper. And then on November 5th, I believe, is when the city attorney's office released the SFPD's version of the white paper to us. And both the FBI version and the SFPD version are identical except for the header on the SFPD version that does say that the FBI loaned the documents to SFPD.
Okay, so do you feel that the issue is satisfied at this point? Did you receive all the documents that you had requested?
Yes.
Okay, thank you. Any other questions for the petitioner? Any other questions for the respondent? No?
If I may, I get that we did receive the document. It's very unclear why SFPD decided to release the document, given that they refused to follow the order of determination by this task force, and the courts had, decided against us, and we decided not to pursue appeals in a certain way. So I think the point that I was hoping that I could make today, I have another request, is that SFPD throughout this whole process, and for the past year, violated the Sunshine Ordinance, flouted the process, refused to follow your order of determination. And I would like to request that this task force, at the end of the year, I know that you submit a report to the Board of Supervisors, and we're requesting that you include this incident, this whole case, as part of your report, because we think it sets up a really dangerous precedent, what SFPD has done, and the reasons that they've used to withhold the document. If these go unnoticed and unaddressed, they set a precedence for other entities and even SFPD for the future. And I can talk more about this, but that's the request that I'm making.
I'd also note that this is, I don't know whether we can consider this that there's case law on this now. The fact that there was some consequence to court proceedings and things that happened through that process. It's really not for us to determine why the information was released, but we're happy that it was, that the justice has now been processed properly. But I think it'd be good to hear from our legal counsel, not tonight, but just if you can review as to whether this sets a certain precedent, and if it does set a precedent that is based in a judicial proceeding, if we can get that notated so it can be referred to in the future for similar type of cases.
Just unclear, the question is whether the Superior Court's determination. The question is whether the Superior Court's determination is binding on this body.
No, it's more about that existing case law. It's kind of like, I'll use Smith versus San Jose. That's case law that applies or has an effect on the ordinance and our determinations.
Right.
So the question is there anything in this case that has the same kind of effect? And it's a little confusing because there was something that happened in the process, but in between court hearings, and I'm not quite sure if there was something that happened in one court that, that all of a sudden that compelled the release of the information. And if there is, and it was based upon some either existing case law that was older than this case, it just is good information for us that we can refer to and that you can refer to in providing us with advice for future similar cases.
Fair enough.
Because the fact that it took a year for that to finally happen, now that something happened in a judicial proceeding, we can call upon it to to compel the custodian to release it more immediately.
Right. I understand.
Okay,
I think I
great.
understand.
I'll just give, if the respondent has a comment, go ahead.
Thank you, Commissioner. I'm Lieutenant Andy Cox. I'm the officer in charge of San Francisco Police Department's Legal Division. Just in context, I do want to say to the board that it still is, the order to not provide the document is still standing. It's still of legal standing. The appeals court rejected it and sent it back to the lower court. There has not been anything since then to force this. We weren't, with the document being released, it was, as she said, the Board of Supervisor member asked the FBI to see it, and then that was given to him by the FBI.
Okay. It wasn't by your hand?
No, it was not.
Okay.
So at that point, once it was released and put online, the FBI, speaking with the city attorney's office, saw no reason why not to release it because the FBI was like, well, it's already out in the public's eye. There's no reason not to.
Okay, great. Cheryl, for our legal counsel, thank you.
Yeah, just to clarify, there was no court order requiring the dissemination?
No,
of this
there was
document?
not.
Okay.
And Lieutenant Cox, why was it released to the supervisor?
I can't answer that question. That would be that's with the FBI's general counsel.
Ms. Vahe, is that how you pronounce that right?
Sorry.
I'm sorry.
I'm Ms. Jamil, sorry.
Oh, Jamil, I'm sorry. Can you tell me how did Supervisor Marr get a hold of it?
Sure. I don't know the reason for why the FBI released it, but we did ask. There was a public hearing on a civil grand jury report that came out on the same matter. Supervisor Marr heads that committee, which is the Government Audit and Oversight Committee. And before the hearing, we had gone to him and tried to explain to him the issue at large, not specifically the white paper, but we had been talking about the issue at large. And in the course of those discussions, we had informed him of the white paper and the fact that SFPD has it, but they're not releasing it. But because we were in active litigation, we didn't think it was appropriate for Supervisor Marr to ask SFPD to release it. We did suggest to him that he ask the FBI for a copy of the white paper because the white paper is pertinent to the larger discussion that we were having. So he made the request and the FBI released it. Again, I'm not sure the reasoning behind the FBI's release, but that's what happened.
And you mentioned that this was also being heard in civil grand jury?
The civil grand jury investigated not the white paper, but a larger issue that's related to the white paper, which is FFPD's participation in the Joint Terrorism Task Force, and came out with a report. Yes.
Okay, thank you. Just to provide some context for that situation. Okay, members, how do you want to dispense with this? You can close the file. If you think it's satisfied, you want to take any further action?
I think closing the file, but I also like the recommendation of including this case in your annual report if you see fit.
Okay.
Are you making a motion?
Yeah.
Are you making a motion to close the
Sure. Should I turn that into a motion?
You can make any motion you want.
I would like to make a motion that we close the file and that the chair consider including a description of this case and how it was adjudicated or how it transpired in our annual report.
I'll second.
Moved by Member LaHood, second by Member Martin. Any discussion? No discussion. So, okay. All right. Any public comment on the motion? Seeing none?
Yes.
Oh, okay. Anonymous on the phone. Go for it.
All right. So I think, first of all, I think your task force should continue to investigate this because it's very strange that when a member of the public's various civil liberties organizations and then this task force order the request and then your task force order the disclosure, we don't get anywhere. But when a politician asks for the document, they get it immediately. And I've actually gone ahead and requested, as a completely separate request, all the communications back and forth between the city attorney, the SFPD, the FBI, DOJ, whoever it is, because we should find out, as the city, why this document was hidden and what arguments they had internally in order to hide these documents. So I do hope you analyze it in your report as well. Thank you.
Any other public comment on this motion? Seeing none, please call roll.
Member LaHood?
Aye.
Member LaHood, aye. Member Martin?
Aye.
Member Martin, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf, absent. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Hinsey?
Aye.
Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to close the matter passes.
Thank you. Let's call the next item.
Item number 7, file number 19077, complaint filed by Ahimsa Porter Sumchai against Mayor London Breed for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner, and 67.7 for not posting the agenda in a timely manner.
Are both parties here? Mr. Starkall? Okay, great. Okay, so this is a first timer. Complaint committee, anything to brief us on with this case?
Just there was a meeting that I think the doctor had been on a list to get notice of these meetings and then was subsequently removed, unknown why, so she could not attend the meeting. I think that's was a part of it. I'm sure you can correct me if I'm wrong. And yeah, I mean, I think that it's access to meeting. I think that was primarily the driver. So,
okay.
Was it not a public meeting?
All right, let's set the clock and start our process. Okay, you have 5 minutes.
Sure. My name's Dr. Ahimsa Porter Sumchai, and I am the surviving child of a longshoreman, a career longshoreman, George Donald Porter, whose contributing cause of death was pulmonary asbestosis. I was a physician specialist at the time that I signed his death certificate in 1992. I've been involved for over 25 years in environmental health and justice issues in Southeast San Francisco, where I grew up, and in 2000 was elected to the Hunters Point Shipyard Restoration Advisory Board. In August of 2001, I founded the Radiological Subcommittee. I have commented on many shipyard remediation documents, and I have a library of shipyard documents. The Navy disbanded the RAB in 2009, and I have intermittently participated in activities of the Hunters Point Shipyard Citizens Advisory Committee, which is a mayor's CAC. I would agree with the comments that were made by the complaint committee and state only that Sunshine Ordinance, San Francisco Administrative Code, Chapter 67, under findings and purpose states 67.13 that barriers to attendance are prohibited. I provided documentation that I have not only been on the email listserv for this organization for years. I gave you a email from March of 2018 where I responded to receiving the meeting notice, and the HPS-CAC administrator responded to my response. More significantly, I presented to this body in January of this year. It was a PowerPoint presentation, and there were email communications with regard to the PowerPoint. Most significantly, in early July, I applied for membership to the Hunters Point Shipyard CAC, and the administrator of the organization acknowledged receipt of my application. So for no intelligent reason, a announcement went out identifying that a special meeting of environment and reuse of this committee, the subcommittee I most often attend, was hosting 4 male scientists from UCSF and the UC system. I am a member of the University of California Medical Alumni Association Board of Directors, and I have an MD from UCSF, and I'm a postdoc from Stanford, a PhD equivalent. So I didn't receive the notice, the announcement via the listserv. And again, I am on the listserv, and I want to make it clear that part of my dispute in bringing this forward is the contention of the mayor's office that somehow or another I wasn't on the listserv and they added me back, and everything is fine. There is evidence that there was a purposeful, deliberate omission of me in noticing of this meeting, and there were other significant people, academic researchers, attorneys with the Environmental Justice Justice Clinic of the Golden Gate Law Center, who also commented on this at the start of the meeting. I do want to correct the minutes that were sent out that stated that I wasn't able to speak at the meeting. I did speak at the meeting. Indeed, my opening comments, I identified that I had been deliberately excluded from the listserv for the announcement of the meeting, and that I felt that it arise to a potential sunshine ordinance. So I've given you a lot of information. I'm going to conclude by saying that the meeting was selectively announced. There were people who were, in the listserv, and there were key people in the environmental health and justice issue, people who've been opposed to some of the shipyard development activities who were excluded. And furthermore, I talked with the doctor who was the presenter at the meeting, and he disclosed that the mayor's office had specifically asked that the scientists working at the community level, including myself, not be included in their discussion. So I have to presume that it was deliberate and that it's a violation of Section 6713 that prohibits barriers to attendance.
Thank you. Are there any persons or witnesses that provide any facts or evidence on behalf of the petitioner or the complainant? Seeing none, respondent, you have 5 minutes.
Good evening, honorable members of the Sunshine Task Force. I'm Hank Heckel, the compliance officer in the Office of the Mayor, here to respond to Dr. Sumchai's complaint. The Mayor's office takes very seriously our obligations under the Sunshine Ordinance and the Brown Act, including relevant open meeting provisions. When we first received the Dr. Sumchai's complaint to the task force, that was the first time that we were made aware of any concerns Dr. Sumchai had regarding the conduct of the Hunters Point Citizens Advisory Committee meetings, and we've been glad to assist Dr. Sumchai with any perceived issues with access to meetings and information. However, we submit that there's been no violation of the Sunshine Ordinance based on the claims in Dr. Sumchai's complaint. Just to give the bit of background, the Hunters Point Citizens Advisory Committee is an advisory committee that does community outreach and research concerning the redevelopment of the Hunters Point shipyard and the remediation of that land. I believe it was created in the 90s under the initiative of Mayor Agnos. Dr. Sumchai claims that she was excluded from a July 17th, 2019 Environmental and Reuse Subcommittee of the Citizens Advisory Committee, but the facts just don't bear out that there was any failure to comply with any notice requirements, nor was there any effort to deliberately exclude Dr. Sumchai from the meeting. As the facts show, the Citizens Advisory Committee notices their meetings on the website for the main committee and their subcommittees, and did so regarding the July 17th subcommittee meeting in question. There's evidence in the record that that was sent to the San Francisco Public Library more than 72 hours in advance, consistent with all applicable requirements. And so that any requirement there was fulfilled. Dr. Sumchai has raised an issue with an email listserv. There's no evidence that Dr. Sumchai was deliberately excluded from any such distribution list. In fact, the investigation that the Citizens Advisory Committee did of this issue shows, and that's in the record at page 644. Mr. Micah Fobbs is also here. He's from the administrators for the committee. They prepared a research memo to get to the bottom of the issues that Dr. Sumchai raised, and that was submitted on September 13th. It's in the file. It shows that after the subcommittee meeting took place on July 17th, Dr. Sumchai, in fact, attended, voiced her concerns that she was omitted from a list. Mr. Fobbs promptly, immediately contacted her right after the meeting to address those concerns. There's emails in his report that show that, and After looking into it, the conclusion was that Dr. Sumchai was never actually on any distribution list, contrary to her belief that she may have been. It's possible that she had been receiving notifications from other sources and assumed she was on the list, but the records of the committee showed that her contact information from sign-in sheets wasn't legible, so that could be the reason why she wasn't initially included on the distribution list when the issue was raised. They immediately went back and included her on distribution lists going forward, and she's been noticed on a going forward basis of meetings. The DCA's memo on these issues gets into the fact that there really isn't any requirement in the Sunshine Ordinance that she be included on a distribution list, but as a courtesy and consistent with the open meeting, the spirit of the open meeting laws and good practices, the committee does in fact include Dr. Sumchai on this list presently. She also has some complaints about the conduct of the meeting. There's no evidence she was prevented from speaking and offering her concerns to the committee. She invoked quorum requirements. There's no evidence that there was a quorum violation because no action items were taken up during the meeting. In any case, that's not really within the purview of the Sunshine Ordinance or the task force as per the DCA's memo. But anyway, we believe Dr. Sumchai's issues have been addressed, and we submit that there was no violation in the first place. Mr. Fobbs is here from the committee. If the task force has any questions for him on the the background, he's knowledgeable of these facts.
Very good. Thank you.
Thank you.
Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Go ahead.
Hello.
Start the clock.
Hello, members. I am Micah Fobbs. I put together this information and did the research. I'm also tasked with one of our primary tasks is to make sure our meetings are noticed and folks receive our information. I just wanted to say that when Dr. Sumchai informed of this, we immediately jumped on it and did what we could to rectify the situation. In doing the research, we found she was not on our list, and there was no reason for us to believe that she, wasn't on our list because she had attended probably 6 to 8 meetings within the time frame, within the past, I guess, probably 2 or 3 years. So there was no reason for us to assume that she was not on our list. But in actually doing the research and finding out she wasn't on our list, we immediately put her on the list. We modified our sign-in sheets to make sure that certain things are on there, like please print legibly, do you want to be added to our email list, etc. The other thing I wanted to say was that the information that she submitted as proof that she was on the email list is actually not proof. And if you look at the information that you have, the emails that she sent have been doctored. The individuals that received the information or that information was sent to, it says to, it's deleted in some instances, and in other instances, and there's actually, I think, only 1 or 2 documents, which if you look on page 15 of 19, at the bottom, circled in red, it says to. This is information she submitted that was supposedly proof that she was on our distribution list. And the only document that that was received was of the same meeting of March 13th, 2018, more than a year before this meeting. And within that, from that time period, again, up until the September meeting the July meeting she's referencing, she had attended probably up to 4 or 5 meetings. On 15, and then if you go to 16, this is also proof that was submitted. If you look on page 16 under the red circle.
What page numbers are you talking about?
It's supposed to be P
It's
something.
I'm sorry. Can you stop the clock for a minute?
Sorry.
I'm
sorry.
I just let him finish and then keep some notes and we can come back to it, okay?
Okay, and I just wanted
Go
to
ahead,
add this.
restart the clock. Thank you.
I'm sorry, I just wanted to add this last thing. On page 16, again, if you look at the information that was submitted as proof that she was on a distribution list, the to is completely gone from the information. So this information that she shows was as proof of her being on a distribution list was actually forwarded, it appears to be forwarded to her from somebody else, and in the process, information deleted. And again, the information doesn't show that it was received or sent directly to her.
Okay, thank you. Are there any other persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none. Folks, this begins on page 644. And then in the lower left-hand corner, it says 1 of 19, so on and so on. Okay. I have some just procedural questions at first. I didn't notice in our memorandum from legal counsel as to what the status is of this particular body. Is it a passive meeting body? Is it a policy body? There's no advice with regards to that. So I think we need to figure that out first as a part of discovery, and then we can determine what the appropriate meeting notices for posting of meeting notices is supposed to be, because it's different for policy bodies than it is for passive meeting bodies. So, I mean, we could try to figure that out here. The problem is as the respondent had suggested, is a possibility that this was created by a former mayor, this community advisory committee, a citizens advisory committee. But the question is was it created by the mayor for the mayor, or was it created by some ordinance? Was it created by some federal law? I mean, because this is a naval shipyard issue and a Superfund site. There's all kinds. Not quite sure of what the disposition is and the status of this particular committee. Even though it says Citizens Advisory Committee, it could essentially be a policy body, despite its title and name, by which the way it was created. So that, I think, before we can even, move forward on discovery, we need to figure that part out first. So we can tear it apart here if you want. And sorry to say, we could, and for the parties, the other way to do it is to continue the item and have further advice from our legal counsel, to do some research as to how this got created officially.
Sure. I'm trying to go back to the Dolores Park CAC. We deliberated on this very subject, and I think we came up with a decision.
It was a community benefits district, right?
Yeah, it was right before they became a proper CAC, and I think we determined, is there a line there? Once they become the CAC, do they fall under jurisdiction? I think we decided that because it wasn't a CAC, that was a dividing line, and we chose not to recognize it as jurisdiction, which implies that had it been a CAC, as this one is, then it would fall under our jurisdiction and then the detail eludes me, but it's in there. I think we chewed over this quite.
Let me clarify on that. That particular case, it was determined whether a body was created before the trigger for the community benefits district process was to begin. So the question was before us was that, body that was created prior to the process, was that under our jurisdiction or not? What happens after the process has been triggered would definitely be. Not quite the same thing. The difference with this is that the Hunters Point Shipyard is it has a big historical a story behind it, and it involves partially with the naval. It's a naval shipyard, and so the question is various things because of that status would determine how certain bodies, oversight bodies or citizens' bodies would be created. That's what we need to find out. Why? 67.3D7 under policy body shall mean any advisory board, commission, committee, or council created by a federal, state, or local grant whose members are appointed by such city officials, employees, or agents. There's that part. Then you have all the other parts for the policy body with regards to is it enumerated in the charter? Was it created by an ordinance or resolution of the Board of Supervisors? Was it created by the initiative of another policy body, some other commission? And then we need to know who the members are. Is it all employees? Is it, or is it members of the community too? So all those things, I think we can't move forward without having that knowledge. And the respondent didn't explain it. The petitioner didn't. Didn't explain it. And I'm read through as much as the case file as possible. I didn't see any background as to how it got created. I think to have something from our legal counsel that would be something that we can count on would be helpful for this case.
I'm happy to do that. However, I will note that under 67.6E requires notice of meetings for passive meeting bodies 72 hours before the time of the meeting, and under 67.7A requires posting within 72 hours for a policy body. And based on the record that I've seen, it seems like those time limits have been adhered to.
Okay, thank you.
Under either analysis.
Okay. Very good. That's very helpful. Okay. Any questions for any of the parties? Dr. Sumchai, do you? It looked like you were going to explain something around the history of this.
I certainly have to respond to any public comment made by a representative of the mayor's office that suggests that I doctored an email to make it appear as if in March of 2018 I had received an email from the HPSCAC administrator to Ahimsa Porter Sumchai, MD. I gave it to you, and it is a screenshot. I'm sorry about that, and that may be one of the reasons why it may appear vague. But I have been on their meeting notice listserv. I am a professional telemedicine physician. From 10 a.m. to 1 p.m. I'm online. I know how to get rid of emails. You just send an incoming email to spam or junk and it goes away, or you can block it. And I believe that after I submitted my application for membership and received confirmation of the membership to my email address from the administrator, that something may have occurred to the email at that time to delete it. Secondly, I do want to also just give you a executive summary regarding the environmental remediation of the Hunters Point Shipyard from July 2013 that gives you a sense of the immense power of this so-called passive body. This is an executive summary prepared by the Office of Community Investment and Infrastructure as a successor to the San Francisco Redevelopment Agency, with technical support from the San Francisco Department of Public Health. And the summary and attachments contained herein provide the Hunters Point Shipyard Citizens Advisory Committee, the Commission on Community Infrastructure and Investment in the Public with a comprehensive, accessible picture of the status of the environmental cleanup and transfer of the Navy property. It also defines the regulatory structure for the shipyard. And interestingly, although it directs this in executive summary to this body, this quote-unquote passive body, it doesn't in any way identify the passive body as being part of the regulatory structure. The Hunters Point Shipyard Restoration Advisory Board would have been under the regulatory structure had it not been dissolved. With regard to the noticing, yes, they do have some evidence that they noticed it. It was selectively noticed. There were people who didn't receive the notice, people who had attended meetings who would have been on the listserv, attorneys. Again, this is live stream documented. It was not noticed on the SF.gov site, and that's where the Sunshine Ordinance says it should be noticed. So again, I must dispel this nonsense that they are basing their position on, that I was never on the listserv, and I just have to give this to you if you don't have a copy of it. And I will not tolerate anyone in a public setting suggesting that I altered a document to make it look as if I had gotten an email from them from their listserv. Thank you very much. Let me also give you that. Again, it concisely documents.
So I just wanted to go back to something that the DCA put on his memo. I don't think passive meeting bodies or policy bodies are required to email to participants notice of meetings. So I think we can dispel the listserv question. I don't think that really is under our purview. However, noticing on SF.gov or the library is what we should be focusing on, and anything relevant to that is probably where we should be looking right now.
Anything else? I'm just hold on one second. I just want to, from me, I find it very difficult from our experience here to go on no facts of how these bodies get created. We end up either going down some kind of rabbit hole, or we end up making a mistake. And I really would like to know how this committee got created, when it got created, who created it, so we know exactly what it is and how it's supposed to operate. I think that's really important for us at bare minimum for discovery of the facts, because it then will guide us as to what sections of the ordinance are applicable, despite what legal counsel had notated for the correct timeline for posting, which is 72 hours in advance for either one. So that's a question that could be asked, whether that was done. Legal counsel had confirmed that it was done in more time than the 72-hour period. There are three issues that Dr. Sumchai brings up. She talks about being omitted from the listserv. So that's an issue we need to cover. The second is that the chair engaged in an uncivil and verbal abusive conduct, quote unquote. And third, that there was no quorum at the meeting. And that third one goes back to whether it's a passive meeting body or whether it's a policy body, because the determination of quorum and its ability to take, the decisions whether it makes, whether they're substantive and of legal standing or not, is a factor here also. Okay, yeah, Mr. Heckel. I mean, are you going to rebut what she's saying?
Yeah, I just wanted to address specifically the the question of how you would classify the body and sort of the impact on the handling of this matter. So our view is that no matter how you slice it, so whether it's a policy body, a passive meeting body, or neither, the strictest requirements were in fact followed, as the DCA noted. The 72-hour agenda posting requirement was satisfied, and I'd refer the task force to the report that was prepared by the advisory committee, starting on page 6.
But that's not in dispute with regards to the complaint that's been brought forward to us. The dispute is that she didn't know about the meeting because she was omitted from the listserv. And we have to then take up that issue as to whether noticing through the listserv is a requirement or part of that. That's a question before us that we're going to explore.
Right. I mean, I think related to, I was just going to reference page 651 in the packet, shows the agenda notice, but going to the listserv question, I think the DCA also said in his memo that there's no requirement anywhere in the Sunshine Ordinance and Member Highland mentioned this too, to provide a listserv notification. So I think the question of, even if you assumed it's a policy body, under the strictest requirements, there's no violation because there's no requirement to do that. But despite all of that, there was an effort to include her on the actual distribution list. So I just don't think there's any other open issues that need to be adjudicated. Similarly, the quorum issue, the evidence shows that there was no action items taken up in this meeting, and that, in fact, a quorum was formed about a half an hour into the minutes of the meeting. That's also in the record prepared by Mr. Fobbs on page 648. So I would just refer the task force to that section.
And just to be sure, this is July 17th special environmental meeting at 6:30 p.m. I see it on the calendar. I am having trouble pulling up any minutes for it.
That's right.
I'm sorry, what meeting was that?
I'm on their website.
Yeah, but what meeting are you referring to? Is this the meeting that is being cited?
Yes.
Okay. I thought you said something else. Okay. Nonetheless, it is when a body is brought to us without any background information as to what it is, how it got created, and what rules apply to it, it's incumbent upon us to find that out, just as part of discovery. So it provides a foundation for us to move forward on. So I'm not. Your points are duly noted.
Okay.
I appreciate that.
Okay. Thank you.
All right, members.
Should this go back to committee and let them find out what we're dealing with first, and then come back here?
It's
one possibility.
whatever you guys think. I mean, at this point, if you think there are items in here that you want that we can work through first, there's that, and then and then we can decide what to do thereafter. This is the first time that's being heard through regular process. There's no, it'd just be referred to committee if need be, but we're in the regular process here.
Yeah.
So again, there are three items. One is the listserv item. The second is conduct in the meeting, and third was quorum.
Well, I think the quorum issue is probably the most interesting to me. And I'm trying to find minutes to see, was there a roll call? Was there a quorum? And perhaps.
Well, you said that the minutes are in the file.
No, I don't see them.
Mr. Heckel, or Mr. Fobb, do you know what page that's on?
The meeting minutes are not listed in the information that you received. That wasn't a request.
Are they
But
online?
They are online on the
Okay.
website. If you go to calendar, to the calendar section of the website, and there's a little plus sign. If it's on your cell phone, if it's on a computer, it might be a little bit larger.
Minutes.
Hit that. It takes you to agendas and minutes.
Okay.
And you go down to environmental reuse, 717.
Gotcha.
The minutes are right there.
Got it. There it is. Okay.
We would never request any information until after this process. So whatever
I'm sorry,
you
requested-
folks provide as far as of your evidence,
Yeah, so
that's
meant
why we're
requested-
asking.
And I'm not requested by you, but by our office.
I see. Got it.
From the mayor's office.
Okay.
And while I'm up here, if I may, I mean, I just don't want to make it appear as though I accused anybody of anything. That's not what I said. From Dr. Ahimsa Porter, I simply said the information that she submitted appeared to be missing information that would be on any email that anybody would send. There's a subject, a to, and a from. If the to information is not there, and you can look on just about any unaltered email, it's there. To, from, subject, all three. On the information that was submitted, that I received from Dr. Asumshai and from the mayor's office, it's the same information, and the information is missing those lines and that information. So that's all I was saying. I'm not assuming that anybody altered anything other than stating that what I see and what I noticed.
Hey, Mr. Fobb, I'm going to be a little direct with you.
Yes.
Was there a meeting on July 17th, 2019?
Yes, there was.
Looking on the Hunter Point Shipyard Citizens Advisory Committee under the full committee meetings info, looking under the agenda, 2019 agendas. Can I just continue?
Sure.
Thank you. There is no listing for July 17th.
There is.
I'm looking at the same thing. It says
July 17th is under the Environmental and Reuses Subcommittee meeting.
I was trying to show you this title here. You have to keep going down. It's not very well laid out, but it is
So
there.
I'm a little confused. Are we
So there's-
talking about a subcommittee of this larger body?
Yes.
Okay. That's not been evident in a lot of these. Okay. I'm reading, from our memorandums and I hear you.
Yeah, the actual notice, I think, then,
Okay.
the information that I submitted shows the headline for the meeting. It says Special Environmental Reuse Subcommittee Meeting.
Okay.
That was the actual notification that was sent out.
July 17th, got it. Okay, thank you.
A quorum was established after roll call.
Yeah,
according
there's
to their-
no minutes posted.
They are posted.
Here.
I'm reading them.
Oh, I'm sorry, I picked the wrong section. 2019, right?
Yeah,
Okay.
717.
17, got it, okay. So this is a subcommittee of the main advisory committee. Okay. Still would need to know whether it's a policy body or not, because standing committees of policy bodies are also policy bodies.
Can I ask a question
Yes,
of you?
Member
So,
Tesfaye.
I mean, do you think that's like a question of fact or a question of law that we're trying to figure out? Because I think if it's a question of fact, that's something that should probably be determined in the complaint committee to make sure that we, if this is something that we should even be looking at.
Mm-hmm.
But, so that's my question. Where do you see this going?
Well,
as fact or?
the fact will determine the law. What
Right,
law
but first
applies.
you determine the fact. Then,
Right.
So where do you think we are? Do you think we're already at the law part, or we still need to figure out this
No, we
factual
still need
issues?
to figure out the facts.
Yeah, well, my recommendation would be, if we're still at that level of analysis, then that should be figured out at the complaint committee.
Okay.
And then they kind of figure out a package to make sure this is ready
Okay,
to come
so-
before us. But that's just I'm putting that out there.
So back to Member Highland's suggestion to send it back to committee, send it back, your suggestion was to send it back to complaint committee?
I think so.
Okay.
I think, and then determine this question of fact.
Okay.
And see if it merits even coming to us.
All right. Are there any other items in this complaint that we can deal with beyond the status of the committee? Assuming whether it's a passive meeting body or a policy body, are there any other items that we want to take up? Never testify.
I think that this second issue that we've, quorum, I think is one, and then the second issue about the verbal abuse, or I think if there are any facts that we want to make sure that we should address that now so that the committee knows exactly what they need to do, because I don't want it to come before us after they've done something and then us to send it back.
Right. So the second, I'm reading from our city attorney memorandum, and so I'll take any corrections from the petitioner, Dr. Sumchai Porter, on if this is not reading correctly. So the second complaint was against the CAC and its chair, Veronica Honeycutt, quote, has historically engaged in uncivil, verbal, abusive conduct, unquote. The complainant contends this violates open government laws.
Only if it bridges.
Does not support this contention with any legal authority, and our legal counsel was not aware of. So, Dr. Sumchai, can you provide any information as to why? Okay. Can you come to the microphone, please, so it's on the record and we can hear you?
State it in the microphone.
I'm sorry?
I need you to state into the microphone.
Yes. Yes, I provided you with YouTube footage from the July meeting in which, without a quorum, the acting chair threatened to shut the meeting down if the attendees didn't stop, quote unquote, asking questions and violating our protocols. And there was a exchange that occurred between members of the, the attendees. But I actually have that footage in my camera roll. And I can just let's
okay.
see.
Hold on a minute. I don't want you to play it just yet. I want to ask members of the complaint committee: did you guys review the video in the committee hearing?
I don't believe so. I don't think we did.
I saw references to it in here, but I didn't see any link. Did you provide us with a link to it?
I provided you with it is my YouTube channel, and I provided you with the link as well as the original YouTube video. In fact, you have it now. And I also referenced it when I responded to Mr. Heckel. I referenced the fact that there was the YouTube video, and that reference that you should have has the URL for the YouTube video.
Can you point to it on your in your submissions here? Do you know what page it's on? Because there's references to YouTube. I can do a search for YouTube.
Yeah, I did a search through, and I'm seeing the word YouTube, but no URLs.
No URL.
Okay, so in my
what page?
If you search youtu.be, that will come up. So it's on page, I can just give you the page number.
Is this 709?
Yes, 709.
709. That's in the respondents section, isn't it?
Well, I'm sending you.
It's on her email. It says it's July 19th, 2019, and it says it's from her email.
Yeah,
to,
but that's in the record submitted by the respondent. Well, just to notate that, because
With regard to the quorum issue, I would also have to challenge the statement that business was not.
Please speak into the microphone.
There were decisions made. There was a decision made about, the scheduling of the next meeting. There was a decision about, the process that these scientists were being asked to develop with regard to, the soil standards. So in 2 hours, it's not believable to suggest that a meeting went on without a quorum and no business was conducted. That just was not the case. In addition to business being conducted in the meeting, after the meeting was adjourned, the acting chair asked the CAC members to meet with her for a meeting after the meeting. So I do have to take exception with that. I did send you the video. I have it. You have it, and when you look at the video, it will be clear to you that this is not the professionalism in conduct or civility that you expect for the chair of a meeting that is being attended by community leaders, academic scientists, and attorneys. There were numerous attorneys, attending this meeting, and again, at least 2 of them identified that they had not been noticed, for the meeting.
So Dr. Sumchai Porter, I'm not sure that our body has jurisdiction to address conduct.
Mm-hmm.
Even decorum, it's not part of the Sunshine Ordinance per se. That's usually handled by the Ethics Commission. Thank you.
So,
yeah, the video. So the video is not in the petitioner's portion of submitted information. It's contained in the respondents section on page 709. So with regards to the second. With regards to we can't take up the issue of quorum unless we know what this body is first. Because if it's a passive meeting body and this is a subcommittee of the passive meeting body, there may not be any requirement for quorum. Yeah, member, Vice Chair Josh Wolf, who arrived at 6:24, I think.
That sounds about right. Sorry for the tardiness. It took 6 hours to get here. I obviously came late, but it seems like we have 2 issues. We have the email exclusion and the quorum.
And then the first, there are 3 issues, actually.
My question regarding the email exclusion is that there's both someone potentially being denied from an email list and also seeking those emails after being taken off. And I was curious if we heard previous testimony of whether there was an effort to obtain the emails after she was removed from the list.
I think the question before us with regards to that is whether there's whether a listserv is considered a requirement for noticing under the rules of Sunshine. And I don't think there's jurisdiction in under the ordinance or under the Brown Act with regards to a listserv per se versus being on a service list specifically to receive notices of meetings.
So the only issue pertaining to the listserv is the automated release of meetings and agendas, not other communication.
Correct.
Well, the part of the discovery here too is that the petitioner is claiming that she had been on the listserv, but the respondent's saying that she never had been, and that they just added her. And the petitioner is saying, well, I've received lots of notices through a listserv. Okay, that demands some, we haven't resolved that part yet.
But the listserv is just a tool for sending out notices. There isn't communication between members of it that we need to get.
We have no idea what that listserv
And
is.
you're making a distinction between a newsletter mailing list and a listserv where participants talk about things with each other.
Well, I'm trying to find out what the content that Dr. Sumchai, and in full disclosure, I did run for mayor against Dr. Sumchai like 8 years ago, so I do know her through that.
Will that bias your decision making? Okay, thank you.
But not at all. But I felt that it was important to disclose that. That if there is any information on there, whether it's communiques from the city or anything beyond a notice, then we're dealing with information that Dr. Sumchai hasn't received in the email communication in addition to being removed from it. And it seems like that's not the case in this example.
Well, I mean, so I think you'll need to ask some questions then to find out what the nature of this listserv is all about first. Who was it created by? What's its purpose? And then figure out if she was really on the listserv or not, and that comes with evidence. You know, she has emails showing that she's on that listserv. It comes from that listserv name, and then comparing that to the respondent's information. So, I mean, I think that you just have to kind of dive into the facts there with regards to that. As far as the quorum is concerned, maybe you didn't pick up on it. We're trying to figure out what this body is. Is it a passive meeting body or a policy body? What are the quorum requirements for each? This is also a subcommittee of the main Citizens Advisory Committee. So again, if the Citizens Advisory Committee is a policy body, then all its standing committees are policy bodies also. If it's a passive meeting body, then they're not.
Right. I definitely recognize the Brown Act areas. I'm just sort of trying to find out, and I guess through the chair asking Dr. Sumchai a question would be the easiest way to resolve that.
You don't have to, through me, just ask, sure.
So as I said, there's definitely some Brown Act issues that we need to unpack, and I'm trying to find out whether this listserv is actually a public record issue, of public records you haven't been given access to, or it's just a complaint about not being notified of city meetings and that sort of thing.
Well, the actual information that was a part of the meeting does include information about the identity of the scientists and their scope of practice, and that was relevant information to me. I ultimately received the email notification of the special meeting from someone else who thought that I should be, aware of it. But again, I've given you a copy, of an email from March of 2018 that clearly identifies the sender as being this organization's administration. I was who it was sent to. I responded and then they responded to my response. So you have an exchange. There are sometimes exchanges that people make, when they're on, the listserv. But in general, it tends to be, information, and the information is important. And I did also convey to you the sensitive information that the speaker at the meeting met with me and disclosed that the mayor's office had instructed he and the scientists not to talk to me and the other community scientists, including people who had complained about not being noticed. So again, my opinion is that there was a noticing of the meeting, but it was a selective noticing of the meeting to individuals who they wanted to have attend, and I felt as if I was deliberately excluded from the announcement of the meeting.
Do you know if the listserv is still active?
Well, I've been added to it.
You have been added back to it?
Yes.
Mr.
Which suggests that if my
Fogg,
email...
who's from that department manages the listserv. We can ask him.
Sure. Let me just finish with a couple questions. So you have been added to it. What was the process to be added to?
When I went to the meeting on July the 17th, I was a speaker during the public comment section, and in my opening comments, I identified that I felt strongly I had been deliberately omitted from the announcement listserv that goes out for these meetings. And the district supervisor was there, and I also identified that I felt that it might rise to being a sunshine violation. And so then the next day I received a notification to my email address saying that they were adding me to the email listserv. And again, I considered it proof that I had already been on the listserv, that they sent it out. So, my personal feeling is that my email address was sent to spam or junk, and that's how it disappeared. It couldn't have been blocked, or else they couldn't have added it back. Well, maybe it was unblocked, but I believe that there was a deliberate and an intentional effort to exclude me and other individuals from a very important process.
No, I'm sorry. A second ago you said may have been sent to spam or junk. Can you explain what you mean by that?
You can get rid of an email. If I want to get rid of someone who's sending me emails, I just direct the email to spam or junk, and that person is out of the system. You can search them usually and you can find them, or you can completely block the email so that it doesn't appear. But that is the only way technically, and I'm not a techno peasant. This is profession for me. I work telemedicine, and I know how to troubleshoot these systems, software and hardware, and that is the only explanation that I can come up with for how I could have been on a listserv, how I could have gotten an email from the administrator acknowledging my application to the organization in early July, and then all of a sudden I'm not in the system with the the listserv that was sent out announcing the July 17th meeting.
I have a question.
Hold on. Member Highland had his hand up first.
I just wanted to point out that before you came in, we were discussing sending this back to complaints to get the answers to some of the apples and oranges, which I don't think we have to really keep going down discussing these three items. One was to determine, get some input from our DCA as to whether this is a passive or an active policy body, because that would then lay out the standards of some of the other things that we're trying to pursue now. I was in the process of making a motion that I think Member Tesfaye was about to second, because we were in the fact-finding mission rather than law-finding part of it, and then we digressed. So what I want to ask the chair is, can I go ahead and make that motion? Do you want to hear rebuttals first?
Yeah, no, we have to hear rebuttals first. This is just fact-finding discovery evidence right now. After we hear rebuttals, then we can deliberate the facts and determine conclusions. Member LaHood.
Yes, Dr. Somchai, how many email addresses do you use?
I do have 4. 3 that are active. There's a Gmail and an iCloud. The Ahimsa Porter Somchai MD at Comcast.net is the only email address that I use for the shipyard medical health issues because I have an archive of information with that email address. And that is the email address that is documented in the screenshot that I gave you of the email exchange that occurred in March of 2018 from, the administrator and myself regarding the noticing of this exact same meeting. It was a Environment and Reuse Subcommittee meeting.
Okay, so it's your understanding that if you were previously on a list, it would have been with the same address?
Yes.
Okay, thank you.
And that was the address, of course, when they did restore me the next day and I got the email. It was to Ahimsa Portasum Cmd at Comcast.net.
I have a question for Mr. Fobb. Yeah, please come up. What is the address of that listserv?
The address
of the listserv?
info@hpscac.com.
That's an email address. Is that also the listserv?
The listserv, our listserv since 2016, we send all of our information out via Constant Contact to make sure that we have a digital record of everything that we send out and to whom and when.
So you're referring to that as the listserv?
Yes, so
that is our listserv. That is how we disseminate information.
It's not really
Right,
a
so
listserv per se.
Right. So
Yeah.
in our parlance and in general, our general knowledge, that's not a listserv. A listserv would allow back and forth conversation, or it would be, that's a mailing list.
That's a mailing list, yes.
Okay,
That's how we disseminate information. If I may,
Okay.
from what Dr. Asumshai had mentioned in the communications that she had directly with me and my staff, that is completely separate from any information that we send out to the community. And the community email, what she had sent over as proof is, I'm not going to go over that again, but would not have come from Constant Contact.
Now I have a question.
Right. Go ahead.
The information, direct information that she released. So she had requested to present at one of the meetings, and what we do in our office is to contact individuals, presenters from the city, public, whatever.
We got it.
To arrange them and provide them with information that they need and whatever, if they need a projector, whatever. That's the communications. We had no knowledge, again, that she was not on our distribution list simply because she had attended all of our meetings. And there's no reason. This is the first instance that she noted that she was not on our distribution list.
Well, why-
And we promptly added her.
So, Member Hinsey, I got you, but let me
Yeah.
just ask, just based upon what you're saying, why would she know about all the other meetings and not necessarily this one?
Well, as she mentioned in some of her emails, she receives information from other community folks.
Okay.
And if you, again, look at the information on page 16, you would see that this is not coming directly from from our listserv. It is coming, it's headed there, but if you look at to whom, there is no to. It should say her email address in that to, if that were the case.
Okay.
It's not there.
Okay, hold on a moment.
And if I
Hold
may,
on.
just real quick,
Okay.
I would say, and we did ask if she had any further emails that she would have received from Constant Contact, noticing the meetings. We had probably, I don't know, maybe 15 meetings in that time she would have received information from. And we had also disseminated other community information. So any, probably of 20 emails, she could have said, hey, look, I received this on this date from this time frame from when she said
But
she
not
was on the list.
other time. Got it.
Right. So
Okay.
that's, to me, it's like just kind of, and even then, if she was inadvertently omitted through our Constant Contact, there would still be a record. It doesn't. You can't delete a name or an email and then put it back on without having the previous record. And so, if you look in this information here that I sent, when I did a search for her email, there was no record, other than what we had sent out that after adding her.
Okay, thank you. Member Hinsey.
I'm curious now that you told us you use Constant Contact. How many distribution lists or so like subgroups do you have in your Constant Contact list? Or
Zero.
Is it all? Is it so? It's all one.
Just one
list.
yes.
Okay.
One list.
And they get all the meeting notices, regardless of what subcommittee they're on, or
Yes.
Okay.
Yes. One list, one distribution, dissemination.
Okay.
I mean, we sent one out today, noticing the cancellations for the meeting of December.
Vice Chair Joshua.
Were you mentioned that the department migrated to Constant Contact in 2016. Were you with the department at the time?
Yes, and I might not say department, but yes, our office.
With the office, I apologize. Where was the list? Where did the list that was inputted into Constant Contact when you made that change come from?
That came from an email list.
And do
From
you
an old email?
Do you happen to have the ability to look at that old email list to see whether Dr. Sumchai was on it?
Not at this point, no. That was, quite some time ago.
Is there any possibility that names that had been on that email list did not get carried over to the Constant Contact database?
No, no. That whole list, that whole entire email list was simply just copied and pasted.
Right.
Well, let me follow up with that for a second. I'm looking on what you would be seeing is page 2 of 19 would be, bless you, our page 645. At the bottom, it's under date July 18th, 2019. The following day, we double-checked both lists and verified she was not on either list. Then we checked in all the sign-in sheets for the past year to see if she ever provided her information.
Mm-hmm.
We found one instance in September of 2018, but however, the information was illegible.
Yes.
Okay. Yeah, so based upon Vice Chair Wolf's question, you don't have any way of going back in time.
Well, and the other thing is, to my knowledge, individuals who request to receive information under the guides of the Sunshine Ordinance need to do so every year. That's one of the reasons I checked back to see, just a year. I mean, I could check back probably 5 years, but I could be wrong, but that was my interpretation, that individuals must request to receive information on an annual basis.
That's an interesting question.
And I did just want to say is I've been doing this for 15 years, and this is what I take pride in doing. This is a community organization, and just to answer some of your questions, I have a photo of a newspaper clipping with Art Agnos and all of the individuals who he appointed to the CAC hanging in my office at the shipyard.
So if you have some knowledge of the history, can you tell us how this body was created?
That's all I have. That's what I can tell you is that I think it was, there's a date, I think it's dated, and it says 1993, Art Agnos appointed, I think 31 members to the Mayor's Hunter's Point Shipyard Citizens Advisory Committee. I've, again, been doing it for 15 years, and that's our primary task, to make sure that the information, the agendas
I'm not,
are sent out.
We're not concerned about your process and whether or not you're following Sunshine or not. Again, it goes back to my original question when we opened this up is, what is this committee? Is it a passive meeting body or a policy body? Because certain things are applicable for one and not the other, and vice versa. And also, the question of a service list specifically for making notices available to the public when they sign up for receiving communications around meeting notices is different than general information. Okay?
Yes.
Like the Ethics Commission is a very interesting way to put it. They have a interested persons list, and that's independent of every other kind of communication that they send out,
right.
Because that interested persons list is specifically for their agendas and their minutes, and that's it. And so it's a very specific list, and that's what I think that's kind of what we're trying to ascertain here.
I see. I just wanted to say to that is that I believe that we have followed, whether it was passive or policy, followed the Sunshine Ordinance either way.
Well, the only thing we were able to ascertain today was that the agenda was posted properly, but that's not in the complaint. That's no contention in this particular complaint.
Well, I'm saying also with the other items, such as the quorum.
Well, we can't determine whether the quorum was correct or not, because, I mean, I'm looking at the minutes, and I'm seeing 1, 2, 3 people present,
And the subcommittee, the subcommittees, CAC,
How many members are there? How many?
A quorum is 3 members.
3 members for the subcommittee.
For any subcommittee, yes, and
Okay.
50%
Okay.
plus, or 50 plus 1 for the full CAC.
How many
And
members are on the
executive.
subcommittee?
I'm not sure. I'm not sure specifically on that. I think there's like 4 for the
1,
environmental
2,
use.
3, 4, 5, 6. I'm reading. I
You
have
see in
Ali
the-
Mixon, Servio Gomez, Deidria Smith.
Dedria Smith, yes.
Dedra Smith, Dr. Veronica Honeycutt,
Yes.
Doris Vincent, and Pastor Bell.
They were present. I don't know if were they listed as members.
Says other CAC members.
Yeah, they were present, but the last 2 were present, but the others were the members.
So there are three member subcommittee or a 5-member subcommittee?
So a quorum is 3.
That means there's more.
Any subcommittee.
But are there 3 members of the subcommittee, or are there more than 3
That
members?
particular subcommittee, I don't know. You, if you read in the minutes, if you're looking at the minutes, the first ones that say members, I believe.
It's
Dr. Honeycutt.
Dr. Honeycutt was excused.
Okay, so Ali Mixon, Dr. Honeycutt, I believe, asked her to chair that meeting in her stead. She's the vice chair.
Okay, so it sounds
she's
like there are
able
three,
to.
3 members. Okay. All right. Thank you.
You're welcome.
All right. What issues should we take up? What issues should we not? Do you want to send something back to the complaint committee to research? I'd be interested in finding out what this body is.
Well, if we're saying we're sending it to them, who's going to do the research between this meeting and that meeting?
When's the next complaint committee meeting?
December 17th. Well, no. Yes, December 17th. The agenda's been just reviewed by Chair Martin today.
Okay, but it's not been posted yet. Okay. Is that something that you would have time for in that meeting, Member Martin? But, hold on to that thought. Let's get through rebuttals so we can get towards the end of the process, and we can decide those things later. Is there anything else on collection of any facts, evidence, any other discovery? Microphone, please.
I just have one question. Maybe the other members can tell me. That if it's
Bless you.
whether there's notice of the meeting or not, whether they properly place the notice. I wasn't really. If they're both 72 hours, I'm like, well, what's the point? But under 67.6E, it says meetings of passive meeting bodies is specified in 67.6D4, which I don't think exists. Of this article shall be preceded by notice delivered personally or by mail, email, or facsimile as reasonably requested at least 72 hours before the time of such meeting to each person who has requested in writing notice of such meeting. Is there a 67.6D4? And 2, would signing up on a listserv constitute written request? Is it even applicable?
How it gets delivered is not necessarily pertinent. I mean, you can have a listserv that doesn't allow you to post anything on it. It's just broadcast only.
Right, that's fine.
Okay?
Yeah.
Or you can do what they're doing with Constant Contact, which is a distribution list.
Right.
Okay? You can, it's not coming. you can kind of create a document,
Right.
versus a listserv which just sends emails. I don't think that that's of any necessarily of any consequence. I think what's important here is what Mr. Fobbs brought up was, did the person request the information? If so, when, and were they on the list or not? I think that is the case. And I see you. But he's also making a contention that it needs to be kind of re-upped annually. I'm not aware of anything in the ordinance that requires annual subscription. I generally get calls from city staff asking me if I still want to be on the list. Once you're on the list, you're always on the list. So,
Yeah, my question is that section and subsection on point in what we're talking about?
I think it is.
Okay.
Yes.
And why is it referencing a 67.6 D4 that doesn't look like it exists? There's a 67.6D.
Oh.
There's not a 67.6
yeah,
D4.
I think that is that's a typo. Yeah, I think that's a typo. There was a kind of a weird adjustment in the ordinance, and it changed some of the formatting some years ago, and I don't think it got fixed on the web version. But I see what you're saying.
Okay. So that's where the passive versus policy matters. And if a listserv...
I think it meant to be 67. Oh, no, that wouldn't be right. 674, there's no D there. I don't know. I don't know. That's an interesting point. I don't know what that reference is to. Member LaHood.
So we are we currently considering the, I guess, mailing list as whether that's requesting information, and are we talking about that now, or are we going to talk about that down the line?
Well, I think the point of fact at this point, or is to determine if and when she was on that list, okay, which would demand some evidence of having received from a certain email address sometime in the past by the petitioner, and or a list from a previous iteration. According to the respondent, she's never been on the list. The question is, and then I think the other question: how many email accounts does she have?
Right. Well,
which one was there? Were any of those? Maybe that's a good question for both of you. And please come up when you need to answer. Please come up to the microphone. How many email have you checked? All of your email accounts?
Yes, I just explained that the IM supporter, Soonchai, MD at Comcast.net is the account that I use for environmental health, justice, medical issues, because there's an archive. That's why I have this information. I just move it into an archive. Let me also restate that in early July, I applied for membership to this organization, and certainly it should have been presumed that I was interested in being on a list for meeting announcements. I would expect that would be the presumption.
Not necessarily. Generally, it's a very active, specific request to be put on these lists. And, they usually will either have sign-up sheets, or you can go to a website and sign up on the website, or you make just a written request I just want to receive the meeting notices. And then however they go about doing that, the point is are you getting them, at that point? We've had some situations in the past where the ball's been dropped, that somebody didn't get added to the list, but there was an obvious request was made, that was presented to us. So
Okay,
there are
I've
things like that.
Yeah, I have signed in many times, and again, I'm not sure what the dispute is. I gave you the copy of that email. What is it that you don't
I guess
find credible about that? That shows the recipient, it shows the email came to me, the meeting announcement, they responded to my stating that I was coming to the meeting and I wanted to address some issues.
Well, Mr. Fobbs, let me ask you this question. With regards to info@hpscac.com, is that correct?
Correct.
Is that only used for Constant Contact, or is that used in general by office staff?
That's the general information. That's the general email used for the public, for our office.
For just communications?
For communications,
to the
yes.
public. And when you send out when you send out messages to the public using Constant Contact, what email address is it coming from, those messages?
It's coming from Constant Contact with a response on it, info@hpscac.
Okay.
So, and to answer your question, we searched for all of her emails on our distribution list.
And you couldn't find them?
And that's the...
Okay.
Exactly.
All right. So, Dr. Sumchai Porter, what's happening here that I think, and kind of help me out here, members, is that they have dual purposes use for this info@hpscac.com. Okay? One use is active back and forth emails to communicate with whoever, general public or what have you. And then the other use is as a standard static from on their distribution list through Constant Contact. So the only way to know the difference is Constant Contact places a watermark or a icon and a lot of information at the very bottom of the email. That would be kind of proof that it's coming from their distribution list versus them just sending you a standard email, like somebody sitting at their Microsoft Outlook or whatever, and is sending an email to you personally, directly, one-on-one. So that's the difference that we're looking at here. So despite this is what you're talking about here.
Yes.
Despite this looks like it's from an actual person, like somebody wrote this. Okay, it's not like something that got distributed to everybody in their universe through their distribution list. So that's what it looks like to me. Okay, so the fact that even though you got an email from info@ and people in their distribution also get emails from info@, the difference is whether it's coming from Constant Contact or not.
Yeah.
Okay, that's the difference here. So it's not, while it may seem obvious to you that, well, if it's coming from info@, then it must be on that list, they bifurcate it. They have two purposes for the use of that email address.
I've received email notices of the meetings in the past, and that's why I've known to attend. The argument
Do you have a copy of any of those?
I can go into archives, but again, I don't want to insult your intelligence, and I don't want you to insult mine. I wouldn't be coming to meetings without getting notices, just as a matter of, I'd be getting the meeting notices, and all of a sudden, it went away.
I also know that I use Constant Contact for a couple of listeners that I have to run for work, and I also know that if a person's if they're on the list and they don't open the emails that are sent through Constant Contact for a period of time, they get bumped off. Their email gets suspended and they get bumped off.
I mean, Constant Contact does that automatically?
Constant Contact bumps them off, yeah.
Well, that's an interesting point.
Yeah.
Would not be useful for complying with Sunshine.
So did you open your emails when you got them through Constant Contact? Okay.
Of course.
Yeah, I think that it's not so much about the listserv or the distribution. The question is did you sign up for notices and did you get one? That's really kind of what this is coming down to, right?
So, and if we come down to that, and on page 645, where you obviously signed up for it, however, I agree that the email address as written here is I would say I can't be read. However, your name is very clear, and if someone within the agency saw this and saw that you wanted to sign up for it, obviously they'd had other communication with you. They would be able to find your correct email address and add you to the list, unless it was done by an intern or someone who didn't know who you were. And I don't know. I mean, because I've dealt with this issue, and I will even Google to find the correct address if I'm pretty sure I know who the person is, even though the email address is not legible. But I don't know. Maybe that's too far afield for this.
When you signed in, did you provide like your phone number also? So could they have like called you to find out?
They had called me. I gave a PowerPoint presentation to this group in January, and I was in communication with them via email. And again, I received the email confirming receipt of the application, that you have. So, okay, well, I understand the dilemma. The complaint committee identified that the organization adhered to the Sunshine, ordinance and used that as a sign that it had jurisdiction. Obviously, if they are following, Sunshine Ordinance policy, then that's an indication. I think that they fulfill criteria for a passive body, but they are acting as a policy body. These are some big decisions that people are making, with regard to the development at the shipyard.
Okay, thank you. All right, I'd like to move to rebuttals sometime soon.
Yeah, that's just real quick. Not a question for them, more for the task force. I guess I'm just a little lost. I know we've gone a lot back and forth about this email list. What portion of the Sunshine Ordinance are we talking about? Because getting back to the beginning of all this, the DCA memo says, regardless, the issue of the listserv does not appear to be a matter within the province of the task force. So
the question here is, I think that we've disseminated, is that she wasn't receiving meeting notices. And it was her contention that she got bumped off of a quote-unquote listserv. It's a email distribution list. Or it could have been snail mailed, or it could have been a phone call, or whatever. However, she had requested to get those. And the question now is, was she on the list? Not on the list?
I'm just trying to relate that to which provision of the Sunshine Ordinance are we looking at?
So I think Member Martin brought it up. It was 67.6E.
Okay.
Well, it's tricky because it's a sign-in sheet. It doesn't say send me emails, but it asks for an email.
Well, why don't you ask the respondent if that's what they use?
Sure.
So, how do they get people? How do they collect information to put on these distribution lists?
I mean, it's a good question. There's a sign-in sheet, and you ask for all this information. I mean, is that how you compile the close contact list?
That is one way we compile the distribution list, yes. And again, since this incident, we've revised our sign-in sheet to make it clear to ask individuals if they'd like to receive or to be added to our distribution list.
Okay, and just because I know we ask questions a lot of times you probably don't expect us to be asking, but as far as when you came in here today, you said, listen, we put it at the library, we had it on our website, we met the requirement, right, for noticing this meeting.
Mm-hmm.
Is that?
Yes.
That's your position, right?
Yes.
And as far as you're concerned, you had a quorum, and if there's behavioral issues with the way the members acted towards this, that isn't for here. Is that also your position?
Yes.
Okay.
And I would just note for you, Member Martin, that in your reference to 67.6E, meeting notices, people know where to go to see where they're supposed to be posted. They can call the office, say, hey, where's it being posted? clerk's office, outside the clerk's office, in the library, or on the website, for the general person that's, just researching. But if you specifically want to know when each and every meeting is, as you noted in here, it needs to be requested.
No, right.
So
I think
that's the other
I think that's
point.
the wrinkle. I think for people who don't care or don't generally, I shouldn't say don't care, generally don't follow this regularly but might be interested once in a while, the library and website that's what that's for. But if someone's specifically requesting information and the sign-up sheet's a little ambiguous, which doesn't help, at that point it was anyway. But I think that's the struggle for us.
And we've never had any issue like this, since I've been there, and it's been 15 years, because I really truly believe we try to do our due diligence in making sure all community members, especially individuals who are frequent members of the meetings, receive the information. And again, had we known that she was not on our list, I spoke with her, during that time frame. I was the one who responded to her emails. And like you see the info then there's emails that she has directly from me.
No, I get it. I think the easiest thing would be if she was able to produce emails from the thing before the issue. That's
and
makes it
we've
pretty
been
clear.
using Constant Contact since 2016, specifically
Right,
to make
and this
sure we have
sign-up
a
sheet,
digital
it's like a
record.
it's like a perfect storm hypothetical for sunshine compliance because you can't really read the email.
Yeah, and
how do you input it?
and
do you follow up and call the person, or just research and then add her? It's tough. Okay, but I think this might be the issue that it kind of hinges on, and it's unfortunate. But
And I do want to say that my assistant always follows up if there's illegible, to try to, and she didn't think to come to me and say, hey, she was new at that time. She didn't think to come to me and say, hey, who is this person? Do you have another email for her, another phone number for her?
Okay.
Because she was
That's all right.
at the previous meeting.
All right. Thank you very much.
Okay. Ready for rebuttals? Okay. Mr. Heckel, you're up first. 3 minutes for rebuttals.
Thank you. So let's just recap the facts and the issues here. So the first issue is this email distribution list. So there's a number of problems with this. Number one, there's no requirement anywhere in the Sunshine Ordinance that you have to generally be included on an email distribution list for a policy, passive, or otherwise meeting body, and that's stated in the DCA's memo on page 50 in the record. But even assuming there was some requirement, we just don't have any evidence that was breached. And going to this issue of whether Dr. Somchai made a request, just to clarify something in the record, the sign-in sheet at page 645 is a sign-in sheet for the meetings. It's not a sign-in sheet to ask to be included on a distribution list. And if you look at page 648 in Mr. Fobbs' submission, he points out this distinction in the third paragraph. He said, after this issue was raised, going forward, we are taking measures to avoid any discrepancies by revising our sign-in sheet to include a checkbox for those who would like to be added to the distribution list. So prior to that, it wasn't really a question of, I'm signing this piece of paper that says I want to be on the distribution list. It was just noting that you attended the meeting. And if you look at that sign-in sheet, unfortunately, Dr. Somchai's email address is illegible. The phone number is pretty hard to decipher as well. So I don't think that advances the ball that there was any violation here. So I would strongly recommend that the task force rule on this issue rather than continue it and find that there was no violation, because as I've noted, the classification of what the Hunters Point CAC is not germane to this distribution list issue. It's also does not it's not determinative on the quorum issue either, as the DCA pointed out on page 50. Third paragraph in the background, complainant contends that actions were taken at the July 17 meeting when there was no quorum. Respondents contend that no action was taken during the meeting when there was a lack of a quorum, that the meeting was purely informational at that time, and that action was taken only after a quorum was established. But importantly, it's noted, regardless, this issue does not appear to fall within the jurisdiction of the task force. There's nothing in the Sunshine Ordinance that determines what type of quorum requirements exist in this type of advisory committee, be it a policy body, a passive body, or neither. And finally, the conduct issue, there's no evidence in the record of any misconduct. The DCA points out also there's no legal authority that the task force should make a determination as to whether any of the conduct was inappropriate. So with that, I would thank the task force for its time and working late into the evening and close. Thanks.
Thank you. Dr. Sumchai Porter, you have 3 minutes rebuttal.
As I stated in my introduction, I have been involved in the shipyard remediation issues for about 23 years, and I am easy to search. If you search the Hunters Point Shipyard, you frequently will get URLs that I am identified with. I'm the Health and Environmental Science Editor of the SF Bayview newspaper. I edited the gantry crane section of the Hunters Point Shipyard on Wikipedia. And I am a member of the Medical Alumni Association of the University of California, San Francisco Board of Directors. And Dr. John Balms on August the 30th of 2019 told me in a meeting that he had been instructed, he and the chancellor and 3 other scientists who are all white males were instructed not to communicate with me, not to talk with me, and to other scientists who are involved in remediation of the shipyard. And simultaneous with this disclosure, I was not included on a informational announcement regarding a meeting, and in the past I had received these informational announcements. I believe that this is a violation, a basic violation of the Sunshine Ordinance 67-13. Barriers to attendance are prohibited. There were other individuals at the meeting who identified that they didn't feel as if the meeting had been properly noticed, and I feel very, very strongly that there were efforts to exclude me from this process, and whether or not it's within your jurisdiction, in your heart and in your mind, you know when things are factually based, and there's too much going on here for me not to accept that this not only violates open government laws, it violates potentially constitutionally protected freedom of the press, freedom of the speech. I believe it's an abuse of power, and I believe it's an abuse of scientific integrity. Thank you very, very much for your consideration.
Thank you. Okay, members, some interesting points, new points that have been brought up here, I think. I'll go backwards. Based upon what the petitioner is putting forward in citing 6713, we have limitations based upon what we would like and what we're allowed. 6713, with regards to barriers to attendance, is specifically and is repeated many times regarding policy bodies, boards, and commissions. This goes back to where my first question is, what is this CAC? Is it a policy body or something else? So it's going to be hard to make that determination based upon the assertion from the petitioner for us to find a violation of 6713, even just to even consider it. Because we don't know what the CAC's true status is. It hasn't been presented here. The other point, if I can remember what it was, that Mr. Heckel brought up.
So that it doesn't, that quorum is not an issue
Oh,
that
right,
falls under
the
sunshine.
quorum. So, with regards to that, he's reading from the background area of the of what our legal counsel has put forward. It's not an opinion per se, but what it says was that there was the contention from the complainant, from the petitioner, is that actions were taken when there was no quorum. And then the states that the respondents contend that no action was taken during the meeting when there was a lack of quorum. Okay? That the meeting was purely informational at that particular time, and action was taken only after a quorum was established. Okay? The contention of the respondent is that the ordinance and or the Brown Act doesn't specify what quorum is, except that the ordinance does talk about that you can't take action on items like that are not on the agenda, so on and so forth. But I think it's general parlance that you can't have a meeting to take action unless you have quorum anyway. I think it's implied, whether it's the Brown Act or some other rules of order. In fact, the city defaults to Robert's Rules of Order, and Robert's Rules of Order will always say you cannot take action on items unless you have a quorum. In fact, the question then becomes, is the petitioner right or is the respondent right? The petitioner claims that they took action when there was a lack of quorum. The respondent says there was no action taken when there was a lack of quorum, but when they did achieve quorum, that's when they did take action. I guess when you look at the minutes of that subcommittee, all it says is that a quorum was established after roll call. Called the meeting to order at 6:39 p.m., but then it doesn't specify at what time roll call was taken. And what was discussed, there's no reference to what was discussed prior to that. So I don't know. That's a little kind of uncertain what's going on there. The second part of the complaint with regards to conduct, definitely not in our jurisdiction. That's something that needs to be taken up with a different body. So that's my collection of thoughts on this. Yeah. Member Highland.
So my initial instinct was to kind of send this back to complaints to kind of dissect it, but I think we've pretty much done that here. So I'm not going down that road anymore. And just very succinctly, very quickly, I see no violations here in either of those three areas. I don't think the listserv is a required way to notice meetings, whether it's passive or policy bodies. I'm accepting their evidence that it was noticed correctly. As far as as Chair Wolf stated, as far as the nature of the discussions, whether it was, I forget the exact language used, I guess the type of language that the chair used or whatnot, again, that's not under our jurisprudence. Thirdly, I'm looking at their online noticing of their agendas. This Special Environmental and Reuse Subcommittee has 4 members. It's listed here clearly. Dr. Honeycutt, Ollie Mixon, Servio Gomez, Deidria Smith. In their minutes, which start at 6:39, they have called to order at 6:39. The next thing is roll call, just like we have. Present are 3 of those 4 members. That's enough to constitute a quorum. Dr. Honeycutt was excused. It's possible the petitioner thought that because all 4 weren't there, that there wasn't a quorum, but according to their... Please don't interrupt. Thank you. That's one possible explanation. Again, on paper, I think I'm convinced with what I'm seeing here. I don't see an issue with quorum. So on those 3 counts, I see no violations. I also don't see a reason to send this back to subcommittee. We can probably still hear from DCA about what he thinks this is, but as Mr.
Hobbs?
No, not Mr. Hobbs. Mr.
Heckel?
Give me a second. Mr. Heckel said, I just don't see any violations here. I think it's pretty black and white to me. Thank you.
Anybody else? I have a clarifying question for Mr. Fobbs. In the minutes of July 17th, first of all, who takes the minutes?
One of my staff.
Okay. Under call to order, it says Ali Mixon called the executive subcommittee meeting to order. How is that different? And then this is a special environmental reuse subcommittee.
I do apologize. That was an error. That's an error. It should say environmental reuse, not executive.
But the word special, is that because it was not on your regular calendar?
It was not the regular meeting day of the subcommittee.
Okay. And, okay, that was just I was just noticing because if you were having executive session or something like that, or it was called, for some reason, it was a different meeting.
Well, and with that, if you look I'm sorry I put it up here, but I noted in my information the timestamp of the Facebook video when a quorum was established. And it literally, if you watch the video, it shows Dedria Smith, the last person coming in. But the action items were not taken immediately. They waited until, because this was a quote on very, very important meeting, and information from these particular individuals people wanted to hear it. So they waited till the end of the meeting to take on the action items, and that was simply approval of the agenda and approval of the previous meeting minutes.
So there's no other action taken?
Those are the only action items. And I just might add, the main focus of the CAC is to get community involvement on the project. Mm-hmm. And basically that's what these meetings are about, for the public to come in and voice their opinion on designs, on whatever it is.
Mm-hmm. Thank you.
The shipyard.
All right. I'm still curious about the nature of the status of this committee. I think anytime it's not explained either through our own staff or by any of the parties, and it's not clear even on their website how it was formed. Actually did a search through every city code and the charter, and there's no mention of this particular body. It just becomes curious to me what exactly it is and how it got created, and then what its responsibilities are, despite the complaints that are put forward about it. I think it's just prudent for us to know what kind of animal we're dealing with here, for sake of a better word. So that's my thought on that. I'm open to suggestions. Otherwise, how shall we work this through?
From what I've heard so far, I mean, I think it'd be an interesting thing to know. I don't know if it's something that's necessary for what's in front of us. Somewhat along what Member Highland said, the quorum issue, I don't really think there's a violation there. The behavior, unfortunately, however reprehensible, isn't something we can deal with if it was. And the email, it's an interesting question. I can't divine intent. It's a sign-up sheet. It's tough. I just can't see a clear violation there either. People show, anyway, that's my cursory rundown, but that's where I am currently.
I guess I'm kind of in the same place as well. I think it would be interesting to know the origin of this committee. I think I'm kind of where Member Highland and Member Martin are, that I'm not sure it necessarily changes whether or not there are violations. That's my thoughts.
Anybody else? Member Hood?
The only other thing is I would recommend that as far as the second issue with threatening language, if you feel as though that's something that you want to pursue, that I think it needs to be taken to ethics, because we can't really do anything about that here.
Anybody else? All right, so my only, I think as far as the question as to what the status is of this committee and its subcommittees, I think that's something that we can ask our legal counsel to do a little research and, find that out, at least guide us to where we might find that information. Because it may require a deep dive. I'd just like doing that myself. I might try to figure it out myself. With regards to the second and the third items in the complaint, I'm in agreement. The first one, I'm still a little on the fence for, because in the record, neither party has presented a sample of having received a notice that is in contention here, a meeting notice. We don't have one from the petitioner, and we don't have a sample of what the one would look like from the respondent. So even though they say they use constant contact, no idea what it looks like. Okay, and I take people at their word. It's not at that issue, but at the same time, we have this process to have kind of documented facts. So I'm on the fence about that, but considering I don't have any information from either party, I have nothing else to go on. Yeah.
Just to kind of speak, I guess where I'm coming from on that is I guess the only type of violation, I talked about this earlier, that there could possibly be related to not being on an email list would be the one that Member Martin brought up earlier.
Right.
But then at that point, even if there was proof that she possibly was on it and at some point inadvertently got dropped off, part of that says it says as reasonably requested, it says in writing. So we would need something, I think, to show that there was a request, and I don't think that sign-in sheet is clear enough to say I am requesting to be on a list.
Yeah, that's my point
right.
too. That's
right.
just not clear enough.
But the petitioner intimated that she had been getting these for a long. She's very well known about. She's been here in the Sunshine Task Force on many of these particular kind of issues, and so I mean she's pretty well known for these meetings. So the fact that she did know that about them before, I'm saying is I have no evidence from her to show that she had been getting it through this distribution list, or never take the distribution list out, that she has been getting regular mailings about meeting notices. I would have liked to see some examples of that to show age, because the respondent's testimony was that you have to re-up every year. And there's no requirement that I'm aware of that you have to re-up every year. And even if you try to do a balancing test between the Sunshine Ordinance and the Brown Act or the California Public Records Act, the ordinance, if it provides more access, greater access, then that's what stands. That's the purpose of the ordinance, of this enhancement of state law. So that's kind of where I stand with that. I don't have any information from either side, enough information from either side to make a determination on that. So do we have a motion?
I'll make a motion to find no violation, or how do we do it these days? Is that how we're phrasing it? Okay. To find no violation for any of the 3 allegations in file number, oops, wrong one, 19077.
Okay, moved by Member Martin. Is there a second?
Second.
Second by Member Highland. Any other comment? I'm sorry, Member LaHood. You
Yeah, no,
wanted to
I
speak
have
after.
concerns because I think we've determined that we don't have jurisdiction on the second issue, so we shouldn't not find a violation. I mean, we should.
Oh, is the wording? Okay.
Yeah.
All right.
I
You
mean,
can
we should
amend.
disregard that.
Correct. The first
and the third.
Yeah.
Seconder accepts.
So we've determined that we don't have jurisdiction over the second violation, and we're finding no violation for the first and third complaint. Right?
It's either this. It might be the second and the.
The second is the conduct issue.
Okay, then correct.
Okay. If I may add, I'd like to also have our legal counsel take a look into the status of this committee for our edification for future. You know, it also helps with determining other similar type of bodies that we have an example to go by. Is that acceptable to the
Yes.
makers in the
Acceptable.
second?
Yes.
Okay, great. Okay.
I'm just
Anything
going to say, I want to say one other thing. I actually agree with you that we don't have evidence because we don't have copies of what these newsletter mailings looked like. So it is difficult to compare whether what was received was one of those or other information about these meetings. Since we don't have that, I think I sort of agree that it would be difficult to find a violation. But I don't know if we feel a degree of responsibility where we want to request that this be provided so that we can be certain, or do we just want to move forward based on the information we have in front of us today?
I mean, we're not a full-blown court, you know, where you can file an appeal. Well, let's put it this way: we do have an appeals process. Within a certain period of time, the petitioner can request a reconsideration. Okay.
And present additional information
if the information is compelling enough, which we have to first make a decision on that before then scheduling for the reconsideration. So there's a process for that. More so would be the original request for receiving these notices. If you had the original request to request those notices from years back, that would be proof enough also. You know, there's that also. Okay, anything else? Okay, let's have public comment on this motion. anonymous on the phone. Go ahead.
Yes. So, as usual, this is directed solely at the task force and is not in any way legal advice to the complainant. I strongly disagree with dismissing this complaint because I believe you need DCA advice on whether Administrative Code 67.6E puts this listserv issue within your jurisdiction, depending on whether this is a passive meeting body. If she has ever asked for email notice at least 3 days before the meeting, she should never have been removed from that notice. And the annual re-up thing is not anywhere in the ordinance. Now, ironically, the metadata can prove this case on record page 659. If you get if that was presented to you, the headers of that email would show you whether that came from a particular listserv and whether it went to the complainant. And that's something you could ask for discovery. Depending on how Constant Contact works, it should keep a log of all additions and removals of a particular person, and that could be requested as a public record, the audit log of all of those issues. Regarding the potential doctoring of emails, I'm taking no position on that, but it is possible that a to-header will not show up if certain applications, if you only used BCC and there was no to. So that's possible. It doesn't necessarily mean that it was doctored. And I also see that there, for some reason, private person's email address is disclosed by the respondent on those lists of constant contact. Regarding the civil speech issue, uncivil speech, I agree that's not within your jurisdiction. But if the acting chair threatened official action of terminating the meeting as alleged by the respondent, that could be a Brown Act violation and potentially a constitutional violation if it's dependent on the content of the speech and not the time, manner, and place of the speech. And finally, I do believe quorum issues are within your jurisdiction under Government Code 54952 through 54953 of the Brown Act, and incorporated within your jurisdiction by 67.30C. The burden of proof should be on the government, not on the complainant. I urge you to please continue this case and investigate these things and perform further discovery. Thank you very much.
Is there any other public comment? Members? Is there anything compelling that moves you? Nope. Are you ready for a vote? Okay. Call the roll.
Member Martin?
Aye.
Member Highland?
Aye.
Member Highland, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair Wolf?
No.
Six members. Motion passes.
Motion passes. Okay, motion passes. All right, let's call the next item.
Item number 8, file number 19079, complaint filed by Thomas Piccarello against the Department of Homelessness and Supportive Housing for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely manner.
If the task force wants to take a 10 or 15-minute break, I don't have any objections, as long as the respondent doesn't have any objections.
No, because we have another case that's going to be
Okay, is respondent here?
So hold on a second. Let me, before you start the time. This is a first time for us. It's not been referred. And is the respondent in the room? Yes. Okay, great. Thank you.
Oh, okay, great.
Okay, please start the clock. Oh, hold on a second. Does the complaint committee have any preface for this?
This is relatively recently. I think there's exchanges of information between two entities that Mr. Piccarello is trying to get a hold of.
Can you speak a little louder?
Sorry, I think there's information between two entities that you're trying to get a hold of.
Well, I dismissed...
Hold on.
Okay,
no,
hold on.
I need to make sure our process is
well, I thought he was addressing me.
Yeah,
I did
he shouldn't be. I was going to correct him that he
doing
shouldn't be. You should just address us, please.
Sorry.
Please, thank you.
So I think it was, there was information from HUD and CHP. CHP is Community Housing Partnership, that he's been requesting. I think one he's done with, and the other he's trying to get information from. And that's just off the top of my head. So I'm sure we'll clear that up very shortly.
And he's claiming not having received any documents.
Correct.
Okay. All right, great. Okay, let's start the clock.
Thank you.
You're welcome.
The Deputy City Attorney's memorandum was pretty good regarding the factual sequence. I'll just summarize. I don't need the full 5 minutes. 5 months ago, just seems like yesterday. 5 months ago, I asked for records, did an IDR to HSA. The next day, it was forwarded to the Department of Homelessness. I requested three categories of documents. I requested the contracts between Community Housing Partnership and the City Department, Department of Homelessness. I did receive them, but I didn't receive them on a timely basis. Second category was I requested a HUD settlement agreement letter titled CHP versus Johnson. I received that document after doing a Freedom of Information request to the federal government. It's disappointing that I can get records from the federal government much quicker than I can from the task force. It's very disappointing. Third category, I requested complaints by Zygmunt Aaron House residents against CHP in the past 3 years. I have not received those documents. Respondent says they don't have the documents. Well, that may be, but they made no good faith effort to locate the documents, and they made no effort at all to get the documents from the nonprofit. So, Department of Homelessness knows I can't get these documents from the nonprofit because of the limitations of 12L. Okay? The only way I can get the documents is through the agency giving them funds and providing oversight. So there's nothing in your packet to show any communications between respondent and the nonprofit whose records I was seeking. Any questions?
That'll come. Thank you. Any persons or witnesses provide any facts or evidence on behalf of the petitioner or the complainant? Seeing none, respondent, you have 5 minutes.
Good evening, Task Force members. Abigail Stewart-Kahn, Director of Strategy and External Affairs at the Department of Homelessness and Supportive Housing. Thank you for your diligent work late into the evening, and to the petitioner for staying as well. On July 16th, HSH received a public information request that was labeled as an immediate disclosure request. As noted, it was originally sent to HSA and was forwarded to us on the 16th and included the following things: a complete copy of contracts between ZAH and HSA, a copy of HUD compliance agreements, which were referenced, and any and all resident complaints filed against CHP in the past 3 years. On that day, I responded to inform the requester that it didn't meet the standards for an immediate disclosure request because it wasn't simple or routine to respond to. And Ms. Ellis, who is no longer employed at the Department of Homelessness and Supportive Housing, continued the response and the search for responsive documents. Because the request alluded to contracts with HSA, Ms. Ellis noted the need for an extension so that we could consult with the department. I want to provide a little bit of clarity here. When the department was formed, the Department of Homelessness and Supportive Housing was formed several years ago, some contracts moved over to us and others did not. And so it does sometimes take us, and some moved at that moment, some moved at different times, and so it does sometimes take time for us internally to determine where contracts reside, and as soon as we do that, we're able to figure out where we need to search. So that's kind of our process. This will kind of go away as the department is older, and we have a longer tenure of holding all of these contracts. In this case, the request bridged a period of time that could have involved a different department. So we then conducted various keyword searches to respond to the requests. We searched for all responsive documents. We provided that contract as noted. We provided a contract amendment as well. And we provided email correspondence from our employee, Grace Jin, and the ADA grievance and intake coordinator. And then we informed the requester, Mr. Piccarello, that we did not hold the responsive documents for the HUD request. This is not something that we retain. We are not HUD. We're the Department of Homelessness and Supportive Housing. I am glad to hear that he was able to get it through another approach. That's not something that we found in our search. And then the conversation continues as Mr. Piccarello clarified what he was looking for around complaints. So the process for grievances are maintained by our nonprofit operators. Those are not things that HSH maintains in its records, unless it is elevated beyond the nonprofit provider to HSH, which is listed as part of the grievance process. So we provided Mr. Piccarello the things that we had in our records, which were not all of them, it is true, but they were the ones that we had that were responsive. And I will also note that we have no obligation to follow up with our nonprofit partners and operators who are not subject to the Sunshine Ordinance in the same way that public servants and the city department are, and so those were the steps that we took in order to diligently and as effectively as possible conduct a reasonable research and respond to the requests. Thank you.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none, members? I have a question. Ms. Stewart-Conger? Okay, great. So you said something flagged me. I was curious. You said that you declared that Mr. Piccarello's IDR was not an IDR because it wasn't simple or routine. How do you come to that conclusion, and based upon what area of law
That's
that
a great
allows
question.
you to do that?
So in this case, when we are looking at complaints, first we have to search for them. Second, we need to review them to ensure that they don't have any protected health information and do that redaction. And that's not something we can complete in a The IDR is created, my belief and understanding is that the IDR is created for things that are readily available that we can respond to in a very quick time frame.
Have you read the ordinance
yes,
under
of course I have.
6725?
Yes.
Okay, because it doesn't say what you're saying. It's when it talks about simple and routine, it says the only thing it says is that maximum deadlines provided in this article are appropriate for more extensive or demanding requests, but shall not be used to delay fulfilling simple or routine or otherwise readily answerable requests.
Great.
It doesn't mean that you can convert it into a regular request. It just says you get to use the maximum deadlines that are provided in this section, 6725, immediacy response.
So in this case, that would be
10 days.
correct. So that was what we did. We responded. We used the 10 days.
That's fine, but you can't then reclassify it as a regular request. It's still an IDR, and all the provisions for the IDR still apply. We've had many cases here where departments will just regularly will convert because it's voluminous, or for whatever reason they think that it should be a regular request. Can't be done. There's no provision in the ordinance that allows for that kind of conversion by anybody. So if it's the only thing that does that, if it's not properly formatted.
I understand that.
Okay.
Yep. So I understand what you're saying. We went with the 10-day deadline. We can adjust our language. We did not dismiss it as an immediate disclosure request. We're simply unable to respond in a 24-hour period given the nature of the request.
Okay, so just again for your information, the response for the 24-hour period doesn't mean you have to provide anything.
Yes, we were
okay?
right.
You just, and it's not 24 hours. It's by the end of the following business
Yes.
day. So it could be 12 hours, or
Yes.
it could be 17 hours. So I just want to make sure we're all on the same page.
Mhm.
Thank you.
Thank you.
Continue. Is there anything else?
I think you
Okay.
had that
Okay.
question for me.
So yeah. So the okay. So thank you very much. I just wanted to get some clarity on that.
Just to clarify, Chair, that we do respond regularly to IDRs within the very limited time period when we are able to. We do not have a protocol where we automatically convert. I just want to note that.
Okay. So
Yeah.
so you also mentioned that this came to HSA first.
Correct.
Okay. Did HSA respond? Well, let me ask Mr. Piccarello. Did HSA respond to your IDR?
No, they referred me to Department of Homelessness
When did they do that?
because they said that
When?
the next day, the same day or the next day.
Oh, okay. So they responded.
Immediately.
They
oh,
did
yeah.
respond.
No,
Okay.
That's why I
Because-
dismissed them. HSA acted in good faith. That's why I
Okay.
dismissed them.
Okay, that's
Okay.
fine. It's just they're named in the complaint.
Yeah.
So,
Well, actually, see, initially my request was more than 3 years of complaints, and this entity became into existence in 2016. This is a new agency. Relative. Is that correct?
There was some info that he
2016. So my request went before they even became an entity, before there was even a Department of Homelessness. HSA had the nonprofits
Right,
and the
so
records.
Someone,
So that's why I initially requested the documents from both.
Okay.
Because one didn't get into existence until 2016, and my request was before 2016.
Okay, gotcha.
Subsequently, I reduced my request for records so I could get some records to just 3 years at one nonprofit building, Zygmunt Aaron House, where I live. Now, if you look at the contracts, and they're in your agenda, but I'm sure you haven't read their contracts. The nonprofit CHP is required quarterly to give Department of Homelessness all records of serious incidents on site. I've lived at that on site there for 5 years. I can assure you there's been more than one serious incident where I live. The Johnson HUD compliance situation was a senior in a wheelchair being stuck in an elevator for 3 hours. That document wasn't produced to me by the respondent. So she has the record, or she received the record, and to say that they don't have any records is disingenuous at best. I can assure you they're either in possession of the records or they know that the nonprofit is in possession of the records that I'm requesting, but I can't access them because of 12L. I can only get the records if the agency acts in good faith and gets them for me.
Okay, stop for a second. Member Hinsey, did you have something first? Okay. Go ahead, Member Martin.
It's clearing up my memory of the last complaint meeting, but I think what's happened is HUD is saying we don't got it, and there's a compliance component to the contract that says no, you're supposed to receive reports, incident reports about all serious events that happen at the place from CHP. But because CHP hasn't been reporting it and hasn't given it up, there's no really way for you to get it.
You're assuming facts, not in evidence,
Well,
aren't
right.
you?
But-
You're assuming that they haven't given them the records that they're required
right,
to.
and
that's an assumption based on what?
Based on that they haven't produced anything, they're saying they don't have it.
I can assume they are complying with the contract provisions and giving them to the Department of Homelessness, just like you can assume that
Well,
they
I'm just
weren't.
saying it's what is being asserted, right? That they don't have it.
You're, okay, you can make
Is
that
that what they're
inference.
asserting?
Hey, you can make that inference.
Okay.
Okay.
And anyway, there's no real way for you to get it from CHP. It's because it's a 12L
That's
deal.
correct.
Well,
Okay.
let's just go ahead, finish your
But
point, and I'll bring
I
it
think that's at the heart. There's stuff that exists, and either HUD's not willfully not producing it, or they don't have it, and CHP just hasn't been giving it to them.
You don't mean HUD, you mean HSH. Right.
No, HSH is dismissed, right?
No,
No, no, no.
HSA.
Yeah, I dismissed HSA. I
You
did.
dismissed who?
HSA.
HSA or HSH?
HSA,
Okay,
Human
HSA.
Services Agency, has been
Okay.
dismissed.
Okay. So either they...
Department of Homelessness is HSH.
Okay.
Yeah.
So either they have it and they're not giving it, or CHP hasn't been reporting it.
I don't disagree with that one.
Okay. Okay.
Okay, so so we're all clear on 12L, public access to records. These are for nonprofits that have contracts with the city. The word contract in the city's definition means a lot of things. It's not just an agreement. It could be a loan. It could be a grant. It could be any transaction between the city and a contractor. For the purposes of 12L, that's what this is about. So the disclosure, the only records that are available are financial records. Of those financial records, I think it's worthwhile to read it so that we all know what it is. Subject to Section 12L.5C, which talks about donor confidentiality, the exemption of revealing the donors. Each nonprofit organization shall maintain and make available for public inspection and copying a packet of financial information concerning the nonprofit organization. The packet shall include at minimum the nonprofit organization's most recent budget as already provided to the city in connection with the nonprofit organization's application for or in connection with the review and or renewal of the nonprofit organization's contract. That doesn't mean work that they do other than what's in the contract, okay? Sometimes that gets a kind of a blurred line for some people, both sides. It's most recently filed state and federal tax returns, except to the extent those returns are privileged. And 3, any financial audits of such organization performed by or for the city, and any performance evaluations of such organization performed by or for the city pursuant to a contract between the city and nonprofit organization, to the extent that such financial audits and performance evaluations one, are in the nonprofit organization's possession. 2, may be publicly disclosed under the terms of the contract between the city and nonprofit organization. And 3, relate to the nonprofit corporation's performance under the contract within the city within the last 2 years. Okay, so it's a very small scope of information. So going back to Mr. Piccarello, your request for information.
Yes.
Okay, so you asked for a complete copy of the current contracts between Zygmunt Arendt House and HSA.
I did receive the contracts.
You did, okay, good.
I did.
Then the second one is a copy of the HUD compliance agreement.
And I got that from the federal government through a FOIA request.
Okay, but you didn't get it from?
No.
Okay. Ms. Stewart-Conger, let me ask you a question. Do you regularly receive HUD compliance agreements between your contractees or of your contractees? Do you have a requirement for them to show you such compliance
Not to my
agreements?
knowledge, but I can go back and check. When we conducted a search for this particular document, we did not. That search did not turn back a responsive document.
Okay, so you're claiming that it was not responsive, not that you won't give it up.
Oh, correct.
Okay.
We don't have this document, to my knowledge.
Okay.
And I just want to clarify, previously, on the third request, there may be a relatively important misunderstanding here that was raised by task member Martin. So our contracts require certain things to be reported to us by our contractors. The requester requested any and all resident complaints filed against CHP in the last 3 years. So there's two categories here. So the resident complaints are filed with the nonprofit provider and are elevated by the complainant to HSH in one process. That was the search we conducted. Contractors are also required to provide us with critical incident reports, which would be to the contract, which would speak to the contract language around serious incidents, but those are not complaints filed by residents. So if Mr. Piccarello is interested in those, then I'm very happy to receive that request and conduct that search. And if that's the source of the information that you need, then that would be very helpful to understand.
So you're not opposed to providing him that information?
No. I mean, as you well know,
I was going to ask. I didn't read, as Mr. Piccarello asserted, I didn't read the contracts word for word, and I would probably ask if that was in the contracts, if there was some provision.
So the only thing that we can't, so we do need to redact them for protected health and other confidential information, and so that sometimes does take us considerable time to go through, depending on, in this 3-year period, Mr. Piccarello, how many there are and what that redaction process is. But we have received requests for critical incident reports across any number of our contractors, and we do provide those in a timely manner. What the original request was for, and this may be as simple as a language misunderstanding, was any and all resident complaints, which really is a very different process.
Why is
so
that
we
a different
don't
process?
have those, but we do have critical incident reports. If I'm hoping that I'm making myself clear at this late hour.
But I thought you said that you have both.
The ones that we have, we provided that were the complaints. We already responded to that and conducted that search.
Well, this is only, okay, but this is, I mean, the purpose of the ordinance is to produce documents that you're custodian of.
Right.
And if you are not custodian of those, then you're to help where the requesters, where they might be able to find them.
Exactly.
Okay?
So that's what I'm trying to do now. Okay. If he's interested in a different source of document, a different type of document, I'm absolutely happy to try to get that to him.
Can I say something? Just
yeah, sure.
I think this might. I think I understand what you're saying.
Yeah.
That a lot of resident complaints aren't critical incident complaints, so you never see them. The ones that rise to the level of critical incidents, you do see. Or they're reported as critical incidents by staff, not by residents.
Correct.
And those are the things that you get.
Correct.
Okay.
Thank you for clarifying.
Okay. The other thing I want you to be aware of in the IDR section of the ordinance is the last section. Notwithstanding any provisions of California law, this ordinance in response to a request for information describing any category of non-exempt public information, when so requested, the city and county shall produce any and all responsive records as soon as reasonably possible on an incremental or quote-unquote rolling basis, such that responsive records are produced as soon as possible. So, I think Mr. Piccarello is well-versed in, he's been here many times, I think he knows that. Just for your edification, too, appreciate what you're trying to do, and just to also let you know, keep it going.
Yeah, thank you. And Chair, in this case, when we noted deadlines, we responded well before them in each situation. We just were citing deadlines to set sort of the end marker of when they would hear from us. And as soon as we had the responsive documents, we provided them. I think in this case, we may have been searching for a different source of documents than Mr. Piccarello is asking about.
Okay. Let me ask Mr. Piccarello a question. So we've dealt with the first two issues. Well, let me ask you on the second issue.
Well, the second issue was dealt with by the federal government, not by
No, I
respondents.
understand that, but
Okay.
but they're saying that they don't have a copy. They don't have
okay.
it. That's why I asked if they have a requirement to collect that information.
I heard a response, yes.
Okay, so
Yes.
that's, what we have to go on. So as far as the last item, what is still missing?
Well, my request was 3 years
Right,
of residential complaints.
right.
She's saying she doesn't have any documents, but now she's saying she has serious incident documents. I'll take those,
Okay,
but I still believe I'm entitled to the residents' complaints at ZAW for 3 years, redacting the names, but I'm entitled to those documents, and I believe she's either
Go
in
ahead.
possession or had possession of those documents.
How do you know that?
I don't know that.
Well, I mean, because, to me, for the second one, HUD compliance agreement, I do work in affordable housing, and we have to provide all kinds of federal and state documents when we do work at the local level.
Right.
And they're requested. That's why I asked the question, is this document required as part of, receiving a contract with the city or doing business, with the city or anything like that?
Yeah.
The answer was no. It didn't seem like it. She wasn't very confident that that was the case. I take that to believe if she's seen one of these before, she's probably seen a lot of them, because there are lots of nonprofit developers out here.
Yeah, it's just hard for me to believe that a senior in a wheelchair stuck in an elevator for 4 years, and that was reported to HUD against the nonprofit she's overseeing. She's not in possession, or never was in possession of that document. Actually, her response to my request was my documents weren't discoverable. So what tells me is that she conferred with some deputy city attorney and told her that she didn't have to produce those documents. So let's start with HUD's document, a senior in an elevator in a wheelchair for 6 hours or 4 hours. That's a serious incident. She didn't produce that document because she said she didn't have it. I don't believe that. You can believe her? I don't believe that. She had the document. She had to have the document. That's a serious incident that HUD intervened against the nonprofit that she has oversight with. So at some point, she had that document.
Well, but the question is, does the document still exist?
Hold it.
Well, the document exists because I have a copy and I got it through.
Yeah, but you got it through a different agency. But the question is, does the custodian here have a copy of that document?
But the parties to the HUD intervention was a nonprofit that she's overseeing, and that the nonprofit is required to report this type of incident to the city agency funding them.
Okay.
Yeah.
We still have, Mr. Piccarello, you've requested resident complaints about issues, correct?
That's right.
Do you know for certain that the incident you're describing was filed as a resident complaint, or was it
I know
elevated as a critical incident?
Good question. I know for a fact it was filed as a resident complaint. Yes.
So
And there's been more than one residential complaint about the elevators in that building.
So is it possible,
Yep.
and that a resident complaint was made,
Yes.
but because it was a serious incident and then it was filed as a critical incident and presented to the city, that the city may have received the critical incident report but not the resident complaint because the nonprofit saw that it was reporting the issue as a critical incident but not as a resident complaint?
That's very possible.
In which case you did not receive the information from the city because they were looking only for resident complaints for you.
You'd have to ask the city that.
Can we
Well,
ask the
but
city
that was your request. Your request was specifically any and all resident complaints.
Yes.
Not critical complaints, not any other kind of complaints.
Okay.
They
We can be semantical.
No,
We
it's
can-
not.
we can be semantical.
It's not, because they specify that they have categories for these different kinds of complaints. So for them, when they see even though you may think that resident complaints encapsulates all complaints, they see it as, oh, that's a very specific term that we use in our office. There's a difference between resident complaints and critical or whatever other categories they have.
Then perhaps the respondent should have sent me an email asking for a clarification as to what documents I was seeking, right?
And did you have any conversations about that with them?
The conversations I had was, first, it was not an IDR, and we don't have any documents. Basically, those were the conversations.
Okay. All right. Any other questions, Member LaHood?
I mean, I think we already have this answer, but Ms. Tort-Khan.
I'm sorry?
I'd like to hear from the respondent.
I can't hear you. I'm sorry.
I'd like to hear from the respondent.
Ms. Stewart-Conger.
Oh, okay.
Yeah,
Sorry.
thank you.
If Mr. Piccarello made the same request, but instead of asking for resident complaints, he asked for critical incidents in the same time period, would you be able to provide those within a short time frame?
If you can define short time frame.
Would you respond to his request?
Take the short time.
Okay, would you respond to that
We would
request?
absolutely respond to that request, and I do appreciate that. I thank you for clarifying that a resident complaint is like a term of art for us, and so that was the search we were conducting. We do have email exchanges with the requester where it got confusing later on, and we tried to clarify, and we never moved from the idea of a resident complaint to a critical incident report. And that is a difficult thing to navigate for somebody who's living in a building that we oversee. And so I'm very interested in getting Mr. Piccarello what it is that he's looking for, and would absolutely, if that is your request now, would absolutely begin conducting that search, that redaction process. We always do request that as narrow as the searches can be to meet the needs. That is very helpful to our staff, so that we're not searching for X number of years when if we're really looking for a critical incident report around this particular incident or around a narrower time frame. That certainly helps our very busy staff, but we're happy to respond, of course.
Thank you.
Okay, so we're at number one was complied with. Well, first, the IDR was responded to properly. Okay, so that's the first thing. The second thing is the first request was a copy of the current contract. You received that, correct? Okay, you got that? Okay, the HUD compliance agreement, they say they don't have possession of it. Okay, I understand you think otherwise, but that's what we have to go on unless there's some other information that you can provide us that shows that they do have it. That's a different story. And then 3, for the complaints, let's just call them complaints, and the different types of complaints that they categorize, they're willing to provide you what you're interested in.
I'm willing to accept them.
Okay, great.
Does that require me to do another request for?
No, it doesn't. No, what I'm going to suggest let me get to that at the end. I'm going to ask for rebuttals just to get through that process, and then I'm going to make a suggestion, okay? So is there any other questions for discovery? Okay. Ms. Stewart-Conger, you go first. You have 3 minutes for rebuttal. If you have anything
I will be brief. I appreciate the task force's time on this at this late hour, and I appreciate Mr. Piccarello seeking clarity here so that we can provide him with information that he's seeking. We responded to the IDR in an appropriate manner. We conducted the appropriate searches. We consulted with the other department to determine who was the contract holder, providing that in a timely manner. And I look forward to your guidance and to consulting with Mr. Piccarello about the specifics of his current request. Thank you.
Thank you, Mr. Piccarello. You restart the clock.
I don't have anything to add, except obviously, if you look at when I did the IDR and when the response was given to me, that they violated 6721. But I'm not really that interested in getting a finding that was 6721. I'm more interested in getting the documents. So if she's going to give me the documents, that's fine.
Okay, thank you. All right, here's my suggestion, is that, that we find no violation, but that we refer this to complaints and amendments for monitoring to make sure that Mr. Piccirillo gets all the information that he needs.
I'm sorry, did you say we find a violation
No, we
or
find
no violation?
no violation.
Okay.
Okay? All right, so I'll move that myself. I move to find no violation.
I'll second.
And to refer this to compliance and amendments for monitoring and to report back to us at the January meeting.
I'll second the motion.
Okay. So moved by myself, second by Member LaHood. Any further discussion, deliberation, public comment? Seeing no public comment, we ready for a vote? Please call roll.
Chair Wolf.
Aye.
Chair Wolf, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Yankee.
Aye.
Member Yankee, aye. Member Martin.
Aye.
Member Martin, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Tesfaye, absent. Member Hinsey.
Aye.
Member Hinsey, aye. Member Highland.
Aye.
Member Highland, aye. The motion to find no violation passes.
Thank you. Okay, let's get to the last one.
Item number 9, file number 19089, complaint filed by Anonymous against Dennis Herrera and the Office of the City Attorney for allegedly violating Administrative Code Section 6721D by failing to provide a determination to a supervisor of records petition in a timely and/or complete manner.
Okay, compliance and amendments. Somebody have any?
Which compliance amendment was it?
Yeah, this came from compliance and amendments. This is also new,
Which meeting was it?
September 24th.
Lila, you chaired that one, right?
Yes.
Okay.
So we found jurisdiction, and this is regarding the mayor's calendar and seeking more complete records than were provided.
Oh, right. This was the metadata one, right?
Yes.
Okay.
One of the metadata ones.
Okay.
Mayor's office.
Okay. So forgive me before we start this. Weren't we going to hold off on the metadata ones until the IT committee had finished its work on metadata? I hate to do this.
I think.
Has the IT committee met yet?
Hold on. The IT committee met once, but we
We don't have any speakers for the IT committee coming this December 17th.
But that wasn't my question. My question was, didn't we make a decision to hold off on all the metadata cases until we had the information?
Yeah, yes.
Okay.
As I recall, we made that decision at the IT committee. I'm not sure whether.
This is another. This is another complaint.
I know. I remember the decision around the metadata. I just don't remember whether it happened at the IT committee. I remember it came from you. I just don't remember whether it happened at the IT committee or the general meeting.
Either way, I'm determining what goes on the agenda, what doesn't go on the agenda, and the assertion was to hold off on all the metadata items and to hear, because there were two or more other types of complaints. And we wanted to make sure that we were all educated enough and had enough information so that we can deal with all the metadata issues, because they probably are all somewhat similar compared to some of the other complaints.
Chair Wolf,
So
I think this is a different anonymous, and I don't think this is metadata. I could be wrong.
Wait, it's the same anonymous, isn't it?
I believe so.
Then why do we have someone?
He's from the city, I
He's
believe.
responded.
Yeah.
Fair enough.
So I'm sorry. Member Yankee, did you have something that you wanted to
No, I was
expand?
saying, I remember the saying that I thought we
Okay.
were going to resolve all the metadata things
At a later date.
at a later date
Yeah.
after the IT committee
Right.
finishes its
I
process.
had specified it would be
Yes,
sooner than January.
Right,
So-
and I remember that as well. I was just trying to speak to the reason that the three of us remember it and others
Right.
might not,
Okay.
is because it happened at that meeting.
Okay, so let me just ask, Anonymous, are you there?
Yes, I am.
Okay. I just want to ask, now I've read through this case, but I just want to ask you, is this a metadata topic area?
No, this is about the supervisor record. It's not even about a public record determination.
Okay, very good. Okay, so not metadata. Okay, just to clear that up.
There's metadata referred to in the.
I know. That's why I wanted to clarify, because we want to make sure that we don't jump the gun on that. We spent a considerable amount of time trying to figure that out. Okay, sorry to delay everything. Anonymous, you go first. You have 5 minutes.
Actually, could I just a quick word, which is that. So my name is Manu Pradhan. I'm here from the city attorney's office.
Yeah.
Just very briefly, we had asked for a short continuance because Mr. Cote couldn't be here today. If the complainant obviously has objected, if the task force would like to proceed, that's fine. I'm here. I'll do my best to fill in. Mr. Cote obviously would prefer if he could be here, but obviously it's up to the task force, and I'm here assuming you'd like to go forward today.
Elizabeth Coolbrith.
May I respond to that?
Attending.
One moment. I have the administrator interacting here. Go ahead, Cheryl.
I'm sorry, I just want to say that I spoke with
You need to speak up a little louder into
I
my
spoke with Elizabeth Coolbrith, and she said that this gentleman, Manu Pradu, would be attending today's hearing.
Okay.
That's why it's on the agenda.
All right. Go ahead, Mr. Anonymous.
Yeah. So I understand Mr. Cote can't be here, but I think that we're here right now. We might as well have the hearing. I know I used the wrong word last week. I would like to proceed with the hearing. I believe I have done all my analysis, research. I have done everything I'm supposed to do. And I would please urge you to allow us to proceed with the hearing today.
Okay. Let me just ask, I'm sorry, repeat your name.
It's Mr. Pradhan, Pradhan.
Pradhan. Mr. Pradhan, are you familiar with any part of this case?
Yes.
Okay. So that's all that's necessary. If you have familiarity with it, then we can proceed. In the middle, we can decide it maybe needs to be continued, what have you, but we want to proceed at least with the process.
Works for me.
Okay, good. Thank you very much. Okay, let's start the clock. Mr. Anonymous, 5 minutes.
Anonymous, go ahead.
I think you may have something.
Hello, can I begin?
Yes, you can.
Oh, okay. So I'd like to begin on page 15 of the PDF, which is page 923 of the record. This is a simple question before you that has nothing to do with the actual records at hand. It is whether the city attorney has to follow the law in 67.21D that says they must provide a determination whether the record requested or any part of the record requested is public. I think it's a very simple case. The answer is yes, it's in the law. Now, you've seen on the second part of this page the actual words of 67.21D. I've bold and underlined the part that I'm asking you to enforce today. Next page, please. Now, the timeline here is very simple. On May 15th, I filed a petition for a determination under 67.21D to the supervisor of records regarding the mayor's calendar, but that part isn't really important here. On May 25th, the 10-day deadline expired. I followed up with the supervisor of records for months. I filed this complaint on August 21st because they just wouldn't give me a determination. As often happens with the city, as soon as I filed a complaint, then I got a response from the city, and they denied the petition 103 days after filing the petition. I then had to file a second petition for the same request, and in 10 days, they closed the second petition, but acknowledged that the mayor did have public records that needed to be disclosed. This case is not about which parts of the mayor's calendar are public or not, and whether you disagree or agree with Herrera's legal determination. Just about whether the city attorney, the respondent, when he acts in a supervisor of records, has to follow a particular sentence of the Sunshine Ordinance. Now, their response, written response, asks that you find that the shall and within 10 days of 67.21D guideline, but if you do that, you will gut the whole Sunshine Ordinance because every guideline will be every deadline will now just be a guideline. The rule of reason doesn't apply here for two reasons. One, they never invoke the rule of reason. And two, in the span of those 3.5 or 4 months, there were only 2 petitions from me. They had no excuse in terms of volume or time not to respond to me. Next page. Now, they're going to argue that my petitions, the way I make complaints, are so legally unique and complicated that it's just me who they can't respond to in 10 days. These are statistics from the last 4 years of annual reports from the Supervisor of Records. Only 51 petitions were filed in 4 years. 36 were closed with no determination. That's their words. 15 determinations were issued in 4 years. All 15 were denials of the petition. 0 petitions were granted, and 13 of those 15 petition determinations took longer than 10 days. The mean I calculated was approximately 32 days on average if you did not get it in 10 days. This is not something where I'm just some, crazy hard petitions I filed. They just don't follow this law. However, if you're the vice president of CBS and their general counsel, you absolutely get a long, timely response within 10 days. That's not fair. All of us should get equal protection under the Sunshine Ordinance. And I'm going to ask that you find, whether it's for the timeliness reason or for the fact that they closed my second petition without providing a determination, that they have violated 67.21D. And I would also like to dismiss Brad Russi, because the law technically only applies to Dennis Herrera. The fact that Russi acts as his representative is not relevant. If you want evidence, you can see the 2 petition responses on page 970 of the record, which is PDF page 62. That's their second response, where they closed without providing a determination. And page 971, which is the first response, page 63 of the PDF, where they took over 100 days to respond to my petition. I think the issues are quite simple. They should follow the law, and their fact when they tell you, well, they should just be a guideline, is really unfair. That's not how the Sunshine Ordinance works. Thank you very much.
Are there any persons or witnesses providing facts or evidence on behalf of the petitioner or the complainant? Seeing none, Mr. Pradham, you have 5 minutes.
Thank you. Thank you, members of the task force. So there's no dispute about what the literal text of 6721D, what it says. It says that the city attorney acting as supervisor of records shall inform a petitioner within 10 days of whether a record is public.
Sorry, can you speak more into the mic, please?
Is that better?
Yeah.
Yeah, speak up, too.
Okay, sure. So there's no dispute over what the literal text of 6721D, what it says. I would ask the task force to keep a few things in mind. So first of all, a supervisor of records petition, it triggers a process whereby our office, whose role under the charter is to serve as legal counsel, checks in with its clients about whether or not records that are allegedly in their possession are public or not. In many instances, we don't have the records ourselves. In many instances, the petition doesn't include all of the factual detail to enable us to make an immediate determination of the matter. And in many cases, in rare cases, certainly, a complaint may raise an unusually complex legal and or factual issue. And I can think of no better example than this petition, the underlying petition, to illustrate this point. And I would respectfully disagree with the claim made by the complainant that the underlying request is not important. The underlying request is critically important. The underlying request concerned the very issue that at the outset here, the task force is saying we need more time to think about. We need more time to figure out. The underlying request concerned all of these same issues surrounding metadata. These issues are novel. They are enormously complex. The task force had to convene this IT and technical committee to investigate an issue, develop a policy that city departments could follow to understand how to evaluate these issues going forwards, brought in cybersecurity experts from across the city. And the task force is figuring it out. Now, I commend you, absolutely. You are doing your job. You have a constructive role to play, and you're doing that in developing guidance for the city and giving these issues the study they deserve. Now let's look at the issue at hand. You are taking the time to do this right. And yet, the supervisor of records is supposed to solve this riddle in 10 days. That is an absurd result, and that is not an intended result of the language in 6721D. A different approach, I think, could have very negative effects. We take the extra time to do a good job. We could, if 10 days were an absolute deadline, we could probably figure out some clever way to technically comply. We could all we have to do is issue a determination. We could issue a one-line determination, denied, rejected. There's no legal obligation there to issue an opinion, which is what we do. We could simply rely on, what's in the face of the complaint. We could defer to departments, but that is not how we want to operate, and it's not, from a good government perspective, how we should be operating, and so we don't do that. In our written response, the point was made that the task force shouldn't dictate to the supervisor of records how it does its job. And I just want to elucidate that one point a little bit. It's not meant in any sort of a disrespectful way. It's actually quite grounded in the text of the ordinance. If you look at 6721D, that is where it says what the job of the supervisor of records is. 6721E then states that if a petition is not acted on by the supervisor of records, the person making the request may petition to the task force for a determination whether the record requested is public. Whether the record is public, not whether the supervisor of records has, quote, violated the ordinance or is not doing its job. If the supervisor of records can or has not acted, the remedy to the task force is to take the place and advise whether the record is public. The task force certainly has authority under other parts of the ordinance to evaluate the city attorney's compliance, provide information, set goals, and we absolutely welcome that, but we would respectfully suggest that it's not appropriate for the task force to be enforcing the ordinance and ordering and finding violations.
Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none? Okay. Thanks. Vice Chair Josh Wolf.
So I'm trying to parse through the thesis that you just put forward, and it seems to me that the complainant alleges that a response didn't come in until after 10 days. How many days did it take to provide the response to the complainant?
More than 10 days, no question about that.
Okay, and what is the legal framework that you're citing that allows you to go past that 10-day deadline?
Let me respond in this way. The literal text of the ordinance says, shall issue a determination in 10 days. Whether you're interpreting an ordinance, a statute, a contract, the plain language is not to be interpreted in a way that yields absurd results, unintended results. And we think that hewing to this very literal reading of the ordinance would be such a result. The other thing I'd point out in terms of legal framework is, again, to look at 6721E. Now, 6721E says that, again, if a petition is denied or not acted on by the supervisor of public records, which is the allegation here, the person may petition to the task force for a determination of whether the record is public. So I think the ordinance itself kind of contemplates this possibility that in some situations the supervisor of records might not act. Obviously, it's our goal to try to address these petitions in a prompt and effective manner. But when that happens, the remedy is for the member of the public to file a complaint, to petition to the task force about not whether or not the supervisor of record has done its job correctly, but simply about whether the matter is public.
So your read on what is it, 6721E, is that comes into play not when a supervisor of records has denied it's public and they're appealing to the Board of Supervisors, but when a supervisor of records has neglected to respond in a timely fashion. Is that what I'm hearing from you?
I'm not sure I understand your question. Could you repeat that?
I mean, it seems to me, so we find timeliness violations pretty regularly in this arena. And your argument, as best I understand it, is that the way the law is written is just not feasible with the type of work that you have to do in certain cases. Is that a fair summary of what you are saying?
Yes, in certain cases, it's not feasible for us to do our job well in 10 days, and the ordinance doesn't.
Right, the ordinance doesn't allow for that, or you're saying it does allow for that?
We think that it's appropriate to interpret the 10 days as a guideline, as a goal, but not a binding deadline in cases such as these.
So the hurdle there that I see is that we find timeliness violations all the time for agencies that aren't able to get the request answered within the window. And as best I can tell, that gets chalked up as a timeliness violation, and that seems like that's the end of it. They say they'll try harder next time. It doesn't. I've never seen like a repeated timeliness violation. It's like a speeding ticket. You can say that my interpretation of this is I was driving safely, but the law still says 55 miles an hour. And I'm not hearing anything from you to suggest other than that the law is impractical, and this is coming from the legal side of the city saying that the city law just doesn't work. And that is hard for me to sort of parse how that is a viable alternative to following the Sunshine Ordinance that we are empowered to ensure is enforced.
Well, I don't think I'm saying that the law is impractical and we're not following it. I'm saying the law doesn't require 10 days as an absolute deadline. I think what we're doing is I'm not excusing a violation of the law. I think what we're doing is completely consistent with the law. To your broader question about what about the other deadlines, I think there is a meaningful difference in the ordinance between the duties of a custodian of public records, who absolutely has a duty to respond in 10 days or after 1 day, depending on the nature of the request, and the role that the city attorney's office plays as supervisor of records, because it's a different framework. Custodians of public records have very strict deadlines to comply. The city attorney's office, when it acts as supervisor of records, we are consulting with our clients and doing what we can to determine whether a record is public and trying to get it produced if it is. And that is, there are simply two different things. Those are apples and oranges.
I'm going to interject here. So 6721D is pretty explicit. The supervisor of records shall inform the petitioner as soon as possible and within 10 days. How is that how can you say that seems arbitrary? I mean, that's the law. It's a voter-approved law. It's very specific that it's within 10 days, not around 10 days or minimum of 10 days. It's as soon as possible and within 10 days. And it's not just within 10 days for you to do something with the document, like determine certain things that need to be redacted or not. It's just to determine whether the document is a public document or not. So let me just ask Anonymous for a second. I think it's important for us to know what exactly you had requested. I'm not going to tear down into the details of what you were asking for, but I just want to ask what kind of documents were you asking for this particular request, please?
Are you asking what my request was or what my petition were? Because they're two different things. I just want to make sure I understand.
No, I'm asking what your request was.
Sure.
Go ahead.
Sure. So the original request is for the mayor's calendars with all items for 1 week with the metadata and headers. And then the petition there are two different issues. There is the metadata and headers, but there's also that non-property calendar. There's no reason for that to take I don't know how many months, right? Maybe they have some argument about we need to go back and figure out all these things about metadata, but why did it take a second petition to get the non-property calendars, and they still have never given me a determination?
Okay, so
I want to be very clear about that. They gave me that first one in 100 days, and that second one, I do not believe I have ever been provided a determination.
Okay, so I'm not going to actually drill down even that deep. The question I have for you is, if let's just take the calendar, okay? Is a calendar public? Is it public or not? Okay, you have you have the ordinance, you have Prop 59, you've got many different areas that determines whether public officials' calendars are public or not. That's all the ordinance is asking. It's not asking you to determine what parts should be redacted or held confidential or not. The question is just on the face of it, without doing anything, the supervisor of records is doing exactly what we're doing here. Same exact thing. Okay? And we refer to we refer people to the supervisor of records lots of times. Why? Because we think it's faster. You don't have to, that's why we get 45 days, okay? Because it's faster for you folks who are in the office every single day, and you've got staff that actually focus on this stuff, than us volunteers that meet once a month, okay? So the question here for me, I see you. The question here for me is, if somebody comes to you and asks, I'm requesting this information, can you tell me if it's public or not? You don't have to, you just have to, in camera, go into a back room, look at it, or say, I need a few days to consult with that agency or department or that custodian, in that kind of way. And just so you can get an eye on it and say, you know, as far as we're concerned, every document that's in the hands of city is a public document, whether it can be released or whether it's exempt or whether it has some special restrictions or something like that is a completely different story, and that can come into play as far as the answer. But it shouldn't be that heavy of a lift to say, if somebody's going to ask for a elected official's calendar, whether that's public or not, metadata, you know, scribble scrabble on the side, you know, whatever, dog-eared, whatever, however it is, the question is it public document or not? And that should not take more than 10 days. It's reasonable for it not to take more than 10 days. So I'd like to hear a response to that.
Sure. And so I think it gets to the question of what exactly a petition may be asking for. Mm-hmm. Now, if a petition is simply saying, is this document a public record?
You're talking about a request or a petition?
A petition to the supervisor of records.
Got it, okay.
If the petition is simply saying, is this a public record? Well, you're right, that is a fairly basic determination. Is it a writing relating to the conduct of the public business in the custody of a public agency, right?
Right.
That is a fairly simple determination, I agree. But many petitions, including this one, do get into the exemptions, and they do go further. And they ask why this particular information from that thing, which is obviously a public record, was withheld. And now in this case, the information that was withheld, that was being asked about in the petition, was exactly the same stuff we are all continuing to wrestle with, this issue of metadata.
But the question is, even if it's meant to be redacted because there's some citation of law that allows it to be redacted, does that negate it from being public? No. It's still public even though it's redacted.
So is it, let me...
The record, right?
Right. So let me make sure I understand. Is it the task force's, I guess, position or understanding that, you know, if that it would suffice for the supervisor of records to simply say, this document meets the definition of a public record under the Public Records Act?
That's exactly... Go ahead.
And we would not offer any opinion on whether a department had properly redacted that document.
That comes later. The supervisor of records does exactly, the way we see it and the way we interpret and understand the ordinance, supervisor of records does exactly what we're doing here, okay? Except it's to maybe one person. You can just walk into the office, you know, fill out a form for a petition, and maybe get it quicker, get it faster, because you're going directly to the city's legal counsel.
Right.
Okay? I just want to know, first of all, is this record a public record or not? Right. If it's a private calendar, not a public record. So no, you can't get the private calendar, but you can get the public calendar. Right. Okay? Now, that's all. The next question would be for the requester to go to the custodian of the record and say, okay, I was told by the supervisor of records that your calendar is public. May I have it? They then say, well, we're not sure. We're going to have to consult with our legal counsel, not the supervisor of records, our legal counsel, to determine what part or if all is releasable or not. Okay? The record, so we know that some actual physical records can't be released. Investigations, personnel files, things like that can't be released. And then we know that there's certain information that can't be released, but the record, the document must be released. That's why we have the use of redaction, because the physical sometimes, we all, people get FOIAs from the federal government all the time, just black pages, right? They're just all redacted, but they didn't withhold the actual document. They actually got the document, and there's some writing on it, but most of it is not there. So that's kind of the thrust of where we see this, and the way we stand for it. Now, I agree. In 6721E, if you choose not to take any action on it, yes, then it can come here. When we deliberate, I'll expand on whether I think the task force has jurisdiction over finding violation or not. But right here, as far as discovery is concerned, that's when I'm trying to get to that point.
So if I could I'd just like to make sure I understand the task force's view on this. So in this instance, I believe the sequence of events was that the request was made for the calendar, including certain metadata. The mayor's office responded with a PDF of the calendar that did not include the requested metadata. That triggered a supervisor of records petition. Is it the task force's kind of interpretation or position that the city attorney, the supervisor of records could have responded simply by stating, we can confirm that the information that you requested, that is a public record, and we have no opinion on whether the exemption cited was proper in this instance, but we can confirm that it meets the definition of a public record.
Yes, and I'll give you an example of how it works here. When we get a petition, it goes to a complaint committee. Complaint committee does three things. One, first, make sure that it gets it done within 45 days. Two, determines if it's within our jurisdiction. And three, if the record was public or not. It makes no other decisions. When we get to the hearing process and somebody says, I got this piece of paper from the city that said that's all redacted, and I want to see what's behind it. Well, then the city comes forward and says, well, under investigative law, code sections, blah, 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 this information is exempt until such time that it can be released, okay? That's where that happens during that hearing process.
I see.
Okay? So the purpose of the to us, the purpose of the supervisor records is just to get the first jump. Is this first? I need to know whether this is public or not.
Does it meet the statutory definition of a public record?
Of a public record. And then if they want to investigate, further, all of a sudden now they get resistance because they're saying, oh no, I can't really. If we want to talk about this particular case, if here's a calendar with some metadata, I want to get that metadata. You just told me that it's public. Well, the custodian is resistant. They're saying that under certain other sections of law that it's not releasable. Okay, now that's a whole nother realm.
Right.
Okay, so there is a delineation, and that's the way we have always interpreted it. And so we suggest, I would say we suggest that that's the way you interpret it too.
That might make sense, and I do think that there is a textual basis for what you're saying. I mean, the question under 6721D is the record a public record or not?
The question is whether it's releasable or not is a different question. That's a different question. So is an investigative file public? Yeah, it's public. Well, how much of it is actually available, releasable, disclosable?
Right. And the answer could be all or none, perhaps.
It could be all or none, but
Okay.
that doesn't discount whether it's public or not.
Right.
And that's at least for us, that is what the purpose of that other place to go to find out is. That's the way we read it, because that's the only part that specifies your charge.
Right.
As the supervisor of records.
I see. I mean, it's sort of interesting in the sense that when the custodian of this document responded, I don't think there was any question at that point whether simply about this threshold question of whether the item was a public record, because it was produced, albeit with redactions, and the basis of the redactions was not that the redacted information is not conduct relating to the public business, meeting the definition of public record, but rather it was that particular information was exempt.
I get it.
So, I think we've
I'll tell you,
tried to address perhaps more than the task force things we need to be addressing.
Right. I mean, when the complaint committee meets and they are determining those three things, it sometimes takes a lot of resistance to not dive into the details and to start adjudicating it.
Right.
The idea is to try get in and get out and then have the adjudication happen here.
Right.
Okay.
Well, I'll try. Try not to. I'm sorry.
Yeah. Go ahead.
I'll try not to, belabor the point or anything. I would just again I just want to make sure everyone understands that in cases like this where we've taken more time, like here, I think it was pretty conceded that the document met the statutory definition of the public record, but we were trying to do more and actually determine this difficult question concerning the exemptions. And that is why we've had to take more time.
Yeah,
in this case.
another good example is the use of the IDR. You have people who are across the street at district court, and they need somehow something comes up in their case. They're like, oh, I need this document that's from the city. I need it really for tomorrow, okay? Or I need it in 2 days. The purpose of the IDR. It's a pretty serious need for, the use of the IDR. It's the same kind of thing here. I need to know whether this is public. Can you tell me, as soon as possible? You're going to get it. Somebody's going to get an answer faster going directly to the city attorney, who's the supervisor of records, than they are coming through our process. But if you fail to do it, yeah, they have the ability to come here. Now, I think the question before us that the petitioner is putting for us is whether we can find the supervisor of records a violation. I'm not going to answer that question. I'm going to leave that for a little more discussion and discovery from the rest of the members here. I spoke enough.
Can I respond to one thing?
Sure, go ahead.
Sure. So I want to be clear that it's not just a timeliness issue that they took 103 days. On that subsequent petition, and you can see this again on page 62, which is page 970 of your record, that one, they responded in 10 days, but didn't provide a determination. That's the same request. And that's the crux of the problem. They never actually provide, I gave you statistics, they don't actually provide that determination. This is the second half of that. This is the non-property calendar. And it really is important for me to know, are the non-property calendars a public record or not? And I think the supervisor of records has a responsibility in writing to say non-property calendars of the mayor are a public record or not. I don't think they have the authority to close my petition unless I withdraw it. So they in 10 days just told me your petition is closed. But what they should have said, and it's their legal option, they can do whatever they want. They could say the non-property mayor's calendar was a public record if they believe that. I think they do believe that because I got the records eventually. Or they could have written in a letter, the non-property calendar is not a public record. And they have a responsibility to put that in writing because that allows us to create a case law. And now I can go to other people and say, hey, non-property calendars are public records. They just refuse to ever give that determination when the member of public is right. I don't know why they do that. They only ever say the other way around. They'll only give you a written determination that it's not public, they'll never give you the written determination that it was public. And I think that is under your jurisdiction under 67.30C, where it's any person violating the Sunshine Ordinance. And I think the city attorney is a person, including when he acts as a supervisor of records. Thank you.
I just ask you, Anonymous, how do you then account for 6721E?
I don't think that remedies are exclusive. I have the ability to go to you to get a determination about and find violations. But I think that 67.30C says you can find any person in violation. I don't think.
That's not my question.
Sorry, go ahead.
That's not my question. 6721E, if the custodian refuses, fails to comply, or incompletely complies with a request described in B above, or if a petition is denied or not acted on by the supervisor of records, the person making the request may petition the Sunshine Task Force for the determination of whether the record is public. They can not act on it and be absolved of all wrongdoing. So it sounds like.
Do you want me to answer your question?
Sure.
Okay. So the law clearly says absolutely. If the supervisor of records does not provide a determination, one can come to you. I don't think that invalidates the word that the supervisor of records shall provide a determination. The fact that a law provides one remedy doesn't invalidate other remedies that may be available under the law. For example, you can go to the court, or you can go to you, or you can go, and in fact, your orders can be enforced in multiple ways. They can be enforced by you sending a referral to the district attorney like you did today, or the ethics commission. I can actually take your orders after 5 days and go to a superior court myself. So I don't think that the fact that there is absolutely a remedy, as you described it, invalidates the fact that there are other remedies available under the law as well.
I agree. You're back to the thrust of your point. You're stating that the supervisor of records has a responsibility to do this particular task. The ordinance specifically says that they cannot act on that. And if they don't, then you have a remedy. You can come here, or you can go to the other two venues. So that's what and I understand what you're saying about 6730C. Okay, we can discuss that a little later. But the point here is that, to me, it's a fine line. It's a really fine line here, and I think after we get to rebuttals, we'll have a little more discussion about it. I just want to stick to collecting facts and getting discovery and just making things clear that we're on the same page about things. Who is next?
I think I was.
Vice Chair Josh Wolf.
So we covered a lot of territory in there, and I think that that part of the reason that we saw the process take what it did was because metadata has become this code word that sets people into, like, we don't know what to do with this. So at the point that we started to peer back at what the actual request was, I think we start to veer into this larger metadata conversation. However, the timeliness thing, I don't see any argument for any violation, any deviation from those 10 days. I haven't heard anything to quote that other than it's not possible. I think there's an issue of the determination that was never issued, but I'm not sure that part of it is something that we should dive into, as we still have the rest of the metadata stuff that we're trying to work through to figure out how to navigate that. But I do have one question for the city representative, which is that the anonymous complainant suggested that orders that find that a document is public are just never forthcoming. Can you possibly speak to examples where documents were found to be public through this process?
Sure. Well, no, I can't I don't have a specific example in mind, but what the complainant has referred to as these, quote, non-determination letters or these failures to make determination, I don't think I really agree with that characterization. I mean, those letters are a form of determination, because what happens is a request is made for a document, a city department perhaps withholds it or redacts information from it, leading to a petition. At that point, again, the process is that the supervisor of records checks in with the client, determines, kind of gives it a second look, and some sort of a second level of review. In some cases, the supervisor of records will agree that this document was properly withheld, or it's not a public record at all, and so those responses will say so. The supervisor of records, though, if information, if the record is a public record and the information is public, the supervisor of records tries to get the department, obviously, to comply with its lawful obligation to produce that. If a record has been produced, at that point, that's when the supervisor of records typically responds with what the complainant is referring to as these non-determination letters, where they don't say anything. But obviously, if a record has been produced, it is public. The department has made it public, and the supervisor of records usually has played a role in getting the department to make it public. So it's a moot point, but I think it is a form of determination.
I understand. Thank you.
I would say that as a supervisor of records, you actually don't have a client when you're in that role. You're really acting on, as we do, to make sure and assure that the public has access to public records. It is after that the determination of whether it's public, when there is a question of what part of the record or whether it is to be withheld or if it's to be exempt, that you then have a client, because then the agency or the department or the elected official will call you and say, hey, I think I got a problem. But for the supervisor of records to kind of merge the two that are happening at the same time, I think is a mistake. I don't think that serves the public. The public is coming to you for a quick, brief determination, something very simple. We begin our hearings that all government documents are public documents, unless otherwise, as the ordinance says, as the CPRA says, that the respondent tells us otherwise and cites it, has to cite, letter and verse of the law. Okay? And we've had cases here where we've had respondents that say, well, we think it should be. Well, tell us what the citation of law is. They can't tell us. They don't know. So then we have to find them in violation because they didn't bring the proof that shows that. They think it should. I agree. There are lots of things logically that maybe should or should not be, but the laws, we're having this discussion nationally now. Okay, we're a country of laws. Okay, so I don't like using the word nation, but that's so I think that that's an important factor. I think it's because you're one in the same office, but you really have a delineation. One is a very front-facing counter, like you're at the front counter, kind of like at the recorder's office, right? You're just taking the applications. You're determining whether they filled it out right. Did they put all the right, correct information? What information, it's all public, that kind of thing. And then once it gets behind the desk and it starts to get processed, then other things may come up that in determining confidentiality or what have you. So that's kind of the way I think about it. We've had a lot of deliberations over the years about such things. I can pretty much speak confidently that that's the way we kind of stand on things. I think those are very interesting observations, and it is a very interesting question too.
The question being, why would the voters entrust this gatekeeping function to the city attorney, right? And because by charter and just by virtue of how our office interacts with our clients, I mean, we're lawyers and they are our clients. So obviously, you know, we try to act in the public interest, and our office, I mean, we believe in good government, and that is a huge part of what we do. And the ordinance, I mean, I forget where, but I mean, it says, you know, I mean, we have to act to protect and secure the rights of the people of San Francisco to access public information. That's important. But we do have to do so in a manner that's consistent with our charter duty. And it is hard to kind of, I'm not sure if you can just take off the lawyer hat. At some level, we are checking in with our clients rather than kind of adjudicating their responses.
Supervisor records is not a charter duty.
But the city attorney is.
I know that, but the supervisor records is not.
No,
so that's where I'm drawing the distinction.
Right? I understand the argument. So, I'm not sure it's one that I can concede to, but I understand what you're saying.
Consider it, okay? That's what we're saying. Okay. Anything else for discovery on this part? Are we ready for rebuttals? Okay. Mr. Pradham, you're first.
Thank you.
3 minutes for rebuttals.
I'll try to be very brief. I appreciate the task force's explanation of how it views the supervisor of record function as being limited to just a threshold determination of whether a document meets the statutory definition of a public record, and that it is not necessary to get into the specifics of whether all or a portion of the document can be withheld or redacted based on an exemption from disclosure. In this case, I would urge the task force not to find any violation. The reason being that I think it was conceded from the beginning that this was, in that sense, a public record. The document was requested and produced with redactions, and the basis for the redactions was never that these portions of the document are not conduct related to the public business in the custody of public agency. It was that particular exemptions applied. So there's never been any dispute in this case, either from the custodian or from the supervisor of records, that this was in fact a public record. If the question is simply, is it a public record, I think that's obvious. The last comment I'll make, in terms of, you know, findings of violations and orders, I think 6721D and E are quite clear that in those situations where the supervisor of records has been unable to timely act, and we do try to timely act, but when it happens, the remedy at the task force is not to kind of enforce against the supervisor of records or order the supervisor of records to do something, but rather to try to take the petition in its own hands and move the matter forward. Does the task force have a role in evaluating the supervisor of records' compliance with its duty? Absolutely. Under 6730, you can set goals, provide guidance, and I think you're doing that, and this is very helpful. But I would just close by submitting that it would not be, I think, appropriate or even necessary in this case to, quote-unquote, order the supervisor of records to do things differently. But your feedback is very welcome and appreciated.
Are you finished? Okay, thank you. Anonymous, you have 3 minutes.
Thank you. I'm going to begin where the respondent ended. I don't think you actually have the authority to order the supervisor of records to do anything, but you do have the authority to say whether or not they violated the Sunshine Ordinance. Those are two separate things that you have an authority to do. Under Admin Code 67.30C, you are allowed to find whether, quote, any person has violated the Sunshine Ordinance. That's subsection C. I don't know. I think they're talking about the part where you can give feedback to supervisor records. I'm talking about 67.30C. And it is clear here that they did not meet the timeliness obligation of responding to by providing a determination in response to a petition. I understand they don't want to use the words, that's not fair. The voters passed the law. You should enforce the law. Now, I'm going to give you an example on page 950 of the record, which is page 42 of the PDF. Exactly a reason why they need to provide written determinations. You will see that on section 1, it says determination, no determination needed. The petition was filed on February 27th, and the records were provided on March 19th, and therefore they said no determination. But that's exactly why they need to tell you within 10 days, yes, this record was public. There was no reason for them to wait and close the petition on April 8th by providing no determination. They should have provided a determination, the obvious one, which is that, yes, these records of peace officer standards are public records. Now, I'm going to go back to the second petition here, which is page 62 of the PDF, which is page 970 of your record. They should have stated in this thing, we determined that non-Prop G calendars that have nothing to do with metadata, those other calendars are public records. That's all I want them to put in writing. And putting that in writing matters because it allows us and others to figure out what is a public record or not. And that was really at dispute here. Why did it take months to get those non-Prop G calendar records? And they really should provide me a determination that non-Prop G calendar records are public instead of closing my petition. I understand what your chair is saying. There is another remedy, but you also have the jurisdiction to find whether any person is violating the Sunshine Ordinance. And without having to order them to do anything, I think you should find that there was a violation in the past in this case. Thank you very much.
Okay, members, I know, Mr. Prodham, you want to say something, but, the way our process works is we end with the respondent's rebuttal, and then we deliberate for the petitioner. We end with petitioner's rebuttal, and then we deliberate on what action we want to take. So if we have any further information we want to ask, we will. Okay? Sure. Appreciate it. Thank you. Okay, members, what's their pleasure? In the microphone, please.
Sorry, Chair. I think, if we read 6721 sequentially, I think respondents' argument is fairly convincing. That's where I am. I mean, E is there, and he says what to do. So,
Member Yankee, then Vice Chair Josh Wolf.
I guess the part that I think it is very clear that there is a response required within 10 days about whether or not the record is public. I'm not sure if it's clear if Anonymous was asking if a record was public or if they wanted to dispute certain redactions within a record, and that's beyond whether or not the record is public. The record is public is what our committees do. They say it's public, then it goes to be adjudicated, which is what Chair Wolf was speaking about earlier. So I'm not convinced that, and maybe this is the case, I just may have missed it, but that Anonymous was asking, is this calendar a public record? Because I'm looking on page, for example, 968, which is, I think, part of this response that the city attorney finally gave on September 5th, and it says the petition is regarding, and then it goes A, B, C, D, and it talks about scan PDFs instead of text PDF, and lack of specificity regarding redaction justification. That's not asking whether or not the record's public. That's asking for a legal opinion on a variety of potential redactions or withholding of information. I don't see 6221D saying that that's a response to that is due in 10 days. Like we talked about, a response seems to be due, is it public or not? Not, can you use scanned PDFs instead of text PDFs? Those are more complicated legal questions than is it public or not. So while I agree that I think they have to give a response whether or not the record is public, I'm not sure that's the question that was necessarily being asked of them in this circumstance.
Yeah, what I'm saying, even if they have to...
Hold on. Vice Chair Josh Wolf.
I guess I'm coming from a similar place as Member Yankee, that I see a timeliness violation. I guess we would call that 6021D for not responding in 10 days. I hear the argument about how E seems to create another alternative, but that to me reads as a response if you either didn't get the answer you wanted or didn't receive a response that was lawfully owed to you. I don't see any exceptions in the language for the 10 days. So I see a timeliness violation focused around 6721D, and I think that these larger issues that Member Yankee brings up and that relate to the actual substance of the request and perhaps relate to why that 10-day response didn't happen is part and parcel for what we're focusing on the IT committee. And so I think that this should be, we should find a violation and refer it to the IT committee. That's not a motion, it's a suggestion.
Member Martin.
Yeah, well, I mean, I don't, maybe I'm missing it now. So that there's been a determination that the record is public already.
Right, but it didn't happen within the 10-day period that it needed to, which is why there's the violation.
But they've admitted that it's public?
Well,
They had the record, didn't they? I mean, I correct me if I'm wrong, but I think Anonymous had the record, didn't like seeing the redactions or didn't like getting it in the format that he got it in, and then went to the supervisor of record and said, I don't think that they gave me this the right way. I don't want PDFs, I want metadata, or I don't want, images, I want text PDFs, this, that, or the other thing. But they clearly had the record because they had it. That's what they were disputing. So I'm not sure that the question to the city attorney or the supervisor of records in this instance was, is the record public? I think the question was what A, B, C, and D is. So I'm not sure.
Let me just interrupt you for a second. I don't know. I think you should ask Anonymous if that's what they were thinking.
That's a good point.
I wouldn't presuppose that you.
That's a good point. Anonymous, what was the question that you asked the supervisor of records that took them over 100 days to give you a response to?
That's a question.
Thank you. That's the wrong petition you're looking at. So let's make sure we're looking at the right petition. The one you referenced on page 968 is a different petition regarding a case 19091. That's not this one.
Okay.
You should be looking at the petitions on page 970, which is the second response they gave me. Sorry, these are the responses: 970 and 971. And you can see they describe that. So if you have any more specific questions, please let me know. I just want to make sure you have the right page number.
Yeah. Yeah. The question here is as far as I can see, the supervisor of records morphed into the city attorney. Mm-hmm. Okay, and went to just kind of launched into the. Oh no, we've got all this other information that throws up all these red flags.
Right.
Warning, 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 right? That's not what the requester was needing. That the requester is, very well knows what would be needing next. Not necessarily that the city attorney would know what the requester was trying the petitioner wanted. That didn't matter. There was just a simple question that needed to be asked. So I'm just going to allow the city attorney to respond, give them a chance to respond. Go ahead.
Thank you. I think I wanted to pick up on a comment that Member Yankee made, which was that, what was the question asked? And the question asked was not, is this a public record? And, I think the question was asked was whether certain exemption from this thing that was obviously a public record and no one was disputing to be a public record, whether that was properly withheld. And I think that information under the Sunshine Ordinance did not require a 10-day response. I think we've sort of moved the goalposts here a little bit, but the petition itself to the supervisor of records was not asking the basic question of, is this a public record? That was not in dispute and never has been.
Is the petition in this packet? I know this is the response to the petition. I'm trying to find the actual petition that was made.
Anonymous is the petition did you submit the petition?
I probably did, but I have to Google through here. 1 second. Let me. I wonder. May I respond while I'm searching through here and looking for the petition to what he said about what I asked?
Well, I think it's both one and the same. If we can see the petition first,
right?
Because we we understand what you might be telling us, but we really want to see what was originally asked
Sure.
first, if you don't mind.
Sure. I'm sorry, these aren't OCRs, so I'm actually looking through as we're talking. I apologize.
Is it on page 921? Oh, no, that's
What's
about
the PDF number? Do you have a PDF for that?
No. Let's see if I can get one. I'm looking at this in a browser, so.
Yeah, I couldn't find it.
Yeah,
By the way, the response makes a representation about what I petitioned. There are two different petitions. I'm okay going with that. I don't think they're lying about what I requested. But it says there are two different things I requested. As you said, it is not just whether a record is public. Actually, it says a record or any part of a record is public.
Right.
The first one was about certain parts of the record, and the second one was about the non-Prop G calendars. So there were two different things, and I think they describe it very correctly. I don't think they're wrong about how they characterize my petition on both page 970. Hold on. So they characterize my petition on, you contend that the mayor's office improperly withheld responsive calendar entries that are not required. That's one thing. So those are records that should have been determined on page 970, which is 62 of the PDF. And immediately below that, page 971, is where they say under the Sunshine Ordinance, they claim their jurisdiction, and then they discuss what I asked below that. So I think both of those pages accurately describe both, on one hand, the record I believe was withheld and is a public record, which is the non-property calendars, and a part of a record, which is on page 971, which was the metadata and some other non-metadata things as well, like attachments and those are records. I contended things about attachments and stuff like that.
Okay, so Member Yankee, for your edification, on page 790, it looks like it's a snippet of what the exact request is. It's indented. An electronic 970. An electronic copy in electronic format with all calendar item headers, addresses, so on and so on and so on, except those explicitly exempted by the ordinance. Okay?
Right.
So,
but then it follows by, it says, in response to this request, the mayor's office produced the mayor's calendars in PDF format from the time issued. So it sounds like.
So that's 971. Sorry, I apologize.
So 971 is what we're talking about? An electronic copy in electronic format with all calendar items and headers. Let me ask you, Anonymous, when you filed this petition, I mean, it says, because we don't see the original petition. So we only have this document to go by. Let's start with 971. This letter responds to your petition to Supervisor of Records concerning your request to the mayor. Okay, so that's the request. Okay. Okay, so here's where, I'm just trying to process here. Mr. Pradham, when you read 971, okay, if from what I gathered, Anonymous is asking whether these calendars are public or not, okay? And in the second paragraph, it says, in response to this request, you are now taking on the question of the request itself. And that wasn't the question that was put to you by the petitioner. The question put to you by the petitioner was, is this document, whole or in part, a public record?
I don't think that was what the petition was asking. The petition was claiming that the information was improperly redacted. And that's why it says, first you contend that concerning the format, right? And then it talked about the disclosure of the metadata on the next page, 972. And those were the main two contentions of that Supervisor of Record petitions. It wasn't a question about, is this document a public record or not? It was a question of whether the format was one that was required to be produced in that way, and was it appropriate to redact the metadata? So the petition was not a petition about whether the record was a public record. It was about the substance of the record and the exemptions.
Okay, I just want to kind of regroup here a little bit because we're getting, I think, a little outside the bounds, okay? So when we have to go back to what the original, for this process here, what the original complaint is. And the original complaint is based on timeliness, allegedly in violation of 6721D. Okay? The question that we're saying to you is, the points that we're trying to keep bringing up to you here is that you didn't have to spend all that extra time. You kind of launched into the actual, what was the request? You launched into attorney-client mode. You follow me? So
I do, but I would phrase that a little bit different, which is it's not. We received a letter. It was styled as a supervisor of records petition, but it was asking for information that the Sunshine Ordinance does not require a 10-day response for. It was asking for the substance of the exemptions and whether the exemptions are properly invoked.
Okay.
And so my point is that given that that's the case, there was no 10-day duty to respond. So you can't find a violation for that.
Member Yankee?
Mayor,
I'm just wondering if there might be a request for like a legal opinion from Anonymous trying to use 6721D. I think 6721D is very basic with the question that can be asked within the 10 days. Is the record public or not? If you're asking for a legal opinion on substantive issues within the Sunshine Ordinance, you can't do that under 6721D. Right? That's a thing in and of itself. Anonymous may have cited that, and without seeing the actual petition from Anonymous, I think it's very difficult to see whether or not it was appropriate under 6721D or not.
That's the question for the custodian.
But I think page 970 is a good example of what you are asking for. So in that one, the contention, so this was sent on August 27th. The petition was dated August 27th. The contention was that calendar entries were improperly withheld. And then so at the bottom of the third full paragraph, it says, separate and apart from 6729F, this office has stated that where an office official or employee maintains a personal work calendar, it would be considered a public record with exempt material subject to redaction. And this response was sent September 6th within 10 days of August 27th. So this is an example where the petition did actually seem to be asking that question, is it a public record? And thus we were able to respond within that 10-day period.
Go ahead, Anonymous.
They skipped over a part on page 971. The metadata was one part of a record that asked a determination. As they clearly state, I had also asked about attachments, appendices, and exhibits. They could have clearly responded to that within 10 days and told me whatever the response was. They didn't do that. And what he just cited to you as, oh, well, they did provide a determination within 10 days the second time. As you can see, scroll through this record, they call these things no determination needed, and the petition was closed. They are not responsible for telling me a generic legal rule about whether the Good Government Guide says something or not. There are specific records I requested. They were supposed to make a determination whether these non-property counters are public. And in their words, that would be called a grant of a petition. I don't know why they use these words. They use closed, denied, and they've never, ever granted a petition, as far as I know. My understanding is this page 970, instead of saying, well, they gave it to you, we're closing the petition, it should say, the non-property calendars you requested, you asked for a determination, are public. And then when they put that in writing, that's not a close of a petition, that's a grant of a petition. That is, I mean, if they want to talk about clear, they keep calling these things no determination needed, the petition is closed. Instead of to say the petition is granted, then we can use that written record to make sure we get those calendars.
Okay. The thing is that we have no jurisdiction over how the supervisor of records chooses to operate or proceed. That is why the ordinance provides an additional kind of an appeals process or furthering of it if you don't like what the supervisor of records provided you. That's what 6721E is for. And so I understand what you're saying, that under 6721, if you isolate 6721D by itself, and you're saying, well, they didn't comply within 10 days, or they didn't provide me with the answer of whether it was public or not within 10 days, and you want to apply 6730D to have us because somebody didn't do it right, I think a court would say, well, but you have this 6721E. And with the way you read 6721 is in sequence. It actually, that's the way it kind of escalates. Are you still there? Hello? I guess we lost him. All right. Well, anyway, so I'll just say that, I'll just keep saying that for our edification, 6721, it is I like to read it in sequence. It's an actual guideline of how do you request a record, what happens in the process of that request, and how do you get what the remedy is built into there in order to find out whether the record is public or not. Okay? The question, the adjudication part is when there is, hello?
Sorry, the call dropped. I've reconnected now. I apologize.
So I didn't get that far. I'll just repeat what I said. We like to believe that 6721 is in sequence a process. It's a guideline for how to request information and find out if it's public or not, and how to receive it, what happens when it isn't, when it's withheld, what are the remedies for that, and there are a further sequence of escalation of remedy as it goes forward. And it actually uses the word remedy in F. The administrative remedy provided under this article shall in no way limit the availability of other administrative remedies provided to any person. So, I'm not sure that I'm not of the mind that we can find a violation for the supervisor records. And we're just talking about just that one function. It's not the entire city. It doesn't affect any other it doesn't even speak of custodians. Supervisor record is not a custodian. Supervisor record functions the same way we do in a different kind of mode. So that's kind of my sense of it in that way. And the fact that if 6721E did not exist, then maybe we'd have a different conversation. Who else? Member Martin?
No,
anybody?
I agree. I mean, that's, I think, what we've been talking about from the very beginning of the hearing is the reading of 6721 D and E, or C, D, and E. And E tells you what happens. And that's that. I mean, you can't use D and then ignore E. You can't use C and ignore E. E says if you find something, you refer to the district attorney or the attorney general. And they have 5 days. It's fairly harsh.
I don't want to diminish Anonymous's intent for wanting to get a decision out of the supervisor records, AKA the city attorney, in writing, because it would enhance or it would provide for more access to information. But we are not here to adjudicate intent. We're here to determine whether there was a violation of this law. And I would say if they didn't comply, as it says, if a petition is denied or not acted upon, I don't know how else to interpret that. So that's kind of where I stand with it.
I agree. I think unless there's anyone else who wants to discuss, I'll make the motion to find no violation.
Okay. Is there a second?
I'll second.
Okay. It's moved by Member Yankee, second by Member Martin. Is there any public comment? No public comment. Any last debate on the motion? Okay, call roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf?
No.
Member Tesfaye absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes to find no violation.
Thank you for
Thank you.
everybody's indulgence. Please call the next item.
Next item number 10, reports from Sunshine Ordinance Task Force committees.
Claims Committee?
The last meeting we had was fairly quick, about 10 minutes. I think there are quite a few who withdrew and did not show up. So I think our next one is scheduled for December 17. That's a Tuesday, the week before most of the Christmas activities. So.
And following the complaint committee hearing will be a meeting of the IT committee, starting at about 7 o'clock, right?
And that's on, I'm sorry, what's the date again?
Is that December 17th?
17th, right, okay.
Yeah.
Complaints and amendments? Anything?
Right, that was last week. Oh, you know what? My brain is fried. I was mostly determining jurisdiction in several cases.
We essentially we served as the complaint committee, I believe, and did a bunch of first-time hearings, jurisdictional hearings.
Okay. EOT?
Hasn't met.
Hasn't met, okay. Rules Committee?
Hasn't met.
I haven't been at the last two meetings. I believe you had seen our reports over the last 2 months and took action on our items. So.
All right. And then IT, we're going to meet.
Yeah, we're going to meet. I'm still waiting to hear back from any expert to confirm. I'm getting a lot of either ignoring or no's. So
Did you see the document that I sent around from the League of California Cities?
Yes.
Okay.
Yeah, I saw that.
Which I thought was interesting that they actually took up the issue of metadata. I'm wondering if it might just be worthwhile. I don't know if that's good enough for having their opinion of it, or whether there might be something more they want to add. I don't know whether it's worthwhile contacting them.
I could try reaching out to them also.
Again,
yeah.
they're government representative body, organization, versus a public interest organization. Did you try to contact EFF?
No.
You might want to try contacting EFF because they deal with a lot of that FOIA requests. I think about FOIAs. Who deals with FOIAs all day long? It's that kind of.
Who's with EFF? Do you have a?
Dave Moss.
I know I did reach out to David Moss.
Yeah.
No, I did. And
you did?
Yeah.
Okay.
He couldn't make it, and he said.
But
none of
there's
them-
tons of people who work there. He's not the only one.
Okay. That's why I was asking if you had another contact person.
Oh,
That might
no,
be-
I would just try to go through the front door.
Okay.
Or ask him directly, can you give me a referral? Somebody
He was
else.
going to look around and see if he could find someone, but then
Nudge.
I'll nudge again.
Yeah.
I've already nudged.
Nudge. And, we have very difficult time getting the First Amendment Coalition because they're so busy.
Yeah, that's what they said.
With
There's
lawsuits.
small staff and very busy.
Yeah, a lot of lawsuits. But again, I think it'd be worthwhile asking for a referral. I mean, Calaware, maybe you want to ask.
I asked them too, and I'm waiting. They seem to be interested in doing remotely, and then didn't confirm after I gave them the time and asked for an email so I can give them call-in information. So I'm
Another
gonna
one
follow.
is Freedom of the Press Foundation. That's the one that, who's on their board? What's his name?
Well, if you think of any,
Ellsberg and Daniel Ellsberg is on their board.
well, if you think of anyone, feel free to email me.
Yeah.
Specific contact names. I'm
Yeah,
more
we
than happy
have.
to reach
Yeah,
out.
we can do that. Okay.
That's right.
Because I want to, really want to make sure we get that done in the next meeting. And I did try to contact Government Loop. This is a the kind of collective of IT professionals in Washington and federal government. I tried just asking them, because they talk about this stuff all the time, like who would be good to speak to. I didn't quite get the response that I wanted, but anyway, we'll keep looking. Okay. Any public comment on reports? Seeing no public. Next item.
Item number 11, Sunshine Ordinance Task Force Chair's Report.
I have nothing much to add right now.
I did send you the letterhead.
Sorry?
I did send you the letterhead
Yes, you
last
did.
month. Did that letter go out? 'Cause
Yeah.
I got a hard copy, a signed copy from you.
I thought I sent it to you, no? Okay, I'll check again. I
Yeah.
thought I did.
Okay.
Okay, and then I'll be working on the annual report. Any discussion? No public comment? No public to comment? Next item.
Item number 12, Staff Report, Complaints and Communications. So,
Any-
as you will all see, there is a calendar of committee meetings, some of which are canceled, including CAC on December 24th, and January 1st. Sunshine Ordinance Task Force is canceled due to the holiday, and it will reconvene on the 21st. January 28th is CAC, and then the February calendar.
Just to confirm, you have people slated for the 17th complaint committee. Who do you have listed for that?
Well, I'm kind of glad you asked that because it's Chair Martin and Bruce and Josh have been alternating between attending. Are you willing to pitch in on that?
I did it last time, so they're going to do it this time. Plus, they were going to have the IT meeting, which is, I don't know if that's still happening or not, but.
Yeah, it is happening.
Yeah, so I think it's them.
So you guys will be at the complaint committee hearing?
Can you make it?
I mean, I'm waiting for a follow-up appraiser appointment, and I don't get to choose what time they come, so.
Let me know if you can't make it. I could try to make it if you can't make it.
Sure, I won't know until next Monday.
That's fine.
Monday next week? Yeah, that'll give me enough time.
Okay.
Yeah.
In the bullpen.
Yeah, just email me too, so I know. Okay. We had a variety of petitions and complaints submitted, hearing files created. Petitions before the Sunshine Task Force. We have nothing in 2016 or 2018 pending to be heard. There are 4 matters in 2017, 3 of which are Mary Miles. She requested a second continuance, so it'll be sometime in February that she's heard. Matters.
Did the city attorney respond, our legal counsel respond to
I
the
sent them the
issues?
request, and I believe they said they did.
Okay.
So, yeah, in fact, I think it was sent in September, and I think I forwarded that to you.
Yeah, okay. I just want to double check.
Okay, so petitions waiting that are referred from SOTF to committee. Javad Mercedes, hopefully will be heard in February. I know that the respondent requested a later hearing date because he wanted to make sure the petitioner got everything he requested. File number 17086, pending legal research from DCAs, whether SOTF proceedings are legal proceedings. Pending issues, like I said, Mary Miles. Communications, we got one from Ann Trabeau, anonymous, on November 8th and November 21. And then requests from community persons, we had 109 emails between October 26th and November 15, so we'll definitely have more between those dates and come January, we'll have a lot more.
Okay, thank you very much.
Okay.
Very good work. Okay, next, any discussion, questions? Public comment? Seeing no public comment, let's call next item.
Item number 13, announcements, comments, questions, and future agenda items by members of the Sunshine Task Force.
Anything for the good of the cause?
Okay, so
Nope.
I just want to make sure I've got the committee attendance right. So for the next CAC in December will not meet, but in January it will. And Lila and Fiona are members. We could use an alternate. A third person would be great.
Can you send me the date again, please?
Jan. 28th, yeah.
All right.
Is that a problem?
I'll mark it down.
Okay.
It's a Tuesday, right?
Yes.
It shouldn't be a problem.
Okay. 4:30 on Tuesday, that Tuesday, yeah.
Oh, does that mean for the full task force meeting on the 21st that we start at 4:30 instead of 4 because it's a Tuesday? No, we start at 4.
It starts at 4, yeah,
Okay.
on the 21st of January, right? That's what you were talking about? Yeah. So complaint committee, that's member Martin and members Wolf and Wolf have been alternating. Anybody else want to step up?
I think member Yankee said he'd be in the bullpen.
You'll be,
I mean, as
Not
an
in-
alternate,
only
I'm
if
not,
he's-
don't-
yeah.
ask me each time. Don't put me down as a permanent.
As a
every month.
desperate
I know.
Yes.
Hail Mary.
Okay.
But yeah, as a Hail Mary, go ahead and reach out.
no, I mean, I have to put committee members, so that's why I'm asking who exactly is going to attend.
So
You can always ask me, do I work
I have
close?
a request that you promote to your networks that we have openings on this task force and that you're being overworked and we need help.
Don't tell them that.
I don't know if that's an
No,
attractive
it's-
appeal.
Well, it just will, it's kind of spread the wealth, you know.
Hey, I'm still waiting for my reappointment.
There you go, right.
Spread the word that if Trump successfully kills Obamacare, this is a way to get help.
Right, there you
Yeah,
go.
exactly.
Okay, anything else for announcements? Any public comment? Seeing no public comment, let's call next item.
Item number 14, adjournment. It
Sure.
is 9:52 p.m.
Is there a motion to adjourn?
Motion to adjourn.
Moved by Martin.
Second.
Second by Yankee. All those in favor say aye.
Aye.
Opposed? We are adjourned.
We flew to New York. That's how long we've
Done.
been sitting.
Yeah.
I got in my car at noon and drove here.
That's rough, dude. That's long.
Oh, no.
Wow.
Got back in the car just in time to hit rush hour traffic.
Okay, yeah.
That's rough, man. That's very rough.
This was the good part of the day. And now I get to go home to my house and try to find out what my rights are.
Uh-oh.
That's not fun. Yeah.
Thank you. See you all in January. Have a good Christmas, everyone. You too. Bye. So we're just going to have 4 complaints on our committee. Okay. We're going to bump Stephen Malloy. I haven't noticed anybody.
Okay.
So I'll just do these 4 and then we'll
Good.
leave and
Good.
IT will take over.
Yeah. No, I think that's good because we have that IT afterwards, so it'll make it cleaner.
Yeah.
We'll have time. Thanks, Cheryl. Have a good, well, I'll see you on the 7th.
Yeah, you'll see me. You were such a good girl. Such a good girl. Like a kiss? I get a kiss. I love petting your dog. She's so good. Well, it's kind of a long meeting.
A lot of pithy issues.